Hypocrisy.
Hey, what's up, guys? Welcome to Lost-Planning the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How's it going? How's it going, guys? Whew. Man, sorry, I didn't have the link up a little bit earlier. I was hoping to, but damn, I am exhausted. Had a pretty good weekend. I hope you guys did too. I mean, pretty good in the sense that I was resting for almost all of it. These trial streams, man, are really draining. I know it doesn't seem like it. Where's the Rumble stream? It's on the Rumble stream. You can check my posts on Locals or Twitter for the Rumble stream link. Both of them have it. I know it seems weird when you see like a streamer be like, oh man, I streamed it, 10 hours. And you're like, yeah, I worked 10 hours. And don't get me wrong. Streaming is not an intensive job in the same way that other, labor intensive jobs can be. But when you do this stream, plus like a bunch of other streams, and then you've got all the behind the scenes work that goes on, it could get to be a little bit much, but that's okay. Not complaining, just explaining the really welcome rest over the weekend, which was nice. Very nice. Looking forward to the trial stream today. We've got trial day number 9, and it's the 3rd calendar week of Alex Murdaugh. Hey, what's up, Kurt? How you doing, buddy? Aren't you streaming? It's the 3rd calendar week of Alex Murdaugh, which this case is expected to go 3 weeks initially, which means it should have been wrapping up by the end of this week or middle of next week. And whether that will remain true looks less and less likely unless the defense's case is like a day long. I don't even know at this point if the state will be wrapping up resting its case by the end of this week. Hey, what's up, Natalie Wisco? How you doing? So we'll have to see. I don't know. I'm going to warn you guys, and I'll bring this up later when more people are in the show. Friday is looking bleak for my ability to stream this trial. So we may have to find an alternative place on Friday. I've got some excuse me. I might have to pop out of town for the day. Actually, let me not say might. The most likely thing is I will be popping out of town for Friday. So I'm not sure if I'll be streaming the trial. And then the same may be true for next Friday as well. But we'll see how it goes. We'll see how it goes. Maybe this thing will just wrap up. Maybe this thing will just wrap up and everything will be great. All right. I've sent out most of the invites. I got to send out just a couple more. Let's see. Who else are we? Oh my gosh, my DMs are a disaster. Speaking of Friday, I hope some of y'all caught Friday's live stream, which was just a blast. The Friday night live stream. We had a really good time. I like to do these Friday. I don't know how familiar everybody is. You never know with trials, like who's a regular viewer, who's new to the show, all of that stuff. Ooh, I got to go get these trimmed up again in the back. My mullet's growing. But on Friday nights, I live stream most weeknights. Normally, I live stream almost every weeknight when I'm not doing trials. When I do trials. I do 3 live streams a week at night. I try to do more if possible, but like I said, it kind of gets cumulatively more difficult. But anyway, I'm talking way too much. What I try to do for that Friday nighttime show is to have just a very kind of relaxed comedy show with some friends. We do a panel show, and this one was a really good one. So check any of those shows out at 11 p.m. Central Time most nights. If you want to always know when I'm going to be streaming, you can check, you can follow me on Locals, ricadalaw.locals.com for free to make sure you get the notifications. You can also follow me on Twitter. I do post those stream links on Twitter as well, but I will say, the Twitter, I don't know if you've seen the trend of people putting their Twitter into protected mode or followers only mode. And then they're apparently getting like way more engagement with their own follower base by doing that because of how Twitter's stupid bubble algorithms work. Something to that effect. And my guess is that when someone goes into that followers only or protected mode, Twitter kicks up their priority with their own followers because they're expecting that there's something that they want to tell follow, like they want to inform them about what's going on. That's my thought. But either way, people are doing that, and they're finding out apparently that their normal Twitter activity is highly truncated when they're not in that mode. All of that to say, you can't really rely on Twitter notifications for everything, but that is a place that you can find it. So if you're one of those people who habitually check certain people on Twitter, you'll find the notifications there, or you can go to ricadalaw.locals.com. You'll get a notification. And if you want, you can get an email too for all of that. So there you go. Hey, Nikki, why no Rumble stream? There is a Rumble stream. Here, at John Morgan. Rumble stream is right there. I'll send it to you. Whew. All right, let's go. Brandon says Monday is a fun day to be late and gay. Oh, damn. I believe Andrew Bronco will be joining us in just a minute. I've sent out other invites and don't know who else will be available. Oh, looks like he's almost ready. His camera is getting there. Here we go. Hey, what's up, man?
Hey, man. Sorry about the camera. Yeah.
Oh, no, that's okay. Welcome.
Thank
How
God
you
it's
doing?
Friday.
Thank God it's Friday. Wait, it's not Friday? Put me on the train track in front of that bullet train in Japan, please. I don't want anything left.
Here we go. Still getting organized.
All right. It isn't showing up on my channel page on Rumble. You might be on the wrong channel page. It was a little
slow. It's up there now.
Oh, okay.
I noticed it was a little slow when I was looking for the link too.
Yeah, that's mostly my fault. I came down. I got everything ready just in time to start the stream at 8:20. I had man, these weekends for me are becoming recharge weekends where it's just sleep. Whew. Boosh McFadden asks, does Bronca even own a t-shirt? Do you even own one?
Yes.
How was your
Maybe
weekend?
you'll see it in Vegas.
Ooh. I'm excited. I am actually unreasonably excited for Vegas.
I'm actually, I mentioned on one of our streams last week that if, I'm just showing up to talk and tell jokes and stuff, but if someone brings one of my books, I'm happy to sign it. And now our customer service is getting requests for the location so people can come to the book signing. It's not a book signing, folks. It's Nick's show. Just if you happen to bring a book, I'm happy to sign it, but I'm not setting up a table or anything.
I should have the location locked down. I know I've been saying this, but in the next couple of days, I'm trying to the initial price, not quoted, but estimated for the venue, has basically been double to triple what they initially said. And so I'm checking out a few other places before I before I lock it down. Hoping for one call back from a guy today, and hoping my planner gets some firmed up numbers. We'll see what happens. I mean, I'm fine with paying the extra, but if I could get down to the initial estimate that I based the ticket price off of, that would be nicer. But we have sold 99 tickets so far. So very cool. Very cool. It's going to be a fun time. I'm also just looking forward to going to Vegas. It's I like leaving my house sometimes. And I really like leaving this state, especially now, because Minnesota is turning into literally not diet California, just California on the political end. And I'll probably be talking about that tonight or tomorrow on my show, because man, they got the House, Senate, the Democrats got the House, Senate, and governorship this year, and they are going full in. They put the gloves on and said, "Welcome to my laboratory." Like, it is not good. It is not good. The Rider 24, do you have an estimated timeline for my lawsuit? Okay. The other party is amending their complaint. They had 7 days to amend their complaint from when they filed that, which was when was that? Is that Tuesday? They should be dropping their amended complaint in the next day or two. And then I will have 14 days to respond to that. So we'll see. We'll see. But anyway.
Speaking of your state becoming California, it seems like every 8th license plate here in Colorado is a California plate. I mean, it's an outright invasion.
Yeah. And you guys don't really need the help, because it's not the reddest state. Well, at least in the cities, of course, Denver and
ironically enough, it was purple until I arrived. The year I arrived, it went hard California.
Yeah. It's funny because so Californians don't seem to realize that all those things that they keep voting in are what made California unbearable to live in for them in the first place. Like,
the shopping bag thing. So now we have to carry our own bags into the supermarket.
Oh God. Okay. I don't agree with it, but I can at least kind of see it for a coastal state. You know, they use the shopping bags and like the straw thing. It's like, oh, well, we don't want this going into the ocean. It's like, I guess. But it's insane anyway. But yeah, having it in an inland state makes even less sense to me. I also hate it. Bring your own shopping bag. No. And then of course they charge you for bags too. Right. It's like, oh yeah, thanks. This is fine. These bags cost you 1 cent per 1,000.
Right.
Like, oh, well, that'll be $1. $1. Of course, $1 is worth about a penny these days, if you're buying eggs. Did you see we shot down that balloon?
Yeah, a little late.
I know. It's like, didn't they wait till it was like over the ocean?
What a circus world. And now, of course, we discover that, Trump was letting balloons float over America, too. We just never mentioned it until today. Sounds credible.
Someone asked if I was ready for the rain today. No. Is it going to rain? Actually, that might be nice because, see, there's this cool effect in Minnesota when it gets warm enough to rain. The snow kind of gets slushy. The rain, if it rains enough and if it gets warm enough for just long enough, it'll wash the streets completely clean. That's what you need it to do. But then you need that water to evaporate before it freezes again. Otherwise, it gets really,
otherwise it's fun,
really terrible. But
well, this is the worst time of the year for me because I can kind of see spring coming, but it's not here yet. I got another 2 months before I can really get back on the bike and start doing trips.
I'm in the same boat with my Mustang. like, which it'll be my inaugural drive. I can't wait for that. That's going to be a blast. I've never in my life been able to have a fast vehicle. I always had to have a kid vehicle.
Right.
So,
yeah.
Or when I was, before I had kids, I was just like poor. I had the same car. My first car was a 1995 Ford Escort. The pinnacle of cool. It was a 4-door too. You wouldn't want just 2 doors on that thing. No, man. I drove it.
New car was a Hyundai Excel.
Ooh.
4-speed, crank windows, no air conditioning.
Do you know when the Aiden Fucci trial starts this week? Who the hell is Aiden Fucci? I don't even know who that is. Murder trial for Aiden Fucci set to begin this week. Accused teen killer. He's 16, is accused of stabbing classmate Tristan Bailey 114 times. Oh my God.
Sounds reasonable.
The stabbings are really ugly when you actually watch them, because someone literally, I mean, it's just like,
let all the blood out.
They just go to town, and yeah, it's gross. I don't like it.
And I guess there's a Courtney Clenny status update hearing today.
Ooh, that'll be good. I'd like to cover that trial. That trial might be a circus.
Yeah, I think I'll cover it. In fact, they had like 3 or 4 days of hearings back in October that were televised, and it was almost like a mini trial all by itself. Lots of evidence presented. Mm-hmm. So I may cover that again in retrospect as kind of a preview to the trial itself.
Yeah, when they actually get to it. We'll see. That one has the hallmarks of any of the social media trials. Like, social media people tend to be eccentric and ridiculous. And her job is to attract people and charge them money for her attractiveness, even though she's not that attractive. I mean, when she's done up, she looks good, but so I'm curious how she's gonna present in court with the jury there, because I think if she's smart, in my opinion, she'll walk a very balanced line somewhere between I'm on OnlyFans and I look like Hillary Clinton, one of those two. Like, she'll have to find the middle ground.
She won't come to court in a bikini.
No, but she should do herself up so she looks like, pretty, but not, I mean, she can't go full on with it either, because I don't think you want to be I don't think you want to look like a whore in court. I
can tell you in that hearing they had in October, she was just there in prison orange, no makeup, and she looked pretty tough.
Yeah, but there's no jury there for that. No, so
right.
So it doesn't have the same concern. Let's see. Rascal 1301 says, just got back from shit. Hold on, let me get the cord up here. Nope, not that one. There we go. Turn on the judge's mic. Oh wait, that wasn't the judge time. That was a bailiff.
Good morning. You ready to proceed? May proceed.
I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
All right. So he says, Rascal says, just got back from weekend in Beaufort, South Carolina, visiting family. Talked with my family's neighbors who are friends with the Murdaughs, and even they think he has something to do with the murders.
Raise your right hand, left hand on the bottom. Do you affirm the testimony about to record in this trial shall be the truth? So help you God.
They got their game way up on the mics.
State your name again for the records. Spell your last name.
Morning, y'all. My name is Mark Tinsley.
Mark Tinsley.
Looks like his wife picked out his tie and jacket this morning.
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would were you testifying before the jury. You understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to.
How much money did Alex steal from you,
Very
sir?
quickly, if you would, just quickly tell us what you do for a living and what kind of practice
You
that
already
have.
told us. He was a
My
lawyer.
name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right. And
I'm an ambulance
how long have
chaser.
you been practicing in Allendale?
Since 2000, so 22, 23 years.
Do you have a statewide practice or is it primarily?
To the extent I want it statewide, I mean, I handle cases statewide if I'm inclined to handle those.
If I feel like it.
Primarily focused in the 14th Circuit, is that fair?
14th and the 1st,
And the first?
Yeah, we're back to
You know the
proper
defendant,
area
Alec
here.
Murdaugh.
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the, what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with or just generally in the same line of work with over the years?
Yes.
Want to take you to February 19, and are you familiar with the boat case?
Unfortunately,
And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alec Murdaugh. Is that
I did.
correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, at when this case started.
Mr. Waters, my recollection is that I sued Alec Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where the boat was launched from, and we believe that there could have been some drinking that went on there. I'm not 100% certain in the
Tina
first
Lewis
lawsuit
says
if I sued
Tinsley
Buster
looks
Murdaugh,
kind of like Mel
which
Gibson.
is Alex's
He looks like
son.
Mel Gibson if he had a
Um,
DNA swap
But
with William
I think
H.
those were
Macy.
the defendants initially.
Okay.
And
And,
maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this: did your client Renee Beach have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
And can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday. So the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alec's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No, nobody really gives me instructions.
I understand. All right. Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
My recollection is within a week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alec's personal lawyer, brought me all of Alec's insurance policies. And so I reviewed them at that time before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
You know, in a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is. Many times insurance companies can be leveraged to pay their insurance out, to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right. And when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat.
How have you never
and
seen
2
the
other
policy?
boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was the Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy, and so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusion. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge. Is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular.
It's a really interesting segment about how plaintiffs' attorneys think, by the way.
It changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to
those
Alec's
factors
attorneys
that had nothing to do
you
with
were
the legality
seeking
of the case?
a personal recovery that he would have to pay as opposed to just accessing what insurance coverage was available?
Always,
And that was consistent all the way through. Is that correct?
all the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that would somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Allied rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference, but yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alex sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case."
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me, and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was no 20. September of 20.
20. Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
COVID, the court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you during the course of COVID take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that
Seems
you
like
believe
this is
would
the
be
guy who
very,
should have killed.
advantageous to proving your case and achieving the large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick.
Some people
Hey,
are
don't
taking
give your
note of
kids
the.
booze and boats, folks.
Yes, that's very true. Some people are taking notice of him saying, "We are friends. I'll burn your house down." Though, I mean, when you're friends in a professional capacity with a lawyer or a personal capacity, but they're opposing counsel, I mean, their job is to burn your house down.
And see if you recognize that document.
I did. I do.
Right. And what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right. Could you turn the screen to me real quick, please?
Let's go. Brandon says, legal question. What is the potential range of compensatory damages for accidentally losing a hot?
There's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so.
I'll get it in a minute.
And then you respond about not walking, just taking $500K and not walking away from someone who's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alec said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel. And about a week after I'd filed that motion to compel, Danny Henderson, who again was Alec's personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, you know, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
Right. And why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever. And so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alec thought there was a fix on, that he was just a placeholder, a venue defendant.
Right.
And so if I told
what
you
that means.
I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know, and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alec, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take? You know, the analogy I use with my clients is it's kind of like that show Deal or No Deal. You may have the $1 million suitcase, or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case, and so at $1 million, it just wasn't.
Kind of pokes holes in the
risk
theory that
to them
Alex was completely running out of money actually, though. I mean, he said he was out of money, but
Did
this
you,
guy's like, he's got half the cases in the
make any
county.
sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alec was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that. Show me the books to prove that. What was your response from Alec's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick.
For those of you just joining, this is the lawyer for the dead girl's family from the boating accident who is suing Alec, presumably Paul, and their
Show you
insurance
what's been marked
company.
as stage 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alec's responses to the interrogatories and requests for production.
All right. And when was this filed?
October 16th, 2020.
All right.
Imagine having half the product liability personal injury cases in a county. Jesus.
So much money.
And they're all being settled. You're not doing any legal work.
Nope. You're just negotiating for basically maximum payouts from insurance companies.
All right. I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number one, please.
Well, in as broad terms as
Well, let's just read it real quick, if we could, please.
all
Can you
right.
read that?
List all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
All right. And ultimately, what was the Alec's defense's response to that, generally? You don't have to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
And so ultimately, you filed a motion to compel. Is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others. Is that correct?
Correct.
All right. To your knowledge, when information was being gathered by the defendant in this particular case, let me ask you this, who were his attorneys in the boat case, Alec's attorneys?
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPD. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon. Ultimately, I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case. Is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available, correct?
That's right.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We all already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well,
Financial information.
The way to, again, like I in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, that's what I'm trying to do is put pressure on him to force him into a settlement. You don't want it disclosed. Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alec's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once you see
Subpoenas.
of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank.
Always
So
watch
I'm
out for the
looking
subpoenas,
balance
by
of
the way.
accounts in terms of institutions.
Very dangerous.
And where else
Sneaks
he
up
had.
on you.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
I wonder if they're going to ask this guy about that private investigator. He, I believe, is the guy who disclosed
After
the
the motion to compel is filed, I'm going to show
existence
you
of the private
Western
investigator
Market
and
States
the
403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right, put this up on the screen. All right, if you would, got this up on the screen. So can you tell me what's going on? And again, this is in April of 2021. Is that correct?
It is.
and tell me what's going on with this conversation right here and how it relates to these issues.
Yeah. So in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to, I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time, I've said that I'm going to leave the case in Hampton. But if I think that Alec has fixed a jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
And was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me. But
I'm asking you today.
But yes.
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
Wait, did you think their handling was shit too? Is it a common theme? South Carolina's investigative powers are garbage.
And how quick SLED came into this Maggie and Paul shooting within hours.
Yeah, I mean, they were there, what, that night?
That night.
And they still screwed it up.
Yeah, but that was just incompetence, not bias.
That Aiden Fucci guy who stabbed the girl, he pled guilty just a little bit ago.
Marked to states 404, 405, and 406 to your for this hearing, and see if you recognize those, please. Generally.
I do.
All right. And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021. 21?
It's either the 10th or my recollection is the 10th. I know the emails say something different, but, and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done. And he had asked the judge to continue the motions, including the motion to compel.
And looking at, again, we're now looking at States 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at States 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right.
Don't you know? Wasn't this your case? Oh my gosh. I just can't wait to hear this testimony again in front of a jury. It'll be great. If they let this in, this case is going to be 8 weeks long. I don't know if it's actually going to be.
Initially, Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After
but
the status conference, it was rescheduled at that status conference?
it was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as Stage 407 and Stage 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right. So the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alcohol, identification of all accounts. Is that correct?
It is correct that motion was going to be heard.
And ultimately, when the murders happened, I'm going to show you what's been marked as Exhibit 408. What happened to that particular hearing that was scheduled that way?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
I mean, he was probably
After
underinsured
the
because he
murders
took his
happened-
insurance company for the housekeeper.
Let me ask you this. You know Alec and have worked with him for a number of cases. Is that correct?
Yeah, I hadn't even thought of
I
that.
had not worked with Alec in a number of cases, but I've known him for a long time.
Okay. But you were generally familiar with him as a lawyer. Is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. you have a case with Alec. He hasn't done anything. It's Monday morning of the roster. Maybe you expect it to be continued. And he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things. But
Among
yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery?
Yes.
Explain that to the court then.
Well, initially, probably say the first week, there was the shock and horror of what had happened. And nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case. So I would have ended the case against Alec.
You would have ended the case against Alec with just.
There it is.
I probably, certainly there was $500,000 in insurance that was offered.
There's where they're
I
trying
may
to
have
get motive.
Tried to see if he could cobble together the $1 million, but whatever the
Who would have
last
to
offer would have
foresee
been
this?
from Alec's
Yeah.
side, that would have been the offer that we
What
took.
this guy would have done is supposed to be indicative of what Alec thinks this guy would have done or knows. Did you communicate that to Alec Murdaugh? I've been waiting for the hook on this
You
guy.
mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case.
Maybe I could get Alec to teach
The
tort
defense and
at
some
American law
relevant
courses.
partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
At some point, did you receive any call or any communication from the Satterfields about any recovery in the Gloria Satterfield death?
At some point, my recollection is it's early September of 21. Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement. And he came to my office at that time.
All right. And did you send them to someone?
I sent him to Eric Bland.
Hold on for me 1 second.
All right. Earlier, I was reading this. Let's go. Brandon says, legal question. What is the potential range of compensatory damages for accidentally losing a hot 18-year-old in a lake present day, given the existence of OnlyFans and the hub? Oh, no.
Nothing further this time, Your Honor.
By the defense.
Good morning, Mr. Simpson.
How are you?
Oh, this I like this
Testified
lawyer.
at length, to the state grand jury, basically this similar testimony you're giving here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was underinsured for this incident, and you're going to go after his personal assets. And that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insistent
You
that he
didn't think it was
pay.
financial pressure to go for more than $1 million?
I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from him.
Sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
What's it about then?
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money. No money had been offered.
So your expectation then was we're going to trial.
Except for the
If you offer
$500,000
me no
insurance
money in a
policy.
case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No,
You believe you were close to taking it to trial?
there was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like you were only 2 or 3 months away from trial,
Sure.
even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
That wasn't the
On
question.
that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex Edge.
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment.
Right.
There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That
Well-
wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
Yeah, but
he
dude,
had
you're talking about
objected to the
scheduling
financial
in
scope he
court.
asked for.
Well, there
No
was an
way that thing goes
objection
to trial in
posed,
2
correct.
months.
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimony is that's just one of many motions that needed to be heard. Is that correct?
Correct.
There are many motions that had piled up and needed to be heard.
There were several.
There are several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had one or two motions. Some of the motions got resolved. One of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practice in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video from mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking to amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter.
Didn't you leak the video?
And ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
Why'd you file it?
I wanted it, but I didn't need it.
But again, this isn't about you. It's about the court's calendar. The court's going to say we have these 5 outstanding motions. No, we're not going to calendar this thing in 2 months. You're going to go to jury trial in 2 months.
What's been marked as Defendant's Exhibit 82. You recognize that?
I mean, stuff is getting delayed by months just because of the other attorney's cancer.
It appears to be my motion to compel against Greg Parker's company.
Pull up 82, please.
This is an interesting thing because right now he's trying, they have to convince a judge.
On the screen that
The judge knows about the court calendar. He has one.
So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12, interrogatory number 13, interrogatory number 15, interrogatory number 18. It seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alec, but the trial wasn't dependent on these things.
And turning to the motion to compel Alex, first, do you believe that the Judge Hall's initial request in May to go forward with pending motion hearings was telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. No, there's nobody in the courtroom, maybe even including me, who wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance,
Or didn't make it.
you don't believe that was any kind of stalling tactic, do you?
No.
Imagine asking for a
That was
continuance and then
legitimate
dying. Boy, you look dumb.
health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up.
Oh yeah, DUI guy said he was going down to this trial, so he might be in the gallery somewhere today. Have to keep an eye out when they show the gallery. Oh, he's going Tuesday? Okay.
I believe the state has already marked this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental requests for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because, 9 and 10 asked Alec about.
Sir, no one's asked you about it. And we'll get to it, but first let's turn to answers to first supplemental.
Ask me about the thing that's favorable. Please do that.
B, so we can see what it is that is being asked for.
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B.
B. It's the first page of what's Exhibit B in here. It's right there. That's it. It's the first page after the motion, so do page 9 of the PDF.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking, savings accounts, retirement accounts. And then you don't have to highlight or expand this stuff. All stock, and then number 2, all stock certificates, and we go to the next page. All property interest of property of every kind whatsoever, from February 24, 2019 forward. All life insurance policies, 4 or 5, all personal financial statements submitted to any bank, et cetera. Profit sharing plans, pension plans, et cetera. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you.
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
He granted this motion?
I think so. You want to see the order?
Yeah.
What? He had it in
What?
his pocket?
So the record, October 7th, 2021.
He just had that in his pocket?
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary, the
Yes.
court will schedule a hearing if
right.
necessary.
Which
If
means,
Mr. Tiller, the attorney on the case, can, from his own client, get the information. This is no way says that the court granted this motion, does it, sir?
Only to you, I think. I mean, it's clear
Wait,
that
what?
John said that Alec was
That's not
unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
That's not an order.
This is an order that says the court will schedule a hearing on this motion to compel if necessary. It's not granting the motion to compel, sir, is it?
Oh, I think so. I think if he was just going to deny it as you suggest, then it would have just said denied. Or
No, that's-
If it was
it's
granted, would
premature.
we say granted?
Yes.
Yeah, I think that's what it says. It's a practical matter when parties have discovery motions, oftentimes, like Alec is in his own statement said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge.
It sounds like a violation of the
So this
candor
is-
to the
this-
court.
My point
Ethics
is that if the
obligation.
judge were going to say it's
Holy
premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did. That's not what happened.
He was ready for that question and answer with the order in his pocket. That's amazing.
The pseudo order.
Yeah. The order definitely does not say what this guy is saying, by the way. If
21.
would have granted, he granted
You asked
it.
for financial information.
Would have scheduled a
in the
hearing.
motion
No, it would just
that
be
was pending
granted.
Against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up his net profit.
And this was like the dram shop action against Parker's, correct? They sold the alcohol.
Like a dram shop action,
Okay.
yes.
And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th day, just along with all these other motions that had piled up in a case that apparently wasn't moving very
Well,
quickly.
I understand you don't want to acknowledge what I've handed you, but.
Sir, I asked you what the ruling was on the motion
Well, it-
compelled from Parker's.
It was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, the difference between Parker's and Alec is that Alec had, and his lawyers had 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the
You
argument.
presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front
So
of the
you're saying
judge.
the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean,
It literally says it's a hearing, dude.
you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alec.
Because the law is how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Alec's lawyers knew what the evidence was. They knew what the amendment was going to be and the allegations. And he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that appears you're suggesting now.
And again, the gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up and we saw the one that asked for financial information was deemed premature.
Not at all. You know, what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. Before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records. And I've seen the records. I've seen all the bank statements now. It would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Alec had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Alec's getting these checks. There's no way these checks are going to Forge. There's no way that this money should be transferred.
And even if, hypothetically, had this hearing on the 10th and you got a different ruling regarding Alex Murdaugh than you got against Parker's, but for some reason it's not premature to him, isn't it true all you would have been enabled, all you could have gotten would have been a net worth statement, financial statement?
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get, you know, for that's the measure for punitive damages, net worth. There's no such case in your opinion as an attorney.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion, and then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, you know, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not
And
what
that
you
worth
get on a motion
statement
to
would do
compel,
that.
is it? Right. You just said ability to pay so your client can make a decision on whether to accept a settlement offer, but that is not what the motion to compel is about, is it? It's about evidence for trial.
The motion
That's
to
the legal
compel-
standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not he ultimately had money, because I knew he had
Admitting
money.
to filing a
I didn't
frivolous
need
motion?
those things. The fact that he didn't want me to have them is the reason that I'm pushing it.
So,
I just didn't know why he didn't want me to have them at the time. I do now.
so the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see. So, no.
You wanted pretrial ability to pay discovery to inform whether or not to accept compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him.
So you're admitting
Would
to
have sued
filing a
me
frivolous
fine not to
motion
have ever gotten
before the
anything
court?
and to leverage it into a settlement and gone on about my way. That's not what happened.
So the motion was not about obtaining information that may have been relevant at trial. It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was, they say he's broke. My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed opinion about what they should do. It didn't have anything to do with the trial. It had to do with the case and resolving the case.
And then I think we briefly touched on Satterfield. just to be clear, they came to you, the first time they came into your office, or was September 21?
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Thank you, Courts and Buildings.
Okay, so a lot has happened here, guys, that could probably take days to unpack, but let me try and give you the skinny. This guy filed a motion that he is now alleging was to solely put financial pressure on Alec put pressure on Alec to engage in settlement negotiations. And he's saying before the court that he had no legal usage for it at all, purely strategic motion to compel. He's also saying that motion to compel was granted because a hearing was potentially ordered on it.
Forward on June 10th. This was a Thursday.
He clearly hates Alex.
What outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome would you have expected?
Well, now I know that Alec was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he didn't.
Let me just make it a little simpler. Would the court have issued an order? Right? Some order would have issued on the motion.
I would expect an order to issue.
Break it down. An order would have issued at some point later, and if it were granting your motion, what would that order say?
I think it would say the same thing as.
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alec, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
Voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what you would have gotten you've gotten his, the law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alec's.
Right. Would you have gotten a financial statement?
No.
The court would have ordered every account detailed listed to you, all his personal accounts, just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I told you that.
Right, to subpoena.
Sure.
And
but that's different.
And that would have
been
resisted, and there would have been further litigation. This process would have taken some time, would it, if it was resisted, right?
I'm not sure what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating as same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about
but
that,
what you said would
and
happen
we can speculate any number
hearing.
of things could have happened.
That's the
That at
point.
some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not it was relevant, whether or not I was entitled to it.
The only reason this guy's testifying is to talk about imaginary things that didn't happen.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Ellick. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that.
And this guy's amazing. If you want to hear a lawyer like argue through something that clearly has not happened as if it has, by him saying it would happen eventually, maybe, therefore it did happen. And then go through conditional statements of things that would be needed to make it happen. I mean, this is fantastic. But this guy's, I mean, he's bordering on perjuring himself.
It's crazy.
It's
like, well, she agreed to a first date, so clearly we were inevitably going to get married.
Look, people go on first dates every day. This is how motion to compel go every day. You didn't get an order, though. You never actually got to the order.
And maybe we can agree on this. The hearing had gone forward June 10th. That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you, whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time after that. Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Ellick would have known that.
I mean, in that analogy, aren't you really saying that the fuse was lit and you were going after his assets, and that fuse is going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money. Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
Right, but it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day. No further questions.
Yes, sir.
Of course, we got to
That's really,
rewrite.
the point, isn't it, though, that had that hearing
point
taken
is-
place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection.
There's only one.
Objection, Your Honor. Leading.
Don't leave the witness.
If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery
happen.
of everything he's done.
Whether it happens that day or some point in time.
Correct.
You had filed this motion to compel, or had you filed this motion to compel because you had been advised supposedly that Allen was broke and you didn't believe it?
Exclusively for that reason.
And you believed that if he was broke, he had to be hiding assets.
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten
From Alec.
from him.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that.
The dead guy
of
agreed to the thing totally.
alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol. So only on the documents that were filed.
So were those issues though in play in your conversations with the defense?
I'm sorry?
Were those issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed, these are the issues.
I'm gonna hand this back to you, but I'll show you what's been marked as States 407 so you can recognize that.
Yes, this is the order that I handed, whatever that lawyer's name was.
Mr. Barber?
Yes.
Well-
October of 2021, is that correct?
It
Someone
is.
said at least this guy has normal hands.
You had previously testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Eddystone,
It was an option.
as well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Thank you, Your Honor. Nothing further.
Anything further?
Nothing, Your Honor.
Thank you.
Thank you, Your Honor.
Step down.
I don't think the redirect did them any favors, honestly.
No.
Next witness.
I mean, the problem for them is he had to make all those arguments in front of a judge rather than a jury, and the judge should presumably know that's absolute bullshit.
Couple things. Our next witness would be Ronnie Crosby. Just to let the court know, the court indicated Friday that we had kind of already established as far as clear and convincing evidence on the law firm issues. Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish
the meeting.
circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forge and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the court. I did want to cross the bridge, though, of this meeting on June the 10th as to the circumstances of it. And thus that if there was no attorney-client privilege to that because of the presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself, and prep in the evening or whatever, privy to that particular conversation.
The other comment about the attorney-client privilege issue, Mr. Griffin.
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call
Right.
some of the folks as witnesses who were there when you were there, along with Mr. Murdaugh.
To ask them what?
So it is the question, these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room.
Ooh, good
And I
argument.
don't know if they overheard anything that I've talked to Mr. Murdaugh about, and that's where this is going. Or if the question is Mr. Murdaugh talking to Mr. Crosby, and is that privilege? Or Mr. Murdaugh talking to Mr. Lee Koch, and is that privilege? I don't, I'm at a loss here.
I don't know either, but I say as far as the law is concerned that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure, and I guess what I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean,
Oh,
Mr.
fuck off.
Griffin says he's at a loss.
No,
and
you
I've been
aren't.
Bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There is no attorney-client privilege involving people that Mr. Griffin does not represent. If you have them as witnesses, and you want to call them as witnesses, if there are necessary witnesses to this hearing, you may proceed.
Unless
Thank
those
you,
people
Your Honor.
represent
Ronnie
Alec in
Crawford,
other
you
matters,
stand?
or represented Alec in other matters. This is a weird one because the judge is in kind of a tough spot. I mean, the guy, no one can state with certainty what he's going to ask is privileged. They'll have to object on the fly, but they should just object to every question that involves anything Alec may have said.
Well, naturally, I would prefer the privilege were scoped as broadly as possible. I don't like nibbling around the edges of privilege.
Right. I mean, that is
Okay.
interesting. This guy's not going to be able to
That
say
is
which
fine.
conversations were definitively privileged or not, because they may have had an expectation of privacy and someone could still overhear it.
Right.
But if they were off in a corner or in a separate room or whatever, keeping their voices low, trying to have a discussion, and someone walks by going to the bathroom or something and hears a statement, that doesn't defeat privilege.
You affirm the testimony about the court in this trial shall be the truth, so help you God.
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Ronnie Crosby,
That's a
Crosby,
long time.
Crosby.
Mr. Crosby, how are you?
Where's
okay.
Stills and Nash, sir?
Tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alec Murdaugh?
I am.
You see him in the courtroom here?
I do.
And where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
And again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury. But I do want to explore a particular meeting. Were you present for a meeting with, in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday that we gathered at Alec's brother John Marvin's place, which is not very far from Alameda that y'all been talking about. And I know I'd been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him. And so we gathered there. I was present. Mark Ball was present. Lee Cope was present. John Marvin was present. At some point, I believe, I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there, and there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day. And we were there for support, and he went over the events of that afternoon or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together. And I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were for me to hear them. I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdaugh. They did have some private conversations that the rest of us were not privy to, but so there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Correct. And this was before, I believe, the South Carolina Law Enforcement Division agents arrived at this location.
To be clear for the court, you did at other times, aside from this meeting or this discussion, have conversations with Alec about his activities the night of June 7th, 2021. They were outside of this. Is that correct?
Well, that's correct. I mean, obviously, we all were in shock, but also wanted to try to find out what all had went on, because we, as we got past that night of June 7th and the morning of June 8th, we're all, trying to help find out what had happened and who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, we had multiple conversations, as you might expect, all of us in a group, and there may be pieces and parts. But what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Okay. Your Honor, I don't believe I have anything further for purposes of this matter.
Anything further?
Yeah, please, court. Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster could be interviewed by SLED. Is that correct?
That's correct. The purpose was to, that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed. And Jim, now that you speak of it, I do think that, well, Mr. Randolph did not come into the meeting, he and whoever brought him over did come by.
Right.
The two that I'd forgotten.
Yeah, and
And then went back to Alameda.
where he died within hours of that. Right?
He died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to, and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also was present.
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not, about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alex some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. What do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this, I never had the perception that I was representing him.
Well, did you or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege? Did you give him that warning?
Mr. Griffin, we're all lawyers. I don't, other than John and Buster that were there, I don't think anybody needed to say that. And it never crossed my mind that when we were sitting in a room and all of us were talking, that we were somehow representing Alec.
No, I understand that. Okay.
And nor would I ever do that, because I don't practice in the area that you do.
Right. But it's clear that Danny had an ongoing attorney-client relationship with Alec, is that right?
He did. With regard to the boating accident, he was Alec's personal counsel in that.
And Danny had sat in the initial interview that was conducted by SLED Agent Owen and Collin County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know.
I don't know. I saw, I know when Alec got in the car, we felt like one of us ought to sit in there with him, for support, because.
Well, can you say for certain that whenever you heard conversations from Alec about his recollection of what happened on the 7th, that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. Can you say for certain there were no non-lawyers in the room?
There were.
That you're referring to hearing conversations with Alec in the group about what happened on the events of the evening of June the 7th.
Is this a prosecution?
And my
or is this
question to
defense?
you is
Hence.
when Alec was making these
prosecution
statements,
went quick on this guy.
let me make it clear, were they just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and where whether John had walked out when I heard any specific thing? I can't tell you that. I couldn't catalog because I said it's a little bit fluid. People come and go, and law enforcement arriving outside and people walking out to greet them. It wasn't like the SLED agents just showed up and it was some rigid thing where you walked out. There was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please.
I can't believe I missed the entire prosecution. They've never been that fast.
They just established that there was a group of people in a room all chatting together. So we're not talking about, whispered conversations between lawyer and client.
Sure.
And the defense is basically saying, yeah, but weren't they all lawyers? Everyone there was a lawyer. Couldn't Alex have perceived them as, being part of his representation?
This particular
You
issue.
certainly could.
No, I know that's a little bit different than the larger issue we've been dealing with, and I'll certainly be happy to argue that further if the court would like. As far as the larger issues, one of the things that we.
But this guy would be happy to
especially with
testify.
The defense that we've stayed away from so far in testimony is the side of the road. And that might be the other piece of the puzzle a little bit that might need some in-camera testimony as I think all this through. I know that we're butting up with the jury being here shortly, but
That can be done at a later time.
yes, sir.
Oh my God.
Not-
This
any-
proffer is gonna
anything
take
further on
forever.
This issue regarding evidence of other crimes.
Aside from the side of the road, not at this time, no, Your Honor.
Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but, that would be it. As again, for in-camera proceedings before Your Honor, to get a handle on all of the sort of the 404 stuff that we're talking about.
All right.
No, that would be it. That's from that side of the road.
We'll take a break of about 5 minutes and I will announce my decision regarding this other evidence.
Wait, they're not going to get to argue it?
Well, they kind of did. I mean, very informally.
Yeah. You just think that at the conclusion, they'd be able to.
Argued again. Yeah, more
Offer
concretely
argument.
based on the testimony we just heard, right?
Right. Wow. I think it's coming in. What do you think?
Yeah, I mean, I wouldn't let it in unless
I don't
you
think
could
it
show.
should.
Yeah, I wouldn't let it in, but I think this judge probably will. And I expect the testimony is going to be Alex said he never went down to the kennel
Yeah.
because that's where else would that come from? Because I haven't actually heard that yet. Although the states claimed that Alex had made that statement in their opening. I was going to go back and listen to the car interview to see if he said it then. I didn't recall him saying it then, but maybe this is how they're trying to bring it in.
There's the car interview. There's the initial night in questioning.
The body
And then-
camera, yeah.
And then there's, of course, the 911 call. He might have mentioned. I don't think he would have mentioned it there. I can't see how that would come into the discussion during the 911 call. So,
But yesterday I went through the opening statements again in a show yesterday afternoon that I did, and it's pretty clear now if you listen to the opening statement again after this week of testimony that obviously the state was planning to bring all this financial stuff in from the beginning, because in the opening they're talking about once you see all the things leading up to June 7th, all the circumstances around June 7th, you'll understand, this was a storm coming. And all those things could only be the financial, because there's no evidence of animus or a divorce or anything else that could be such a contributing factor. So there's a notion where the state pretends like, oh, they kicked the door open, now we can get this financial information, and they were clearly planning to bring it in from the beginning.
right. Yeah, I mean, all of this. I don't know, man. That lawyer testifying was amazing. Like when you really, I don't know, breaking that down and going, that might need a separate video to go through and rewatch that or something, because that guy is sitting there and some of his testimony to me looked like borderline ethics violations. I mean, he's admitting to filing motions to the court for the sole purpose of putting pressure rather than having a nexus related to the case. Or, I mean, that is a frivolous motion. I don't care what the results were. I didn't need it to go to trial. I mean, he's making these statements under oath. To me, that's pretty crazy. Not that he would do it. It's crazy that he would say it. It's
Also, his testimony about, hey, but if I decided not to change venue, but if I discovered that Alex was rigging the jury, it's like, oh my God, like that was going on.
yeah. Very, very crazy. Jeff Hayes says, sadly, in South Carolina courts, it's common. No, it's common in every court for lawyers to file motions for the purpose of putting pressure on that they don't actually have outcome. But you're supposed to have a plausible explanation for why you would file these things. And this guy does until he admits that he doesn't. Like, he doesn't need to get up on the stand and say, yeah, I don't care about the outcome of this motion. He could have come up and said, yeah, I thought this would help us at trial. There, that thing, I thought that was relevant evidence for trial. Suddenly, it's perfectly fine. But he comes up and says, no, I could have gone to trial in 2 months without the answer to that motion at all.
He said the quiet part out loud.
Yeah. And that's when, whether or not you have a plausible thing or not. Now, it may not be illegal necessarily, but it could be ethics, because one of the ethical obligations of attorneys is candor before the court. So not to just, he essentially misrepresented to the court he was filing the motion in what his purpose was. And that's a problem. Let's see.
But he sure hates Alex Murdaugh.
Yeah,
and
he
this
hates
guy they
him.
just had on the stand, of course, was a former law partner. He had to make good on all those judgments that were supposed to go to clients that never got their money.
Right.
Those people lost a ton of money that was stolen by, not only was it stolen initially, like the fees, but then the compensation to the clients they had to make good on.
Right. The law firm had to pay out that compensation to the client, which Alec presumably has never paid back.
Well, he's broke.
Right. Although I do have a problem with the theory of this testimony from the prosecution's perspective. Their theory is that Alex's financial house of cards is coming down or whatever. But that guy's entire testimony was predicated on the idea that it wasn't
Right.
coming down at the time of the murders.
He was happy to offer a payment plan because Alex was settling half the cases in the county. I mean, this guy was making money hand over fist. A Mississippi River of money was coming into his practice.
Hundreds of thousands of dollars a week. It sounds like, if he's settling half the cases in the county, tons of money is coming in. Okay, Lancelot 652 says, so all you have to say is that Alex is a son of a bitch. Thanks, we already knew this. Do you have any info on this case?
Right.
Atlas Knife and Tool, welcome to Paralegal Status. Bad vibes. Nick, the prosecution is dumb AF. If they let this in, they'll be creating the theory that the family of a dead gal may have killed the wife and son in retribution. To be fair to the prosecution, the defense is already going to be working on creating that theory. If they're not, they're stupid. But, and I don't think this defense team is stupid. They seem very sophisticated in their presentation of the theory of the case. I have a feeling a big part of their entire trial strategy is to create those alternative theories as much as possible. We've already seen them front the 2-shooter theory. So I don't think we need to worry about that too much. But
and this notion that this little note written by the judge on a cocktail napkin is an order granting his motion is ridiculous.
That was amazing. First of all, the theater of it was fantastic. He has the order sitting in his pocket, and it's like the biggest gotcha. And if it was an order and they genuinely missed it, it would have been a truly magnificent moment.
Right.
But it's tampered immediately by the guy reading it. And I'm sitting there going, how do they not know this? How did they miss the order on the motion?
Well, somebody in locals just posted up a part of the docket, and he's like asking, where is this order if it was granted? Why is it not in the docket? And of course, it's not in the docket because it doesn't exist.
Right. It's a response from the judge that if you don't get this, we will have a hearing in which an order shall issue one way or another.
Right.
Right. And critically, I mean, this guy's saying, well, we would have gotten it. It's like, well, actually, you haven't heard their argument yet. So you might not have gotten it. There could be several legal reasons why they would not be able to compel this request. We don't know. And you don't know until you have that order in hand. So, but yeah, that moment was so great until the guy like, wait, and he starts reading the highlighted section. Like, if they don't compel this voluntarily, then we'll set a hearing. They didn't even have a hearing set for the order. That was magic. Sherry Law, I don't believe Paul was driving the boat based on witness statements and depositions. He can't defend himself now and still no justice for the girl. Same defense lawyers. I wonder if this will be brought up in the defense case. Maybe. Don't know. Getting into the Paul and boat thing before the jury may be kind of muddy. It might be a mess for the defense. My opinion, I mean, I don't know what they know, but my opinion, they should focus on the creating alternative theories that match the facts, because the job of the prosecution is to find beyond a reasonable doubt that this is a course of events that happens and leads to guilt. So poking holes in that, the 2-shooter theory, a single shooter theory would be good to have for them to have too, which actually matches the prosecution's sort of theory of the case, except their theory is that the single shooter is Alex. But it's just as easy for that single shooter to be anybody else. Someone emailed me or messaged me over the weekend, and they said that something that hasn't been brought up at trial, and I don't know if it will, but the waterway there has allegedly been a consistent drug running issue. And that they have found stashes. They sent a news story about how there had been a stash of 20 kilos of cocaine on one of the islands in the waterway there that possibly, making this whole murder thing a possible water escape rather than a car escape, for example. Although that doesn't necessarily explain how the phone gets tossed, so who knows? Speaking of tossing phones, welcome to stream, Kurt. How you doing, buddy?
I'm doing well. This morning was the riveting content I was waiting for. I was really looking forward to discussing the minutia of whether the judge was going to grant the motion to compel with respect to the financial records and some sort of quasi dram shop action, or whether or not Murdaugh would have objected and relayed to more time, blah, 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 something, something, something. Also, there might have been a murder that we're talking about. I'm not sure.
To be fair, I'm detecting a bit of sarcasm in your assessment. However, it's still the most riveting testimony in the case.
I'm not saying you're wrong. I'm not saying you're wrong. It's been 2 weeks of pain.
Yeah. By the way, thanks for bringing people to the channel. Very, very appreciative. I saw your raid.
No problem.
Channel
Yeah,
raid.
when I remember to do it, I always like to try to do that. It's always nice to help stuff. So why not send my 300 measly people over your way?
I appreciate it, man. Let's see. We're just going through some of the super chats that came in earlier. Bad Vibe says 1 million from Alex and whatever from all the defendants wasn't enough. Yet vigilante justice wasn't an option. Sawyer just said, burn your house down. Double talk will be their undoing. Sherry Law says, I made some ugly comments in chat about Charlie on Friday, but by the end, she had grown on me. Apologies to her. I think the hard part with Charlie was people may not know she speaks 5 different languages, and English is one of the ones she uses the least. So she was trying to articulate her points, but having to translate from Dutch to English. And I think that was kind of making things a little bit more challenging. But I thought she was fun. I'll bring her back for some show. I don't know if I'll bring her back for this trial or not. We'll have to see how it goes. But I like getting different perspectives, even from, and someone was like, why did you bring a non-American lawyer on? Well, it's like, I bring Runkle on too. It doesn't matter about the legal system except when we're talking about the specific legal merits, but lawyers look at things in particular ways, and I like getting those perspectives on the panel. So the T-Man says, I am suing Ricada Law. In order to fund my lawsuit, head to thedragonstreasure.com and use coupon code NOSE to get 10% off your anime-themed order. 5% of that goes back to Nick, which in hindsight isn't what I should give the man I'm suing. Haven't decided what I'm suing him over yet. So there you go, guys. Check out thedragonstreasure.com. Get some great tea. I had last night I had a big mug of ultra mint stinged tea. It's really delicious. Dude makes some good stuff. So Kurt, you've been watching this trial.
Yes, I have.
I'm so sorry for you
I know.
because it's brutal.
It's mostly an exercise in me losing my mind. The fingerprint expert is really where I lost my mind completely. That was the moment where I totally cracked. It's like, let's bring on the expert to testify about the evidence we didn't find, which makes him all the more guilty, I guess.
Yeah, it was crazy. But yeah, that one was rough. But that's the problem in this case. And it's something that Andrew's talked about a million times. The state will use whatever they can to prosecute you, even if what they have is not having anything.
Yeah.
Like that also makes you guilty. Once you are the man or woman, what is a woman? Once you are that person, the state will relentlessly pursue you. That's how it goes.
Apparently, they'll relentlessly pursue the Excel spreadsheet that tells me every time the phone changed in any way.
Yeah.
Because I need to know every time the phone orientation changed for 5 seconds.
The state's not in it to lose.
This issue is before me on the motion of the state to admit evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of res gestae. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing. The court has reviewed all of the exhibits submitted and I've considered
It's coming in.
the testimony of each and every
I think so.
witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is
Trial
offered
just
to
got
show
weeks
motive,
longer.
identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And
Or
before
motive.
admitting this evidence, the court
Or
must
motive,
first
which is the big
determine
one that
if
you
it's
just missed.
relevant.
Good job.
Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced.
Which we had
This
zero
requires the court to
testimony or
analyze
argument in
whether
favor
a
of.
logical nexus exists.
The nexus is pretty thin.
Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence. And the court is to conduct and required to conduct an analysis.
So good news,
under
everyone. We get to hear all that
403,
testimony again because the
which
jury
weighs
gets
the
to hear it, which means
probative
we
value
get to
versus
hear it.
the prejudicial effect. According to the state, The nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies.
Well, that's an open
all
question,
in a
isn't it, Your Honor?
relatively short period
Yeah,
of time.
we actually don't know that at all.
The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh.
Okay.
The state argues that the logical nexus between the murders and other crimes
I mean, it's terrible. This is going to take an extra 2 weeks now, but
is
on the
that
other hand, I think the
looming
defense can spin this in its
exposure of
favor.
financial crimes
Sure, that's possible.
provided motive for the murders and is evidence of malice.
They must
an
have argued
essential
that
element
in
of
a
the
written
crime
motion.
of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdaugh concerning the improper disbursement of fees in the case of the estate versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife, Maggie, to hide them from discovery in the boat case.
Yeah,
She
killing her wouldn't make
testified
them
that the firm
findable.
conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendants, funds that the law firm had to replace. The defendant and his son, Paul, had been sued following the fatal boat crash, and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days.
Spiders are weaving webs over everybody in the courtroom.
Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances. Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as a main depository for a substantial, if not most of the misappropriated funds. We heard testimony from attorney Chris Wilson about confronting the defendant about the missing $792 and the personal sum to him owed of $192,000 was later discovered That testimony or that confrontation took place on June 7th. Mr. Murdaugh later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield, Michael Satterfield's mother, who was the housekeeper of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case. And when he discussed it with Mr. Murdaugh told him that no money had been recovered and it would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,304,000. Also received testimony from Mr. Carson Burney,
judge is liquid
State
Ambien.
Attorney General's office, who traced funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh,
What apparent
because
desperation?
of his
really.
dire financial situation,
That wasn't testified to.
the threat of being exposed for committing
We just got testimony from all these other people who knew about the
which he
financial
was
crimes.
later charged with resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it.
The malice is
In
the
this
execution
case,
shots to
since
the head.
identity of the
Yeah, that was easy.
perpetrator is a critical element that must be proven beyond a reasonable doubt. Evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground.
Really?
Or
Really? You sure about that
than the
one?
specific charge. Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial, but is
The jury
more
has no idea. They just
probative
got another 2-3 weeks
than
added to their
prejudicial.
sentence.
Yeah, because
As
not
to
only are
raise
we going to get the
justice,
testimony
state
that we
alleges
got,
that
we'll get
Mr. Murdaugh was under
additional
immense
testimony
pressure
from all
after
those
being
witnesses.
confronted about
An
the missing
additional cross.
fees,
Additional cross, yeah.
the upcoming hearing on the motion to compel his financial information, his dire financial straits, and looming exposure of this criminal activity.
Now it's actually in the defense interest to make it look as horrible as possible. These people lost as much money as possible.
That situation led
Suggest alternative
to the
people? Yeah.
murder of Maggie and Paul Murdaugh.
That's
Now, of
certainly a
course,
direction
held
to
that
go.
where evidence of other
And,
crimes
make sure the jury knows,
is
hey,
an
this guy, he's going to be
integral
tried
part
for
of
all
the
these
crime.
financial crimes. That's not this
of
trial.
which the defendant is charged, or
You can tell him all
it is
day.
needed to
Gonna hear this
aid
guy's a
the
thief.
jury in
We
understanding
must have killed him
the
because he's a
context
thief.
with which the crime occurred.
I mean, even if you
Then
think
that
about it,
evidence is admissible under the
He's a
theory
thief.
of res
he must have killed
gestae
them to
or
cover
res
up his thief
gestae.
crimes. Whether that makes sense or not
That's
will be in the
somewhat
jury's
lost.
head.
I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res gestae, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case.
Yeah, this order might well have been drafted by the state.
Is entitled.
Yeah, they have a
Sounds like
proposed order.
Right.
Since
That would not
the
be, that wouldn't be
state is
like
relying heavily
improper,
on
by the way,
circumstantial
No.
the
evidence.
chat. You often submit a proposed order for the judge
I find that
and
it
he
is
can
so
adopt it or not
intimately connected with
and modify it to his
explanatory
leisure.
of the crime charged under the theory that the state is seeking to prove. That proof of it is essential to complete the story. Our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae.
You should just merge the trials, continue it and merge the trials.
Further in State v. McGee, the court
If it's all
held that
interrelated, then
where,
it should be tried together.
res gestae, evidence of res gestae or
Such a
part
misapplication of res gestae.
properly admitted,
Yeah.
then no 404B or
Under this
Lyle
standard,
analysis
everything comes in.
reached. However,
It's
is
also
technically-
assuming the very premise you're trying to
the
prove,
evidence which I have done,
saying it's related in order to prove it's related.
I nevertheless conducted a Rule 404B analysis or Lyle analysis, though not needed. In conclusion, the state's motion to admit the other evidence or evidence of other crimes is admitted,
Maybe they should have written up this order in graphic novel form.
granting the state's motion later today.
Well, I think that order is too expansive to be legally supportable.
Your Honor, one point on Your Honor's ruling, I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time they offer the evidence. And so-
Yeah, thank you very much. And certainly upon request of the defense, the court is required to give a limiting instruction.
Request it every question. So to head off the appeals questions, this is certainly an appealable order. However, judges have broad discretion on evidence, and the standard to overturn it is abuse of discretion.
And that's why he read all that into the record.
Tomorrow when we start
Right.
to cross into some of those financial witnesses.
Have you reviewed the defendant's proposed
However,
limiting instruction?
It could be part of what
Right now, Your Honor.
Stephen Gosney has talked about, a sort of cumulative order. All of these little abuses of discretion, all of these little things leading towards prejudicing the defendant and being at that point a mistrial in which he'd have to go back and it'd be redone. But on its own, I don't think this is sufficient for that abuse of discretion standard. That's just kind of how it goes. And it's, why the judges can make a big difference in some of these cases.
I appreciate all that, and I think the caution is warranted, but of the cases we've at least covered, I think that this one is the most ripe for appeal on an abuse of discretion analysis. I think the judge's order is way overbroad by allowing way too much stuff in that is, if you want to let in stuff like relating to this particular check that was discovered that day, the particular conversations, but to just have what seems like a completely open-ended inquiry, I don't think is supportable. So if we are looking for appealable grounds, this is the best one I've seen yet, for whatever value that has.
No, I think that's a good opinion. I don't disagree. It's just, man, I just have so little faith in the abuse of discretion standard. It's such a hard hurdle to overcome. But this one, I mean, my problem is there wasn't an argument on the logical nexus, and we didn't get any testimony as to that logical nexus. That's what I would expect. I would expect a witness to have something. I mean, we've heard about Maggie going in for, consulting a divorce attorney or something like that, or potentially threatening to expose his crimes. Any of that testimony would have been helpful.
If we had any of that testimony, that would be great.
After the testimony or before the testimony?
Before the testimony is offered, Your Honor.
What?
Uh-oh.
They're having technical difficulties over at Court TV, apparently, or Law and Crime. One of those two. Court TV are the cameras in the courtroom. Law and Crime is the.
I can definitely assure you that I'm not going to watch this testimony a second time. As enthralling as it was the first time, I think I'm good.
Typo in it. But I would.
Well, I'm in until I leave for Vegas.
Generally, though, I have no problem with this charge, and I have no problem with it being given before such financial evidence is received.
You've indicated those witnesses will testify later today or tomorrow?
Probably not late today, but almost certainly tomorrow.
Legal Vices says, damn it, somebody please Murdaugh me now.
Submit your own proposed limit.
I've already confessed to the murders on my stream just to make it end. That's how bored I've been.
Absolutely, we'll work on that.
Yeah. Of course, the other question of res geste and whether or not a limiting instruction is required for res geste.
I also particularly love the part where he said, this is definitely not going to prejudice the jury. This is going to be fine. I find this is totally not going to make them convict them for this reason instead of the murders. I'm like, sure.
Prior events he wasn't confronted about on June 7th. Now, if the court's ruling is limited to the confrontation on June 7th and about that transaction, then it would be res geste.
It's not limited.
Yeah, that's the problem.
June 7th also includes res geste.
No, it really doesn't.
All evidence of financial crimes that may likely have led to a motive, lend itself to motive for the crime committed. And that may be before.
How did any of them likely do that?
You're bootstrapping.
And the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record.
Yes, sir. I understand.
Showing no disrespect to the court.
No, I understand. Okay, we're ready for the jury?
State's ready to proceed, Your Honor.
Bring them on.
Yeah. If he had limited it to this particular check, if he had limited things that occurred on that day, he'd be in a much better legal posture. But if he's going to have a completely open inquiry into, let's talk about all the financial stuff, no matter when it happened. It's all res geste.
Whole second trial.
I'm like, it's like, come on.
It's a whole second trial within a trial.
So the interesting thing is, now all of the statements made by witnesses in this case are on record for the in-camera review, which doesn't matter for the jury, except for the fact that they cannot testify differently to any of the stuff they're confronted with on cross during the in-camera hearings. So like that order, that lawyer is going to have to sit and defend that order again if they bring it up on cross in the same way. So all the times where someone on cross in these in-camera hearings looked like an asshole, they'll have to still look like an asshole in front of the jury if they're questioned in the same way. They'll have to maintain their answers.
Right at noon.
Otherwise, it would be perjury.
Well, 11:58. It's still morning.
Technically.
Mark on day number 11. Call your next witness.
This lawyer talks, or this judge talks like the turtle from that Tootsie Pop commercial. I never made it without biting. Ask Mr. Owl. You guys remember that one? Lancelot 652 says, so he murks his family to dodge the money he had been stealing when his family has no money attached to them and would still owe because it was his crime, not related to his wife or son.
Yeah.
I mean, that's the theory.
But if the murders would have wiped out his legal liability because something Attila the Hun.
Yeah.
Spell your last name.
So even if he's parking assets in Maggie's name, killing her and assuming those assets that makes it worse. Like, that doesn't get him away from the crime. It doesn't make sense. None of this makes any sense.
What is your first name?
Michelle,
Spell that, please.
Mushell.
Where'd you get that name from?
My auntie named me.
And where did she get that name from?
I don't know.
What are we doing now?
Is it Michelle with a U?
You, yes, correct.
During the course of this, if you don't mind, is it okay if I call you Miss Smith or Miss Shelley or Shelley? I really don't know what's going to come out of my mouth sometimes. Is that okay?
That's okay.
But do you go by Shelley?
Yes.
Please tell these folks, Miss Smith, about Michelle Smith, where you were born, where you were raised, please.
Hampton, South Carolina.
And ma'am, if you don't mind just pulling this up a little bit and speaking into it.
Okay.
Love that accent, though. South Carolina.
Go ahead.
I was born in Hampton County. Have 4 grown kids. I was born in Hampton County, 4 grown kids, 8 grands, and I worked for the Hampton County District for the last 28 years. Food service is my professional.
Pull that chair up. I just want you to be comfortable. You said you had 4 adult kids.
Yes,
And then you said 6 to 8 grand.
it's 8 grands.
8 grand. Okay. And raised where?
Hampton, South Carolina,
Okay. Where'd you go to high school?
Wade Hampton High School.
And what did you do after high school, Ms. Smith?
Got married, raised my kids, and that's it, my profession, that's it. Mhm.
And that is the hardest profession, raising children.
Yes,
You had 4 kids.
4 kids,
And when you were raising them, you were raising them, taking care of
yes.
the family.
Mhm.
And are any of your family here today?
Yes, my brother and my daughter,
What's your brother's name?
Michael Smith.
Michael Smith, will you stand up?
Oh, Lord.
Is that your brother?
Yes, that's my brother.
Action,
And
who
who else
cares?
My daughter, Rochelle.
Miss Rochelle, will you stand up?
Why?
Thank you. They in here supporting you today?
Yes,
I only care if those kids look like Alex. Like,
Don't take this the wrong way, but other than raising a family, which is the hardest job, were you doing anything else during that time period?
no, till 1995, I started working at the school district.
Okay. Did you work in your church while you were raising your family?
Yes, I worked at church.
Okay, and that's what I'm asking. What did you do with your church while you
Objection
were raising
leading.
your family?
Usher, kitchen ministry.
Kitchen ministry?
Mhm. Yes,
And how long did you do
Is there any
that?
particular reason we're trying to make her seem like the
Church.
greatest person in the history
Are
of
you still
time?
doing that?
yes.
bolstering her character evidence
Name-
straight out the gate.
It's a little early for that, isn't it?
Fairfax, South Carolina.
Tell us about the work you did with the homeless and orphans, please.
Moved up in years or got older, did you start another profession?
Yes,
Okay. And tell the ladies and gentlemen what that was, please, ma'am.
private home care.
I'm sorry?
Private home care, caregiver.
Oh, this is the caretaker
How
for
did you
the
get into that?
dementia
Thank God.
mom.
And was she in that business?
Yes, she's an LPN. Yes,
An LPN?
Yes.
Licensed practical nurse?
yes.
And when did you get in the home care business?
About 10 or 12 years ago.
Now, prior to that, had you already started with the school?
Yes, I'm still at the school also.
Okay. Tell them when you started with the school.
The school in 1995, that's correct, 1995.
And what school did you start with?
At North District Middle School, in Warrenville, South Carolina.
North Central Middle, Varnville.
North District Middle School,
North-
yes.
What did you do for them?
Food service.
And how long did you do that at that school?
I've been there for 19 years at North District Middle School.
After that, did you change
Yes.
locations?
Yes, 6 years later, I went to Wade Hampton High School,
And for those of us that don't know, where is that?
Warrenville, South Carolina.
And you've been there 6 years?
Oh, no, 6 years at Wade Hampton High School.
So total years in the school system is what?
28 years,
And you're still there.
still there.
So you started home health care while you were still teaching school, or
No.
still going to school?
Going to school, working service.
And will you please tell them, you said your aunt got your business. Were you working with one family at a time, or did you have,
Different families at a time, different families.
and how long would you stay with the family once you became their caregiver?
It all depends on how long if they're deceased, I will move on to another family.
So is it fair to say you'd stay with the family until the person passed on?
Passed on, yes, correct.
And then how'd you get other jobs as far in that caregiving profession?
My aunt always called me and said there's a job, and she let me put me on that job.
So give the jury an idea before we get to this case, your schedule would be what when you were still working at school?
Yes,
and
that is true.
caregiving?
Yes.
Okay, so what was your typical day like?
My typical day was I leave home at 7:20, have to be to school at 8 o'clock that morning. And I will stay there till 1:45, make my deposit for the school, then leave and go to my next job.
Can you tell this jury, Ms. Smith, how it came about that you started working for the Murdaugh?
It was a job opening. I think one of the caregivers mentioned it to me, and I said, yes, I'd be interested in going. And that's how it started.
And one of the caregivers mentioned your name. Do you know who that was?
Yes, yes, sir.
Okay.
It's Barbara Mixon.
It's Barbara Mixon?
Yes, sir.
So there's an opening and your name got brought up.
Yes.
And can you tell these folks when that was? When did you start working for the Murdaugh family?
It was October of 2019.
And what was your role as a caregiver specifically for the Murdaugh?
Miss Libby, taking care of Miss Libby, Miss Libby.
Was Mr. Randolph, I knew him as Solicitor Randolph Murdaugh, but was Mr. Randolph, was he there living when you started there?
Yes, he has, yes.
And then that's what we've referred to as Almeida?
Yes, Almeidas, yes.
What was your primary job as the caregiver? Were you there to take care of Solicitor or Mr. Randolph, or was your primary job for Miss Libby?
Miss Libby.
Did you also ever tend to Mr. Randolph's?
Yeah, every now and then. Mhm.
But your main focus was Miss Libby?
Miss Libby, yes.
From October 19th up to June 21st, Ms. Smith, and I want to be very delicate in this question. I think it's something that affects everybody in the world, this jury there, but did Miss Libby's condition get worse?
Yes,
And she's suffering from something that affects all our families, is Alzheimer's?
yes,
And that got worse from the time you started until June?
yes. Mhm.
Oh, boy.
Well, in June of
I
2021.
hope she testifies that he came up to the house covered in
How would
blood
you
and changed
describe Miss
clothes or
Libby's
something.
condition?
That'd be good.
Alzheimer's, couldn't remember anything at times.
In your opinion, as her caregiver, was she aware of what was going on around her?
No, no.
I specifically, in June of 2021, Ms. Smith, or May, June of 21, tell these folks what your school schedule was and then your work schedule with the Murdaughs.
Okay. My school schedule was 7:20, I will leave home, be to school at 8 o'clock, and I leave there at 1:45. Go home, make my deposit at the bank, go home, rest, come back to work at 7:45. Had to be there at 8 p.m. that night. I would stay all night and leave 7:45 the next morning, leave there and go
I mean,
back
they
to the
paid her
school.
like $7 an hour or something terrible.
So was that the shift you were working for the Murdaughs
Yes,
primarily?
yes,
An 8 PM to 8 AM?
yes. Mhm.
When did you sleep after you went to school?
Took little cat naps every now and then.
But would you go home after you made your deposit?
Yes,
You would rest?
yeah, that's for a couple of hours. Mhm.
And then did you have a change of clothes at the Murdaughs for when you went straight to school the next morning?
Yes. Mhm.
Well, ma'am, I'd like to take you to June 7th of 2021. If you'll go back there, if we can take them back in your mind and take this jury back there right now, please, ma'am. Were you working as a caregiver for Miss Libby Murdaugh?
Yes,
Now, had Mr. Randolph, again, I know Ms. Solicitor, but had Mr. Randolph's condition worsened? Had he gotten, was he in the hospital? Was he there when you got there on June 7th?
no, he was not.
Do you know where he was?
He was in the hospital.
What time did you get to the Murdaugh, Miss Libby's residence and Mr. Randolph's residence on June 7th of 2021?
7:45.
And that's the time you were there?
Yes,
And you're never late, are you?
no,
And is somebody waiting to leave for you to get there?
yes.
Okay, and this night, who was there?
Was this Miss Barbara Mixon, I'm thinking? Can't remember. I think it was Barbara.
I'm having trouble
I'm sorry.
understanding your words. Can you speak maybe louder?
Okay.
I know you can't change your voice, but
Yes, sir.
a little louder, please.
Judge, can you change your voice to
Of course.
normal human speed? Can you change your voice to the speed of the conscious?
Can you tell us what Miss Libby, when you got there on June 7th of 2021, shortly before 8, where was Miss Libby?
In the bed.
And as a professional caregiver, and this was what time of night?
8 o'clock that night.
If one of your patients that you're taking care of is in the bed resting, do you like to disturb them?
No,
If they're sleeping, do you want to wake them up?
no.
So when you got there, was Miss Libby in bed?
She was in bed, yes.
And do you get briefed by Miss Mixon on what happened during the day, or y'all exchange, hey,
You know, it's come in, and, you know, change her, she need to be changed or whatever like that.
make sure that
She's
Dry.
She's dry. It's okay, yes.
and so where's your desk? What's your position when you're there, when you're in her room, Miss Libby's room?
Yes.
Okay. Where do you sit when you're in the room? I mean, what do you do to take care of her?
In a recliner. Have the recliner, sit there.
And is there a TV in the room?
Yes.
And is the TV usually on when you're there with Miss Libby in the evening, or
Yes,
was it on this night?
it was on, yes.
And do you remember what y'all were watching? Or what was on TV?
American Saves, a game show.
Say it again?
American Saves, the game show.
Okay.
American what? Sayings?
It's, stays on, it repeats. It's afterwards, repeats itself.
What channel is that on?
Game Show Network?
The Game Network show.
It's Game Show Network. My
Channel,
grandparents
excuse me.
watched it all the time.
At some point on the evening of June 7th of 2021, did you see Alex Murdaugh?
Yes.
Do you remember what time it was? Approximately.
The game show was on, so it had to have been 8 o'clock, 8:30, 9:30, somewhere up in there.
8:39, 9:30?
There's something up in there.
Is it fair to say it was later in the evening?
It was late in the evening, yes.
And you had worked that schedule for that 8 PM to 8 AM shift for how long?
2 years.
2 years.
2 years.
Was it unusual to see Alex Murdaugh at that residence that time of night?
Yes, on my shift, yes.
And that's the only shift you'd work.
Yes,
So the 8 PM to the 8 AM shift, it was unusual to see Alex Murdaugh there visiting, correct?
Correct, yes.
Have you ever been
He
over
had
there?
a pretty good
for-
reason for being there that particular day, though.
I think different off and on, it all depends.
When he got there, can you tell the jury what happened?
He called the house and told me he was outside.
He called the house.
Yes,
What phone did he call? It's a terrible question. I mean, was it your phone, the house phone?
the
I'm
house
not-
phone, the house phone.
And when you answered the house phone, what did he say?
He was outside. They let him in.
He was at the house,
Yes,
right outside the house,
yes,
and he called you,
yes,
and he said, let me in.
yes.
And after he called you, how long did it take you to go open the door to let him in?
About 5 minutes.
So he was right there
Mhm.
at the house.
Yes,
You let him in?
of course, yes.
Do you remember what he was wearing?
Shorts
Okay.
and a
I
t-shirt.
mean, if he's calling you to let you, he'll
know
let
what
him
kind of
in.
shoes he had
That's
on?
not weird
Those cloth,
that he's
cloth
there.
shoes, like Sperry's, that type of material.
Yeah.
Like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth, I mean, yes.
And you said something called Spears?
Something like Sperry's, that kind of, but it was cloth. That kind, yeah.
Wasn't boots?
No, it wasn't boots, no.
Are you familiar with tennis shoes?
Yes,
Was it tennis shoes?
no, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes,
Did he have any socks on?
no.
I don't wear socks a lot of the time either.
Tell the ladies and gentlemen of the jury,
Yeah, I rarely wear socks.
Oh,
could you
Especially in the
describe
summer.
Alex Murdaugh's demeanor on June 7th.
Unless
You
I'm
were
wearing
there with
nice
him and his
shoes.
Mother Libby.
He just
How was he
came
acting?
kids these days.
like fidgety.
I'm wearing a nice shoe. I put on
Fidgety,
socks.
Yeah.
like fidgety, I'm thinking, it's normal. Like he was fidgety, like, yeah,
Fidgety.
yes.
So saying.
She's talking too fast
um,
for the South. That's the problem.
Did he tell you why he was there?
What?
Just came to see his mother.
Oh, he was fidgety.
Did he talk to his mother?
But she was asleep, yes.
She was asleep. Okay. And what did he do?
A lot of Southerners talk that
What
way.
did all do when his mother was asleep?
I lived there
Came
for
in
20
from
years,
bed.
Nick.
Because we was actually, I was watching, I said American Says, I said a game show.
Did he say anything to his mama?
We said, hey, mom, how you doing? You know, just came to check up on you, yeah.
Said, hey, mama,
Did
mama,
he say
hey,
why he come
mama.
to check up on her?
Because dad was in the hospital, you know, call him Hansel, yeah, was in the hospital.
Yeah, it's a pretty good reason to be there.
Her opinion is being there, her caregiver, did she even know that he was there?
No,
The objection's overruled.
You said no?
no.
No one should ever visit an Alzheimer's patient.
I say y'all, for the record, you and Miss Libby, I apologize.
About 15 to 20 minutes, 20 minutes.
Was he moving around the room?
He was laying on the bed,
Did he have his phone with him?
yes,
Was he looking at his phone?
yes, he was on his phone, yes,
I'm sorry, ma'am. What?
yes. Mhm.
Okay.
After that initial conversation.
When I
you said
visit
he
my
said, "I'm here."
grandmother with Alzheimer's,
Did he
I
have
would
any other
look on
attempt
my
to have
phone
any other
too.
Conversation with Miss Libby?
Because
Can you hold your hand out?
she wouldn't remember anyway.
Yes, he did hold her.
Did you talk to her?
Yeah, she was in the bed, yeah, yes.
And her condition then was what?
She was, sleep off and on, sleep.
How long did he stay there? I forgot.
Said 20 minutes.
20 minutes, about 20 minutes.
I forgot.
It wasn't that long ago,
20
counselor.
minutes.
About 20 minutes.
Yeah, that's what she said. 20 minutes.
What happened after that?
He left, I'm guessing.
He left.
Wow, amazing.
Kurt the soothsayer.
Your shift ended when?
8 o'clock the next morning.
At some point after that, did you get a call from Miss Nixon?
Yes,
Did you learn what had happened at Mizell.
Yes. Mhm.
At some point after that, did you get a call from a family member? I really don't know who it was, but did you,
Yes, yes,
do you remember who it was?
yes.
Okay, who was it?
This is Randy,
Randy Murdaugh,
Randy Murdough, yes,
Alex Murdaugh's brother.
yes.
And as a result of that, what was, were you expecting people to come over after that?
No,
After that phone call, were you expecting people to come spend the night that night?
yes.
Okay, who was gonna come over?
Randy told me, John Marvin, Buster, his girlfriend, and Alex.
John Marvin,
Mhm.
Buster and his girlfriend, and Alex.
Yes,
And did you, and in fact, see them later on that night? Or that morning, the next morning, I'm sorry. Did they come to Alameda after you got a call from Mr. Randy saying they were coming? Did they come?
yes, they came, yes.
And at some point later on that morning, did you see Alex Murdaugh again? Did you see him again that morning?
No, mhm.
Did he ever come looking for glasses?
That morning, that night, he was in there. He came with glasses. He said he couldn't sleep.
Did he ever have a tarp or guns or clothes that he was disposing of? Because otherwise he went to
Was
his.
he covered in his blood? Was blood in his
Randolph,
hair?
Solicitor Randolph died shortly, a couple of days after that.
Yes,
Now, you were working the 8 p.m. to 8 a.m. shift. Were you asked to work more after this to get the family through this? Were you
Yes.
asked to help more at the house?
yes, mhm,
And were you happy to do that?
of course.
And do you remember the day of Mr. Solicitor, I'm gonna call him Solicitor, this way I know him, Solicitor Randolph's funeral?
Yes,
And I've been reading through all this stuff here. What's a repast?
a repasses, but everybody come back after the funeral and eat.
Everybody comes back and eats?
Yes,
Well, after the funeral, did people come to Alameda, so like a visitation after a funeral?
yes,
Did folks come over there then?
yes,
And was the family there then?
yes.
And during this repast visitation, where were you? And I said, what was your job during that, or what were you doing during the visitation?
I was in the room with Miss Libby, just back and forth.
And sometime that afternoon, did you see Alex Murdaugh?
Yes,
Tell the jury about that, please.
he came in the room,
You'd speak up, please, ma'am.
he came in the room and speak that, spoke like he always do.
And what did he tell you?
Hello, Bueller? Bueller?
Then he was sitting at the house. He was at the house.
Say it again.
He was at the house.
And I'm not 100% following you. He was telling you or saying to you that he was at the house?
Mhm.
When?
The night of the murders.
The night of the murders.
Yes.
What was he telling you about that he was at the house the night of the murders?
That he'd been there 30 to 40 minutes.
Was he telling you that? Did he ask you anything about that when he was talking to you?
Yes.
Did he indicate to you what he wanted you to do with that information?
No, no.
What did he say?
He just said that he was at the house. The 30 to 40 minutes, I said.
You said what? Was he there 30 or 40 minutes that night?
Did you not understand the question?
Not to my recall.
Why are you crying, Ms. Smith?
Because they're a good family, and I love working here. And I'm sorry all this happened. They're good people,
He wasn't there no 30 or 40 minutes, was he?
No.
Can't leave it with us.
Did that conversation upset you?
Somewhat.
Is this the night of the murders film?
Yes,
So wait a
Tell
second.
anybody about it?
my brother.
He was there
Called your
20
brother
minutes,
after that
but he
conversation
thought it was more
Yes.
30 to 40.
to tell him about that conversation.
Yes.
And what?
I don't know.
One of the themes of the state is was trying to orchestrate an alibi.
Yeah, I guess.
Like when he was calling all these different people and on his phone to try to create a record of making the calls.
But did she actually time? That's going to be the question. How do you know he was there 20
To
minutes?
be clear,
Well, she was watching the game show, right?
Yeah, I
what
guess.
was the statement he said about how long he was here?
30 to 40 minutes.
But his phrase was, I was here, or you know
I was here 30 to 40 minutes.
I've been watching this trial for 7 hours today.
No joke. You and me both.
Not surprised, but I can't help it sometimes. What else is going on in your life right there?
This is,
Socially awkward human says 20-ish minutes plus the 5 waiting
hours and
outside.
hours.
You're whispering.
Touche.
What you're saying.
When you gonna get married?
I was planning on getting married. I was planning on to.
And had Alex Murdaugh mentioned anything to you about your upcoming nuptials?
Yes.
And when was that?
Day afterwards, I'm thinking.
The day after this?
I'm thinking it was,
After
yes.
the conversation you
Yes.
said? Where
Offered to
were
pay for
you?
a wedding?
At the house.
And what did he say about your marriage, your upcoming potential marriage?
I heard you was getting married. I said, yes. He said, if I could, you let me know because the wedding's gonna be expensive. I said, well, thank you.
The wedding's gonna be
He
expensive?
said, wedding's gonna be expensive. I said, well, thank you.
Did he offer to help?
Yes, he offered. That's the type of person, a good person.
And did he ever mention the wedding to you before?
No, mm-mm.
Did you mention that to him before?
No,
Did he have a conversation, anything else about your job? Were you working at the school?
yes, at the school, yes,
Did Mr. Murdaugh mention to you about your school and your position there?
yes.
Tell him what he said, please.
He said that, if you need a position at school, my good friend is there. I said, yeah, I know, worked at the school, the principal.
Retro 704 says she's about to mention Alex helped her
When you
bust up a
testified,
shift
you-
robe.
Did you help out
That's a
more than
deep
just your regular
reference.
shift the rest of this week?
Yes,
That week after
yes,
the murders and Solicitor Murdaugh's death? Were you working full-time then, trying to help?
yes,
Was school out then?
no,
So you still going to school and helping?
yes.
And after Mr. Randolph's funeral, did you have an occasion to see Alex Murdaugh early one morning?
Yes,
Do you know how long it was, how many days after the funeral of Mr. Murdaugh?
3 days, I think, 3 days.
Can you tell the ladies and gentlemen of this jury what time it was in the morning that you saw Alex Murdaugh?
6:30 that morning,
Say that again.
6:30 that morning,
And that had been a part of your regular, 8 to 8 a.m.
yes.
And did he call you and tell you he was coming?
No,
You didn't? Had he called you on June 7th and told you he was coming?
yes,
And he was right outside the house?
yes,
And this morning at 6:30, he did not call you?
no.
How did you know he was on the premises?
He knocked by the bedroom, yeah, the window,
Not.
yes, on the wall.
Or did you hear him say anything after that?
He said, I'm outside,
Say it again?
I'm outside.
Had he ever been there at 6:30 in the morning before that? While you were working there?
No, sir,
Never.
no.
And tell the ladies and gentlemen of the jury what you observed that morning when you saw Alex
And
Murdaugh.
his wife and son died, and his
He came
dad
in the
died in
white-
close
Left in the
succession.
white truck, came in the white truck.
Ever before in your employment?
Was there still
No joke, right?
funeral stuff's not the world road? There's still funeral equipment in the yard?
Mhm, yes,
Like what?
The tent was still there and the big old building, they put the food in, had out there, like, oh, yeah.
Like a food truck?
Yeah, food truck, yes, yeah. Kind of, yeah.
Was that blocking your view some?
Yes, Broadview, yes,
So when you saw Alex Murdaugh this morning at 6:30, what did he do after he knocked on the door? Did you let him in?
yes,
Then what did he do?
came inside,
And was Miss Libby sleeping?
yes, she was still asleep.
Okay. Did he go check on Miss Libby?
No, he didn't come in, no. Mm-mm.
He didn't go check on her?
I can't remember.
Well, what did he do then?
He came inside.
Okay.
Mhm.
And did he have anything or was he holding anything?
He had a blue something in his hand,
Say that one more
a
time.
blue something in his hand, something blue.
A blue something in his hand.
Mhm.
Okay, so here's the
And,
TARP testimony. This is what,
can you show me
8 days after the murder, 6
how he
days,
was
something
holding
like
it?
that?
Like this,
Is it all right if I touch it?
yeah, that's fine.
She said 3 after the funeral. I think the funeral was 2 days
Oh,
after
something
the
like this.
murder.
And what did it look like?
Like a blue tart, like a tart,
Blue?
blue.
Okay. Was it vinyl?
It's like a tart that you put on a car, you keep your car covered up.
Big thing.
Yeah, blue. Yeah,
And was he holding it like this?
it's sort of like, yes.
Could you tell if there was anything in it or do you know?
No, I couldn't tell.
But not holding like this.
Mhm.
Did he say anything when he walked in?
No,
What did he do when he walked in?
went upstairs.
Make course notes.
So 5 or 8 days after the murders, he had a blue tarp, and that must have been the blue tarp he used to cover himself with blood or what?
I think the idea is that he wrapped up the firearms in the blue tarp and brought them, because I think they're going to have testimony that there's gunshot residue on the tarp itself.
On the inside.
Yeah.
2:30.
Which, if
Okay.
it's actually a raincoat that he would maybe wear while hunting, I don't know.
I mean,
Maybe
I would imagine, as I said
223.
before, I imagine gunshot residue kind of gets everywhere when you're on a shooting
222.
property, you know.
413.
You touch guns, you shoot
412.
guns all the time. Gunshot residue is going to be everywhere.
At this time without objection, I'll save the other two.
You're admitted without objection.
what's the difference between an enzyme and a hormone? You can't hear
Just
an
like Mr.
enzyme.
Murdaugh came into Alameda residence that
Good
morning.
one. I like that joke.
This is States
Damn it, Loco.
223. Do you
That's a nice
recognize
one.
that?
Yes,
What is that?
upstairs, going upstairs.
And is that where he went?
Maybe not the way
Alex
you're
Murdaugh
doing
that
it, you
morning,
can't.
Yes.
Carrying some blue thing,
Mhm.
and this may be duplicate. If it is, I'm sorry. That's 222. Same stairs, same house.
Yes,
States 413. What is this?
that's the bedroom,
Where in Alameda is this bedroom? First floor, second floor?
first floor.
Is this where Miss Libby stayed?
No, mm-mm.
And 412? Is that the same?
Yes, same bedroom, yes.
I'm guessing on this raincoat in which they found the gunshot residue, they didn't also find massive
Show
amounts
you
of
marked,
Paul
what's
and
marked
Maggie's blood.
411. Don't call out the answer. This is
Right.
stage 411 for identification.
So he managed to
at this
clean the
point.
blood
Do you
off,
see
but not the
blue
gunshot
object in the
residue?
Center.
Yes,
Does that appear to look like the object you've described?
yes,
You saying yes?
yes,
Is it blue?
it's blue,
Is it vinyl?
yes,
That appears to be the same thing you saw the defendant holding this early morning hours when he came in the house. Is that correct?
it looks so, yes.
You know, this is states 411 we'd offer at this point. I don't know how to ask except to ask it. Did you ever see that blue thing unfolded when you were that morning, or you saw him carrying it?
It was unfolded
Okay, where'd you see it?
in the bedroom,
And where in the bedroom?
on the chair.
And again, I'm not clear. Was that in one of these pictures we showed you? What chair? Did they disappear? Oh, I'm sorry. I apologize. Was that on one of these chairs in this?
Yes,
Okay, and I'm referring again to 412. You saw it on the chair?
yes.
The notion he was hiding this at
You
his
ended up
parents'
leaving
house
at some
is
point that
ridiculous.
day,
He could have
right?
shoved it in any garbage
When
can
you
at any
came
gas
back the
station
next
along
day,
the
was
way.
that there?
No, it wasn't.
It was gone.
Yes, it's on.
And did you see Alex Murdaugh leave after he went upstairs? Do you know what he did upstairs?
No, no,
Did you actually see him leave the house after he went upstairs?
yes.
And where did he go?
Oh, I don't know. He just left outside and left.
Okay. Did he say, hey, I'm leaving?
Yes, I'm going, yes.
And at that point, what did you think? Did you think he'd gone?
I thought he left, yes,
Okay. Did you see him after that?
yes.
Tell them where, please.
He
That
came back,
morning.
he came back to the house.
And how do you know that?
Because the blind was open, I seen him came through the driveway.
And what did you see him? Was he walking? Was he driving when you saw him in the driveway?
He was driving the truck,
And I'm sorry, Ms. Smith, what truck was he driving?
the white truck.
Whose white truck was it?
I'm thinking it was Mr. Reynolds. I thought it was his truck. He had the white truck also.
He had a white truck also.
Mhm.
So when you testified Mr. Murdaugh coming back in a white truck, that was Mr. Randolph's truck?
Mhm.
Whose truck was it?
I don't know.
Ma'am, you must use words as opposed
Was it?
to-
Yes, I don't know.
Or because we need to know exactly what you're saying. Say yes or no if you can.
Whose truck did you think it was?
I thought it was Mr. Randolph's truck.
And were there four-wheelers or ATVs out on that property?
Yes,
Okay. What, if anything, had you observed about a four-wheeler that morning?
it was at the house,
Where had it been previously?
at the smokehouse,
When did it get moved?
the same day of that, the same morning.
Same morning when Mr. Murdaugh was there.
Yes,
And in what direction did you see Mr. Murdaugh leave? When you saw him leave the house and you thought he was gone?
Mhm.
Do you know where he went?
No,
And when he came back in this white truck, what did he do?
he got another truck,
How long was he gone?
for about 10 minutes or 15 minutes, thinking.
And then you say this other truck. What truck are you talking about?
It was a black truck.
Had you not seen that before?
No,
Why not?
because the food truck, the catering thing was still out there anyway, so I couldn't see it.
So that blocked your view.
It's blocked my view, yes.
So what vehicle did Mr. Murdaugh leave after he came back in the white truck? What color truck?
It was a black truck. Black.
You know whose that was?
No,
That morning, this morning when you first saw him at 6:30, did you observe anything about his face? Any on his face?
they had like a little color, a little blue cut or something,
And ma'am, I apologize, a little what cut?
like a little bruise or something.
Where was it?
It's like above his forehead,
I won't ask you to touch me, but can you touch yourself to show where?
right here,
Oh,
right here.
Did it look
careful
fresh?
there.
This looked like a cut, not, I wouldn't say fresh, but it looked,
Was there a video system in the house for either Solicitor Murdaugh or Miss Libby Murdaugh?
yes.
Can you tell them about that? Where was that? What was that?
It was in the, Miss Libby's bedroom.
And how was that activated or operated? It's better. Do you know?
No,
Was it on all the time or not?
yes,
And what color would it be if it was on? Was there a marker that, or a red and black or red and green?
no surface, yes,
And would there be times when that wasn't on?
yes.
And do you know who controlled it?
No.
I'm going to show you what's marked 410. Do you recognize this?
Yes.
Okay. And does it relate to what we're talking about this morning as far as your location?
Yes.
Your Honor, 410, I believe without objection.
Says it relates.
Her testimony, where she was at.
No objection.
It's admitted. Without objection, it's submitted.
Can you see this on your, you got a little thing up there? Do you mind coming down here?
It's amazing that this trial was scheduled to be done by the end of this
Briefly, it
week.
won't be long.
I don't see that really happening right now.
Not a chance. The state isn't even
If you would
close
stand
to
up, let's just,
resting.
block the jurors.
I wonder why her marriage didn't go through. Was she marrying Paul?
Oof.
Is this a picture of what we refer to as Almeida?
Now Randolph.
Can
Randolph.
you show where the, I guess I called the main house? And I'm sorry, we don't have a pointer. That's the main house. And you have to say yes for the record, please, ma'am.
Yes.
I'll be right back. I got to say hi to Lady
Down
Brandon
here, I
before she
know it's
leaves
hard to
again.
see. Can you tell what that is? Sorry. Can you point to the main house again? I think we blocked some jurors. That's all we're doing.
Right here.
Is that where you took care of Miss Libby?
Yes.
Now, down here, there's even a little O on it. Do you know what this is down here? Let me ask you this, what other buildings are on the property?
The smokehouse and a barn, another little shed
And where were the ATVs usually?
at the smokehouse.
Where's the smokehouse?
That's it. Yeah,
There you
that's
go,
it.
that's the smokehouse.
Mhm.
And that's where the
Shed.
ATV was.
Yes.
And where did the ATV end up when you saw it after you thought Mr. Murdaugh left? Had it moved?
At the main house.
Say that again, please,
At the
ma'am.
main house.
Okay. And when you saw him coming back, you thought he left. Where did you see him in the white truck? Do you remember?
He left me across the railroad track, He left me across the railroad track and went out.
Which way to railroad tracks?
This way, I mean, that's the house. So had to been around, just had to drive through.
You're not going to say anything, but speaking up.
I'm trying to.
They don't have railroad tracks
That's
like
good.
I have
Good.
railroad tracks. Mm-hmm.
talked with either Mr. Griffin or Mr. Harpootlian or one of their investigators?
Yes.
There was, yeah. Best you remember. I'm not looking for a date and time, but you know how long we got?
It was last year.
And I met with you a couple of weeks ago
Yes,
and just a little while ago this morning.
yes.
And I have to ask you for the record, this Alex Murdaugh who came and saw you the night of the murders with the shorts and the shirt and the Sperry type loafers on, is that him over there?
Yes, sir.
And is he also the person that you said told you he'd been there 30 to 40 minutes?
Yes,
And is he also the person you saw in the house that night with some kind of blue vinyl that you said consistent with this picture we put in? Is that him?
yes.
Thank you, that's all.
Good afternoon, Ms. Smith.
Good afternoon.
We have met once or twice. Did anyone ever show you a blue rain jacket?
No, no, that. Yes, I think so. Yes.
Now, some of our investigators showed you a picture of a blue rain jacket.
Yeah,
correct?
picture of everything, yes.
But has anyone at SLED or the Attorney General's office ever shown you a blue rain jacket?
No,
Now, you saw Mr. Murdaugh bring a tarp in, you said, right?
yes,
And I'm going to show you a tarp, which we marked for identification purpose. This is, Your Honor, Exhibit 86. Is this the type of tarp that Mr. Murdaugh came in to the Alameda house on the day that we're talking about?
yes,
Tarp like this that would maybe cover up a car. Is that right?
yes.
Any way to confuse this with a rain jacket?
No,
He was not carrying the rain jacket, was he?
no, it was balled up. I don't know it.
And you said it was balled up, and it was balled in such a manner it did not look like there was a shovel handle, a gun, or anything. It's just balled up. Is that right?
Correct.
Have I balled it up sort of correctly?
Yes,
All right.
No, we have no objection to that going in.
Your Honor, move Exhibit 86, I think, in evidence.
Without objection.
Now, when Alec left that day, this was laid out on Ms. Libby's retirement rocking chair, wasn't it?
yes,
And you had, and when you left for end of your shift that day, that's where it was, right?
yes,
And you've never seen it since, correct?
correct.
Now, they showed you a picture, which is in evidence. Do you even know where that picture was taken in the house?
No, in the closet.
Do we have that picture? What's the last photograph that went down? Can you see that, Ms. Smith?
Yes,
Do you know where that is in, or even if it is in Ms. Libby's house?
I couldn't say because I don't be in the closets. I don't know.
So you don't even recognize the closet, is that right?
Correct.
And have you ever even been upstairs in Ms. Libby's house?
Twice,
2 times over how many years?
3 years.
2
Really?
times in 3 years.
Wow.
And do you know where Alec Murdaugh went when he went upstairs on the day that he brought a blue tarp in the house?
No,
Now, you mentioned that this day that he came over was about 3 days after Mr. Randolph Murdaugh's funeral. Is that right?
Yes,
Okay. And it was early in the morning?
yes,
So, and do you remember that Mr. Randolph's funeral being on a Sunday?
yes,
So then it would be Monday, Tuesday, Wednesday of that week. Is that right?
yes, that's correct.
And is that the morning that you said that you thought you saw a bruise on his forehead?
Yes,
So it was Wednesday after Mr. Randolph's funeral.
I'm thinking, I can't remember. It's so long, I can't remember.
Yes, ma'am. And and you mentioned that that he came in a truck. I think you said he drove up in a white truck.
Mm-hmm,
Is that correct?
yes.
And he does have a white truck, as
Yes.
far as you know, right?
Yes,
And then you said he left in a white truck. And are you sure that it was Mr. Randolph's truck or Mr. Alex's truck that he left in?
because it was moved. Mr. Randolph had always keep his truck in a certain position, certain part.
So you think he left in Mr. Randolph's truck and moved?
Yes,
And when you came back, when you left that morning, I guess Wednesday we're talking about, was Mr. Randolph's truck back in the driveway,
yes,
parked in its normal place?
yes,
Anything out of sort?
no,
Was it all covered up with mud, like someone's been mudding in it?
no,
Anything unusual about the truck?
no,
Now, you mentioned there was a four-wheeler that had been moved at some point in time. That four-wheeler had a flat tire, didn't it?
yes, it did.
And was it a front tire, back tire?
I think it was a back tire.
And it was moved up close to the house,
Yes,
far as you know, so the tire could be repaired
yes, it was moved from the smokehouse to the wreck house. Yes,
with a flat tire.
yes, with a black tire.
Now, you were asked questions about the day of Mr. Randolph's funeral. And you had a conversation with Alec, and he's talking to you about how long he was over at the house on the night of June the 7th, right?
Yes,
And he said he was there 30 to 40 minutes.
yes,
And you said, no, I don't think it was that long.
yes,
And then the next day, I think you said, or day after, well, the following day, or I guess that would have been Monday, you had another conversation with him where you just brought up back that you were going to get married. I think you said that was a different day, right?
yes,
And he was just being nice, wasn't he?
yes.
I think you used the word good
A
person.
good person, yes.
Who were you referring to when you testified in response to the question by Mr. Meadows that someone's a good person?
Mr. Alex Murdaugh.
Now, he came over on the night of June the 7th. And you said it was somewhere between 8:30 and 9:30 in the evening.
Yes,
And that's just your best estimate of when he got there, is that right?
yes,
And I think you testified that he was there, in your estimation, 15 to 20 minutes?
yes,
Now, when you said 15 to 20 minutes, you're talking about 15 to 20 minutes in the room with Ms. Libby or on the property the whole time?
been property the whole time. Thank you.
Okay, well, now you said it took you about 5 minutes to let him in, is that right?
Yes,
So
So he's in the
Are you
room 10
including
minutes?
the 5 minutes it took you to let him in your 15 to 20, or could he have been on the property 25 minutes?
20 minutes on that is
No.
the whole time, so.
Mhm.
And you would agree that
It's a bad way to ask that question.
Alec Murdaugh would visit his parents frequently, right?
Yes,
And he would always come over more so than any other sibling. Is that right?
yes,
And you would agree that it was not out of the ordinary for Alec to come at night, correct?
yes.
You agree with that, right?
No,
Wait,
So
what?
you don't agree that is, so was it out of the ordinary for him to come at night?
yes, on my shift, yes,
Well, do you recall being interviewed, a telephone interview on June 17th, 2021 with Agent Joe Albiado? You remember that?
yes,
And do you remember telling him that it was not out of the ordinary for Alec to come at night?
yes, it's been a long, I couldn't remember, it's been a year now. so I
Oh,
can't
it's been a
really
year now?
remember.
I mean, is it possible that you told him that?
Yes,
Why would that be possible? Why would it be possible if that's the truth?
And here today, you said, as I have in my notes, that when he came over, that he was acting kind of fidgety, yet normal. I believe that's what you said.
Mhm.
Is his normal behavior kind of fidgety?
yes,
He's just kind of a fidgety person, right?
yes.
So it wasn't the first time you'd seen him being kind of fidgety, right?
But he always come different times, so I can't,
But his demeanor was normal for Alec the night that he came over on June the 7th, wasn't it?
I'll say yes,
Okay. Now, you mentioned the clothes that he was wearing. And he came in and he sat on his mom's bed,
yes.
lay down
Late,
next to her
late, late. Mhm.
and held her hand. Is
He
that
walked
right?
in and hold her hand and spoke to her, then went on the bed and lay down.
And lay down.
Mhm. Not lay down, but sit up.
Wait,
And when he got up off the bed, was the bed soiled in any way? Was it wet?
I can't recall, but I didn't touch it.
No. What, did Alec Murdaugh have blood on his clothes?
No. I didn't-
He had blood on his shoes.
No,
He had blood on his hair.
no,
Did he leave blood in his mom's bedroom?
no,
Now, according to the records that we've been providing in this case, you were interviewed by SLED on June 16th. Do you remember that
yes,
interview?
yes,
And I think in that interview, you told SLED that he had been there 30 to 35 minutes. Do you remember telling him that?
I think it's, yes,
And then you were interviewed again by telephone on June 17th. You remember that follow-up call? You remember having a short phone call on the 17th?
a phone call.
Okay.
Mm-mm.
Well, whether it's one interview or two interviews, you never told anybody at SLED in June in these interviews, one or two, anything about Alec coming in with a blue tarp. Is that right?
Right,
You didn't say anything about a blue tarp until sometime in September. Is that right?
yes,
why?
And you initially mentioned something about Alec coming over with a tarp. The first time you mentioned it was to Officer Joseph Dingle of the Allendale
Dingle.
Police Department when he was working a
You
wreck.
know
You
that guy's
remember
called
that?
Dingleberry.
Mhm.
Is that yes?
yes,
Okay. and you had been in the automobile accident, and Officer Dingle was working the wreck and I guess filling out an incident report, and you were having a conversation with him.
Yes,
And in that conversation with Officer Dingle, didn't you tell him didn't you tell Officer Dingle that
You sure it's
on
not
the night
Captain
of the
Dingle?
murders that Alec came over with a blue tarp that looked like it had a gun
First
in it?
Lieutenant
no,
Dingle.
I felt like he was holding something.
So you didn't say,
I didn't say specific it was a gun. I said he was holding something.
Was
so
it
you
his
didn't
dingle
tell
that he was
Officer
holding?
Dingle that he came over and you couldn't tell, but stated it looked like a rifle.
No, I said it was like he was holding something. I did not say it was a rifle.
And if Officer Dingle wrote a report up saying that, he was just incorrect.
Yes,
Ooh, that's good.
And then after you had this conversation with Officer Dingle, then you were contacted by SLED agents, right?
hmm
And they asked you to go down to their offices, and that's where you were interviewed in September, right?
yes,
And in that interview, you told them about a blue tarp that you put over your car, just like this, right? Is that correct?
yes,
Okay. And you didn't tell them because it's not true that there was anything wrapped up in here to look like a rifle.
right.
The tarp doesn't look like it has blood or anything on it.
And
And if it did, he'd just
since
throw it
that
away in
day
a
of the
garbage can on the
interview,
way. Why would you hold on to that?
SLED office, have you
Right.
had any additional interviews with SLED agents other than getting ready for trial last week?
Yes,
How many additional interviews?
two or three.
And in each of those interviews, did you reiterate to SLED that it was a blue tarp and not a rain jacket that you saw Alec Murdaugh walking into the house with?
Yes,
Is there any doubt in your mind it was a blue tarp like this and not a rain jacket?
and it was balled up with a blue tarp.
So you saw it laying on Ms. Libby's retirement rocking chair, right?
Yes, yes.
Second, Your Honor.
Oh, that's not the original tarp?
No.
Oh, okay. That makes more sense. I wasn't here when they got it out. I was like, that tarp looks remarkably clean.
It's just a different blue tarp we picked up at Walmart. It could be similar to the tarp. That's a kind of evidence.
Where is the tarp? They never
Where
recovered
is
it?
the evidence is the big question to most of this trial.
So they never
Just one more
recovered
point.
this tarp? They don't know anything about it?
When
Other
Alec
than
Murdaugh
that
came
there
over
is a
on
tarp,
that
or
early
was?
morning, I guess it was Wednesday, you testified.
I don't think
were
anybody
you
knew
in
about the
Ms.
tarp
Libby's
for
room?
months. So when they went to look for it, it's probably just gone.
Yeah.
You can't see the comings and goings out of the driveway from Ms. Libby's bedroom, can you? You can?
No,
Okay. Thank you, Your Honor. That's all the questions I have.
Wow, illuminating.
Well, Amazon's sending me all kinds of recommendations for women's shoes. So I guess Emily must be shopping.
January 20th of 2022, on page 25, line 17, when you were asked about how long do you think he stayed in total, do you remember that?
yes,
Do you remember your answer being 20, 10, 15, 20 minutes?
yes.
Mr. Griffin asked you about the 30 to 40 minutes. Why'd you call your brother after that?
Because he's a assistant chief police at Warrenville. So I called him.
Had that statement by Alex Murdaugh affected you?
Yes,
How?
I was nervous.
And Mr. Griffin asked you about the evenings visits and the morning visits. Had he ever been there at 6:30 in the morning like he was that morning? Ever?
No,
In his 9:30 visit, the night of the murders, That was very unusual for him to be at night, wasn't it?
Objection, leaving.
Don't leave the witness.
I'm sorry.
He already did.
Yes,
Was that unusual?
yes.
Don't lead the witness. Just answer the leading question, though. It's fine. Don't make him rephrase it. That would be terrible.
Now, so you told an officer, did you tell an officer about this? You saw something that he thought he was carrying
Yes,
before you told anybody else?
yes.
And what was that about, a traffic accident?
I had someone.
There's
hit my
another
car.
leading question
He was
there.
on duty,
And when was that?
September 11th.
That's my birthday.
Hashtag never forget.
You had an accident, and you told the officer that you had seen him, Alex Murdaugh, come in holding something?
Objection
The
leading.
fact that your birthday, September 11th, why you're such a disaster area.
And you just told him that.
We was talking.
Had anybody asked you that before?
Mhm.
You have to say yes or no.
Yes,
Had
No,
anybody asked
no,
you that before?
no.
Okay. So why did you tell the officer that on September 11th?
We was having a conversation and just talking in general. And he asked me a question and I said, yes, I've been there. And I said, I work with the Murdaughs. His mother.
In response to him, you told him you saw Alex Murdaugh with what?
A lining, a blue tart,
And you saying tart or tart?
like they cover a car with a tart,
And you said you saw him with that, and did it appear he was carrying something?
like he was holding something. It was bundled up. It was bundled up.
Bundled up?
Yes,
Like this?
yes.
So you never saw this unfolded?
No, I never saw it
Never.
till the next morning. So it was on the chair. I'm just looking through him.
And you don't know where this tart came from, do you?
No, I don't know where it's coming from.
And it didn't have silver on one side, did it?
No,
It was all blue.
all blue.
And you said that the defense took a statement from you?
Yes.
Did they record it?
Yes.
John, under Rule 613, I'd like a copy of that statement or the recording at this time, if they have it. She's now taking stand.
Why didn't you ask for this in discovery earlier?
Your Honor, under Rule 5, it is not subject to being produced. And we didn't question her about the statement, so.
Rule 5 is pretrial.
Under 613, once the witness has taken the stand and she said that they took the statement from her, either recorded or written, we don't have it, hadn't been provided. He asked her about that specifically, dealing with the blue tarp, and when they discussed it with him, I'd like a copy of it.
I actually don't mind him having it, Your Honor. We don't have a copy with us.
Rule says upon request, the same shall be shown or disclosed to opposing counsel pursuant to Rule 611A. So the defense must provide it to counsel.
Where's his mic?
We do have a copy here. I don't know if we can download it to, yeah?
Is it okay to produce it on a flash drive? Judge, I mean, I can't look at a flash drive, but yeah, I guess. Is there a hard copy?
Well, you're either going to get it a flash drive and plug it into your fucking laptop, or you're going to get it printed off on a piece of paper. It's going to be the same damn thing.
I'd like to have an opportunity to listen to that without the presence here. Yeah, I'm assuming it'll be a hard copy, but I don't want to mess the court schedule up either.
Yeah.
Ladies and
What
gentlemen, we'll have
schedule?
you go to the jury room. Please not discuss the case.
How about lunch?
He's not going to do lunch for another 22 minutes, probably.
Oh, good gosh. Now I'm thinking about lunch. Okay.
Why weren't they asked to produce this? And just, I mean, this is a state witness, and they clearly had her on the list. It's not like she's coming in randomly now.
The why didn't we solve a lot of these problems in pretrial is a very pertinent question. Also, does it matter? I'm just waiting for, because we haven't heard what happened at this meeting that they want to get to this attorney-client privilege stuff. I'm guessing that we're going to
Eddie's
admit it and it's
momentarily.
going to be nothing. That's my working bet. We're going to go through all
Probably.
this pain of, can we admit it? Is it privileged? Have a huge fight over it, determine it's not privileged, and then it's going to be like, I like Moselle. Moselle is nice. I like living there. Yeah,
I'm just
that's
curious
going to be the statement, because that's how this trial is going.
why do we not have a production request for this statement? Like, they have to have known that this already existed.
Yeah. Yeah.
I mean, that you would think that when they interviewed their own witness, they would have said, now, has the defense interviewed you at all? Have they talked to you at any time? Yeah, they did. Oh, okay. Was that recorded? Do you know? Did they write that down? Did they do a physical recording? Was it over the phone? Anything like that? And even if they didn't ask that follow-up question, it would just be part of the regular production request. This
I've
trial,
never
man.
seen such extensive pretrial hearings in the middle of trial.
Yeah, exactly. Here we go. Denmark Radar says, should the defense actually make a motion for compounding the two trials, murder and financial, for instance, to ensure proper application of the Fifth Amendment? I mean, it'd be denied. The judge isn't gonna. If they combine the two trials, what would happen is this one would get. I guess this one would get continued, and they'd lose their speedy trial. They'd have to waive their right to speedy trial.
Yeah.
And then
Maybe we can also roll in the whole boat litigation. Do it all in one.
The way
just-
it's going,
do
right?
one shot.
Ladies and gentlemen, jury, I want you to decide whether this discovery dispute should be resolved in favor of the plaintiff or the defense.
Just insane. What
Do
am I
we get
eating?
access to this book?
What am I eating? I have these very Jewish dill pickles, Clausen
Excellent.
kosher dill sandwich slices. They're really delicious.
Are you trying to attack Tug?
Yes. Yes. Zool
That's my
says,
thought.
just a thought. What if the state's plan is to run out the clock so the defense isn't able to make an effective case? Why else would you want to bring? That
Well, let's see.
isn't a thing you
if
can
you
do.
need a half an hour to listen to this tape. We can take.
We have a rough draft of a transcript that we're emailing to them but it's 57 pages long, but we're sending it to them.
A rough draft.
So I'd like to look at the video at this point.
I'd like to
I'm
watch
going to
it.
bring the jury in and break for lunch.
They're going to watch it over lunch, or they're going to watch it when they come back from lunch?
Are you continuing watching this trial all the way until Vegas just to remind yourself how lucky you are to get away when you get there? Is that part of the plan?
Yeah,
Like by
except
torturing
now
myself, I'll love it even more.
I'm going to have to miss a couple days now. Like I've got a new thing on Friday that I'm probably not going to be able to stream on Friday of this week. But next week I had stuff already on Wednesday and Thursday. So I'm going to miss those days, and then we'll see going up to when I leave for Vegas. But I think this thing will be going on in March at this rate.
Yeah.
I mean, I hope I'm wrong on that, but good Lord.
Well, I might cover a day if you're not going to stream that day, but I think otherwise I'm kind of done with this trial because it's just boring and torturous. I did my 10 days of service. I'm good.
It's kind of terrible. Like this expansion of the clock is crazy.
Yeah.
And the judge, I mean, even the 3-week trial is looking suspicious if there wasn't all the financial testimony, in all honesty. Just the way the languid pacing moving through those witnesses. And we still don't even know, I guess, who else of the non-financial witnesses they had, but presumably they still have several to go. I don't know.
Well, we have to hear from the medical examiner for sure.
One would imagine.
And that's going to be long testimony.
All right, thank you. Ladies and gentlemen, we'll break for lunch till 2:30. And
I would assume we'd also have to hear from the lead investigator still. We've only heard from the assistant lead investigator. Right? I mean, maybe not.
Yeah, I don't know. I mean, I hear in the comments that a lot of people have in the law enforcement circles, local law enforcement, have been fired or
Jury number 729.
prosecuted, mostly over this boat event.
So you can return to the jury room, please.
Thanks for coming back. Now get the hell out. I wonder if he's going to make him do a working lunch over this
Is the
recording.
jury allowed to get funnel cakes during the break? That's the only thing that makes it worthwhile. Does the daily allowance include the funnel cake?
God, funnel cakes are so good. Have you met people who've never had a funnel cake? They don't even know what they are.
No, because I don't talk to monsters.
We're going to take a break for lunch. You just cannot discuss your testimony with anyone during lunch, but you can step down and have a good lunch. And we will be in 2:30.
It's not okay. So I guess they'll get to listen to it and review the statement privately. I thought they were going to maybe play it in open court, but just without the presence of the jury.
Yeah.
What a disaster that is.
Hey, I got my grift up. Yeah, let's knock that
There you
out. Free book, Law Self-Defense Principles. Check it out on Amazon. 5-star rated, over 1,200 reviews. But don't buy it on Amazon. They'll charge you for the book and shipping and handling. We only ask you to cover the shipping and handling. We eat the cost of the book. You can get it for free. Real physical book, folks, not just some PDF download. Get this at lawofselfdefense.com/Nick. Nick, so Nick will get credit when you
There you
order
go.
the book.
Go order a bunch of books, y'all. Bury him in shipping and handling payments or whatever.
Thanks, brother. I think we're just going to use lawselfdefense.com/Nick all the time now on your show. We'll just change what it goes to,
There
free
you go.
book or class, whatever, just to keep things consistent.
Makes things nice and easy for people. Well, what do you guys think so far? I mean, I thought we'd all kind of resigned ourselves to the fact that the judge was going to let this in, the prior acts evidence, which I really do think is improper. I think it's way too prejudicial to allow that stuff in. And I still don't see the logical nexus. And I didn't see the prosecution make the argument for the logical nexus, although in fairness, they may have done it by written motion, I guess.
I mean, I can't justify watching that part of the trial. It's completely pointless. They're going to have witness after witness testifying that Alex stole a bunch of money from them. I get it. You sold me. I believe you. First of all, so what? But second of all, I already know what the testimony is going to be. So I can't justify spending day after day listening to that. They should just put up a flag when they're done, and maybe I can hop back in once they're talking about the actual use of force event again. But I wish they could just get all that testimony in over a weekend or something when I don't have to pay any attention.
Yeah, because and the number of people, the number of victims of the financial crimes. Remember, he's charged with, I think, 91 or something financial crimes.
106, I think, was last count I saw.
106 financial, and it's not just one party. Like it could theoretically, you could have a financial crime against one party if it's over a period of years or whatever. Sure, this isn't that case. This is tons of people, and if they're going to bring in all of, I mean, they theoretically could bring in all of them, and the defense is going to want to cross every single one of them because the defense wants to raise the specter that any of these people could be motivated in the killing.
Right.
And
Once it's coming in, you want the more the better for the defense.
Right. Yeah. It's it's just crazy.
I mean, that's $10 million worth of people he screwed over, their families. A lot of dreams broken. That's
Is it
a
only
lot of
10
people who have
million? It's
potential
got to be
motive.
more than 10 million.
I thought it was 8.
I rounded up.
Who knows? I have no idea.
I mean, it took 4 million just from the
8.5 was the
housekeeper.
last count I saw officially, but yeah, I
Like,
rounded up.
This is consistent with the rest of the trial is what I'm trying to say, in that I still barely know what's going on half the time because the way the state is running their case, they haven't given me a good narrative structure as to all of this stuff. The only thing we got was that little 5.5-minute oratory during opening statement that was like, he went down, he killed them, he got in his car, drove to his mother's house, and then he drove back and found the bodies and then tried to claim that someone else killed him. Like that's an adequate summary of what the state has laid out for what happened. They didn't lay out anything related to motive for the financial crimes, motive. And I've seen so many rumors. Oh, Maggie was consulting a divorce attorney. She was going to expose all this, et cetera, et cetera, et cetera. The state didn't lay that out. That's all conjecture at this point. And it may be part of their case that they get to eventually, but tell us this damn story arc before you're going to fill in the details. I mean, this isn't TMC.
Even the divorce thing, folks, thousands of people are getting divorced every day. They're not killing each other.
Right. Now, if she had said, if her divorce conversation had some sort of, like maybe they bring in the divorce attorney, right? And he can now disclose their conversation since she's dead and can't assert privilege. He could disclose that she had suggested to him that she was going to go to the police with the financial crimes that she just found out about, and that was the motivation for the divorce, and she needed to get away from it, and his whole world was going to collapse down. She wasn't going to be taken with it. I mean, maybe you got something like that. But again, that would have been, all of this should have been in opening statements if any of that was coming through. So, no, man. What a mess.
The trial has been incredibly just frustrating, boring, banal, lots of detail. The story, the ability to connect evidence has been completely missing. I don't know the degree to which they can even connect evidence. Like they talk about particular rounds or shells or casings that were found at the murder scene and other ones that were found in the house, but they're not doing like a one-to-one comparison. Is that because they can't, because there's not a one-to-one match? Are they just similar? Or are they the same? Are they saying, yes, this is the exact same ammo, the same brand, same gauge, same length, same shot size? Are they saying that? Or are they just saying they're similar because they're not connecting it?
They can't even
They're
say
going
all the
through this
brass
tedious
was
detail.
fired from the same gun.
Yeah. Yeah. So there's just a lot of that where it just doesn't really seem to connect in any way. And then there's a lot of this tedious detail. And then it's the evidence we didn't find. We didn't find blood. We didn't find fingerprints. We don't have the gun. The timeline is also really tight. He's letting Sled in that day, he's talking to the cops in the car and they're interviewing him. The next day, Sled's in the house with his consent, looking around. They're not finding bloody clothes, not finding blood in the shower. They're not finding things. They've got spent casing at two parts of the property that are similar.
I mean, he could have just
can date them.
He left, right? He went to his mother's house. If he'd already killed them, he could have just stayed at his mother's house and then gone to work the next day, and the bodies wouldn't have been found for days.
Right. That too. So
And
it's just, I'm not buying it. I'm not buying the theory of the case. Not that they're really presenting it well. The whole financial motive doesn't really make sense. The check that he was confronted with that day wasn't the first time he was confronted with the check. His father going to the hospital, they had moved on to other topics because of course they did. They're compassionate. That buys him another 2 weeks. The hearing that he was going to have that week on the boat case, that's going to be continued. Everything's going to be continued. It buys him 2 weeks. No problem. If he was, if he thought, oh, I'd get more time, more sympathy. People aren't going to come after me on these issues when I'm dealing with this stuff. So his impetus to, I need to commit this murder right now. And then he somehow plans this quasi-perfect murder, executes this quasi-perfect murder. He has a 17-minute time frame before he goes over to his mom. He's there for some length of time, comes back, we
have to simultaneously believe that he plans effectively the perfect crime.
Yep.
Executes it flawlessly, except Sled cracks the case, and they've been shown to be wildly incompetent in all of their investigation, but they still managed to get it. So then you have to ask, well, how competently perfect, like how expertly planned was the murder? And where's any evidence of the planning? Like it seems like it'd be difficult to plan this type of murder with with no involvement from anyone else at all
Yep.
in any way, because there's
Yep.
there's a lot of moving parts here. There are people that come to this property all the time. They're friends. He's got an ongoing investigation into the boat stuff. And if he if as they allege that this is threatening to expose the financial crimes, he has to know he's under investigation then in general. So you'd think there'd be some level of higher scrutiny around just his person. To me, it just all feels weird. Again, there maybe is a theory of this murder that fits him in. The one that is loosely presented doesn't seem to be it to me.
Yeah, and if you listen to the state's opening again, I mean, the state wraps up their opening by urging the jury to, just use your common sense. What does this feel like to you? And so it's really, they're arguing a preponderance standard. They're right. It says, because that's how most of us make decisions, right? Do I want to go out to lunch? Do I want to eat in? What do I want to do? How do I feel about this? It's a preponderance standard we apply in normal life, and that's basically what the state was urging on the jury in different words.
Right now, to me, a much more, if you want to get Alec for this, it makes much more sense if he hired someone to kill them.
Yep.
And then he has his alibi that he's developing. His alibi makes sense if there's a hitman involved. His alibi doesn't make sense for himself, but it makes a ton of sense if he hired someone to come in with one of those like little fan boats, come in on the canal, drive right up to the property, plop, plop, kills Paul. Oh shit, there's Maggie, blah, blah, blam, takes the guns, takes his own gun, the shotgun he brought, takes the 300 blackout rifle that he had to improvise with, gets back on the fan boat, ditches those out in the waters somewhere, in the middle of a, lake or stream or river. I don't know. Or just takes them and throws them in Virginia. Who cares? Like what happens to it after that?
Yeah, it's good. Yeah.
And then Alex leaves, like he knows, okay, hitman's going to come around this time. I'll drive my truck out and I'll send some text messages and everything will be perfectly fine. That makes sense to me. That theory would be great. The problem is, they can't put that case together because they'd have to have some evidence that he talked to someone else, and they got nothing on that. So now it looks to me like they're trying to ham fist in, he must have done it. And I bet the state even thinks that someone else killed him, even if they think Alex is the reason that someone did. But I don't know.
Sure.
It's a mess to me. Yeah. I don't know.
I wish I had something more meaningful to say, but there's not been a lot to intelligently comment on.
Pretty
which is
brutal
all the reasons it's been
execution
so difficult on my channel is I just stare nakedly at the chat well, guess we're here now. So
Yeah. Locals chat's been keeping me entertained with memes at least, which helps. But it's like, yeah, the testimony it's just not useful. Rumor has it Eddie might testify and say Alex asked him to kill Paul and Maggie. Eddie the drug dealer who Alec hired to kill him. I mean, he's going to have credibility issues. And then what's his motivation? Did they offer him a deal to do that? I mean, because they'll bring that out in front of the jury in a heartbeat. Oh, wait. So
talks about that in their opening. They say, hey, you're going to hear from a lot of witnesses that, the state's made promises to, that they're getting benefits from.
Yeah. I mean, bringing in that guy is not going to be, well, I mean, it could be helpful. I don't know. But it looks like, I mean, the state, Steve Gosney said it last week a couple times, and I think it's right. The state looks to just be piling on as much evidence as possible and hoping that the jury just goes, well, I mean, there's all of this stuff. It must mean he murdered them. It must mean it. Tilly T says, hello, chaps. If you had to work this case, would you rather be on prosecution or defense? Well, I'd normally say defense because they get paid more. But in this case, I'm kind of curious how they're getting paid. Where's the money coming from? Because these guys seem like pretty expensive lawyers. But I don't know. Maybe Harpootlian's doing it pro bono. He's a state rep.
Doubtful. I doubt it.
It's a lot of work.
It's a ton. So who knows? I mean, a week of trial. How many lawyers did they have? They've at least four attorneys doing the examination, cross-examination for the defense.
Mm-hmm.
Again, even if you lowball it at $500 an hour, you're talking $2,000 an hour, 8-hour days.
For a year-long trial.
And a lot of them are, well, some of them are working on the financial trial as well, I believe. So, yeah, what a mess. What a mess. I'm going to start reading some of the other chats. Oh, I should say, while you're all here, this show is sponsored by my Las Vegas live show, February 26th in Las Vegas. Sold the 100th ticket today. So there's
100 people that want to meet you.
At least 100 people. Hopefully there's some more. But it is going to happen on February 26th in Las Vegas. And again, should be locking down the venue on that any day now. I've got a couple, I've got one I can say yes to, but I'm trying to just make sure it's the right one for the event. So we're working on that. But that is available. It's a pinned comment on the YouTube chat section. It's also in the YouTube and Rumble descriptions. You can go if you're going to be or want to be in Vegas on February 26th. Go grab a ticket, grab a second ticket and bring a hooker with you or whatever. It's Vegas, baby. Do whatever you want. And then come on out. It'll be a lot of fun. It's going to be a comedy show. There's going to be a whole bunch of people there. Camelot 331, Dick Masterson's going to be there. Andrew Bronca's going to be there. Nate the Lawyer, Eric Hunley, Mark Gruber, I think. Let's see. Viva and Barnes were going to be there. They moved their event, so I have to re-verify if they're going to be there. But Danny on Direct is going to be there. Shit. I keep forgetting all the people that have said they're coming, but it's quite a few. The lead attorney is going to be there as well. I don't think Drex is coming. He said he seemed to indicate he's not going to be able to make it, but it's going to be a blast. There's going to be a comedy show. Yes, Lady Rackets, of course, the one person I like to see the most is going to be there as well. It'll be a fun time. So come on out. I'm going to try and convince Ari Jacobs to come out as well. She's in that area, so it should be good times.
Yeah, I had mentioned to people that if they bring any of my books, I'll be happy to sign them. It's not a book signing, folks. I'm not sitting up a table and sitting at a table signing books. And I'm not going to sign anything outside the venue. So if you want a book signed, you got to pony up to $50 to get inside.
And that price, I know people are like $50. Believe me, it's impossible. I'm way undercharging for the venue. We'll put it that way. At the $50 amount, it's just to defray some of the cost of the venue. I'm not looking to make money on this. I'm going to probably lose thousands of dollars doing the show, but I want to go out and meet people, and Vegas seems like a really fun place to do it. So that's the whole purpose. And if you bring stuff you want me to sign, of course I will sign it as well. I don't charge for autographs or anything. I might bring a little bit of merch, but it's mostly going to be, it's not intended for any of that stuff. It's literally just come out, meet people, have some drinks, have some fun. That's the purpose of all of it. So come on down. Will the event be late and or gay? Yes. What happens in Vegas stays in Vegas. So you'll maybe waddling the next day, but you don't have to tell anyone why. All right. So thank you for that. Let me read some of these chats that have come in. The Uncovered Lamp says, something occurred to me over the weekend. Imagine trying to follow this case as a juror when you can't take notes. I don't know if I could vote to convict just based on that. That'd be tough, man. That's a tough gig. The jurors have it really rough. They don't have anything to kind of keep themselves occupied at all. Like they don't.
I don't believe they're capturing anything. They're just on hold until they get closing arguments. That's it.
Pretty much. Let's see. MeFlower66 says, I was my mom's caregiver for 4 years before she died of Alzheimer's. To suggest there was no need to visit her because she wouldn't know is ludicrous. Mental stimuli and social interaction is important. Yeah, man. My grandmother had Alzheimer's for several years and eventually was admitted into a nursing home. And I talked to her on the phone from time to time, and it was very disjointed and messy. When I saw her in person, you could just see the difference in her face because she didn't really, like, she she had trouble remembering that I had kids and how old they were and all that stuff. She loved having them there, though. She would just smile at them the whole time they were playing, especially because I think one of my kids really looks like I did. Very like when I say really looks like me, I mean like the exact mirror image of me as a kid. And so that was something that she got to really enjoy. But while I was there, it's a completely different thing. She loved having that physical presence there, no matter what. And she probably liked seeing me because I look exactly like my dad. So, it's like for her, even if her memories are stuck in the past, she may not have known it was me. She might have thought it was my dad or whatever, but that doesn't matter. That physical presence was something that was comforting to her either way. So no, I fully agree. Again, it doesn't mean this guy didn't kill his wife and kid either, just because there's some, he has plausible reasons for doing what he did. But the problem is the state has to show why these are not just normal activities. Your dad gets moved to a hospital from his home because he's sick. You go visit your mom with Alzheimer's at a time that you don't normally do it. Okay. Does that mean he murdered someone? No. Could he have still murdered them? Sure. But the state's job is to prove beyond a reasonable doubt that what he did.
I have many reasonable doubts.
Yeah. And
at this
that's a problem. Richard Stuplick says, is there a way for the defense to get into evidence if Alex knew about PIs following and recording him and his family? As a juror, I'd really find that informative and useful if he would commit this crime. I mean, I don't know if they're going to get in that he knew or not. I guess if he takes the stand, which he may now. We had talked about him not taking the stand before, because if he takes the stand, kind of all this financial stuff gets opened up potentially. But now all the financial stuff's coming in, and the reasons for him to not take the stand are less and less. And the reasons for him taking the stand are more and more.
But if he takes the stand and the financial stuff would come in for that reason, it moots the judge's decision with respect to the error. So assuming the judge did make a legal error, in allowing the financial stuff in, if he takes the stand and that opens the door, that's now an independent reason to bring it in. And now the Court of Appeals can't do just shit about it.
But it would come in before he takes the stand. So how would it
matter either way? It doesn't matter either way. If him through his testimony would allow to bring in, it basically is like, well, he opened the door, so it would have come in regardless, right? It just would have come in at some later stage.
Well, I don't know, because he may not have mentioned it in his testimony, but for the fact the evidence was already in front of the jury.
Right, you'd make
selling that to the Court of Appeals is what I'm saying.
You'd have to make the argument that it was rebuttal testimony to rehabilitate after what the state did on the financial crimes.
Good luck.
But it's tough. Blue Varo says, as a defense attorney, I would ask every single person that came up during that financial portion whether or not they wanted to kill Alex for stealing. No, you don't ask it that way, though. You don't want to say, did you want to kill Alex? You'd want to say you just raised the specter of it because you were angry with him, right? This is a betrayal. I mean, you've known this man for years and you find out he's stealing from you, or you trusted this man with your case, with your life, the loss of your loved one, the loss of your limb, if it's catastrophic injury or whatever. And then he completely screwed you out of it, didn't he? That had to make you mad, didn't it?
I think any of these witnesses, if you poke them a little bit, they'll start expressing anger on the stand. And then you circle back to, surely you weren't happy that he stole your money, right?
Right. I mean, how could you be? How could you even? I'd have a hard time forgiving him. Stuff like questions like that.
Let me sign off for now, and maybe I'll come back a little bit later this afternoon if something interesting happens.
All right, buddy. Talk to you later. Thanks for joining.
Bye-bye.
Peace. All right. So, yeah, it's you can certainly and Andrew, you talked about this earlier, and we had talked about this last week. I still think the better strategy would be if you could have the evidence excluded, all of this evidence. You don't want the financial evidence to come in. It's cumulative. It's highly prejudicial. It makes him look like the dirtbag that he is. And him being a dirtbag doesn't make him a murderer, but it does make him a dirtbag. And the jury just may want to convict him based on that. However, now that it's in, your strategy has to be to utilize every single witness that you can to draw one more person who would be motivated to harm Alex Murdaugh.
Right. I mean, what you definitely would not want is the state to simply say, hey, we just want to admit that he stole $8 million from 100 different people.
Yeah.
If that information is coming in at all, you want to hear from the 100 people, because those are all alternative suspects for committing these crimes.
Right. And that's why it's such a mess to bring this in. And why it'll be so bloating to the trial in general.
I mean, I'm surprised the judge didn't exclude it. You know, he wouldn't say this, but just on that basis, like, I'm not going to turn this trial into a circus. It's already complicated enough and boring enough. He's going to have a separate trial on the financial stuff. I'm just going to exclude it. I'll make up a reason.
He's the judge on the financial stuff too, from what I understand.
So he's going to have to hear it 3 times.
Yep. He's probably going to have to hear this murder case twice when they try and bring that into the financial crime thing. The uncovered lamp. Well, of course, if he gets convicted on this, he may just take a plea out on the financial crimes. I mean, if he's going to go away forever on this, of course, maybe not, because if they think he has any reasonable chance on appeal, then you'd want to take the financial crimes to trial, because even if you lose there, you may be able to appeal that as well. Right. You may have some prospect of getting out rather than pleading. The uncovered lamp says 15 minutes behind watching the judge let it in. See you all in 5 years and this case is over. So prejudicial. The standard for reversible error needs to be lowered.
Well, it's only getting higher. It's not getting lower.
Yeah. Retro 704 says she's about to mention Alex helped her bust up a shifter robe. That was, dude, I cannot believe you did that. I did not believe that. That was good. When did what time was the caretaker game show? Didn't she say that was when Alex is visiting around 8:30? How could he be there for 20 minutes seeing mom and drive 20 minutes while being on video at 8:44? Who knows? They've got more of this witness to cross-examine, so we'll have to see. Yeah, I don't know. She mentioned that thing again, and he prodded on the 15 to 20 minutes thing. She said 20 minutes total on the property. It's like, well, how are you actually timing this? Because I don't know about you guys, but I've watched Game Show Network before, and they will run the same show several times in a row. Or not the same episode, but the same show. Right. You know, you watch like 5 episodes of that catchphrase or whatever in a row. They're going to have catchphrase 2 hours, and you sit there through each freaking episode. So it's very possible that he was there for 40 minutes and she saw the same show and thought it was less. You know, who knows? I don't know. There's a lot of doubt there, but I don't know that her testimony was overly damning, in all honesty. Even if he's only there for 20 minutes, it doesn't mean that he killed him.
She doesn't know. I mean, can't even pin it down to an hour that he was there. 8:39, 9:30 is when he showed up. So if he left at 9:06 when his truck started up and it takes him 20 minutes to get there, it's 9:26. I guess it's just within that window. But there's not clarity here. It's not like he clocked in or clocked out of the house.
Right.
Although they say there's security cameras, so they should have security camera footage that would have timestamps.
They're probably not very convenient. Rebecca Welty says Judge Borowski totally would have said it was boring and he wouldn't listen to any more crap about stealing money. You know, he'd say it just like that. This is terrible. I can't believe you're wasting my time with this. Bring me a reason or get out of my courtroom. Oh my gosh. Oh, Steve. And I will be curious to see what that limiting instruction is on the prior acts evidence. They said that they had a proposed limiting instruction, and the judge said that whenever they requested that, he'd be required to provide that limiting instruction. But it didn't sound like his ruling on it was overly limiting. So I'm not sure what he's going to do there. Dist Opt says, my brother Heath is having open heart surgery at 48 today. Prayers appreciated. He's my best friend, big brother, and protector. Absolutely, Dist. I'll keep him in my prayers, and I was
telling my, I guess this is a bad follow-up to someone asking for prayers in a hospital, but I was telling my wife a story about my best friend in high school, and she was like, oh, you ever keep in touch with him? I was like, no. So she looked him up, and he died last year.
Oh, damn. Ugh. Yeah, I don't know most what happened to many of my friends in high school. My close friends I still keep up with. So, but this is to your brother just stopped. May everything may everything go smoothly, and the doctors' skill and dexterity be well beyond their training and physical abilities, and may the divine hand of protection be upon your brother, man. Cheers. Man, that is really good. Attorney Tom gave me this bottle, Andrew, and it's I've never seen it before. It's this Duncan Taylor, and it's dark like coffee, and it is like drinking smoke, like it, and in the best way. It's like drinking the feeling you get when you smoke a cigar. God, it's good. Let's see. Pinkalo, the driving ape, says the mental fatigue pre and post stream is not fun. Oh yeah. Me too. Yeah, I didn't do anything over the weekend at all. I just crashed out. Slept a lot. Well, I was on Flashcast on Saturday night, which went a lot longer than I thought. But other than that, I didn't do anything Saturday or Sunday other than go to church on Sunday and just sleep afterwards. Mr. Perfect says Rumble stream is behind. I just got a notification. Sean S., what Mustang do you have? I have a 16 GT 6-speed. I just bought in December a 2022 GT 500 Mustang. So looking forward to driving it. Jacoby Davis, do either of you have any plans to cover the Billy Mitchell defamation trial if it happens this year and if it's televised? Yes. I also have plans to bring Carl Jobst back on the show. It's been a long time since I talked to him, and I really like that dude, and definitely want to bring him on to get an update. I haven't been following the Billy Mitchell stuff, but I talked to Billy a couple times back in the day, but I don't know if he talks to me anymore, or if he would talk to me anymore. Travis Schipple says, I make custom steering wheels for cars and trucks. Let me know if I can make one for your Mustang. Facebook is shaped. Cool. Tina Lewis, Tinsley looks kind of like Mel Gibson. Sniffer in Chief says that suit and tie is annoying. Who wears a solid matching tie? He bought his jacket and tie at Walmart. As much as I want to run with that joke, I would imagine it was an expensive suit, no matter how it looked. That guy, I mean, these guys that you're running into, I mean, are personal injury attorneys or representing, some of the biggest cases in the state. So who knows? Gates of Above says, my non-guilty levels are as high as a Chinese balloon floating over the heart of the U.S. territory. Lord Vader, Bronca, from a tactical shooting perspective, I'm struggling to think why anyone with motive would do it at Moselle. Murdaughs were well armed and known to have loose dogs. Not a legal question.
Well, who says the person who did it has any tactical training at all? It could just be an angry brother shows up with a shotgun.
Exactly. Could be. Or it could be a hit. I mean, entirely. Could be someone close to the family too. Who knows? There's this guy that we've kind of dismissed, but the dog trainer that Alec kind of pointed to as being a little bit suspect, maybe having a little bit of a shifty past, violent past, but also being maybe physically capable. He could be the killer. He'd have familiarity with the property, with the dogs, that area. He would know about the guns on the premises, probably, presumably. So there's all sorts of open questions on this one. Clay Wagner, if money is in a trust, is it protected from a lawsuit? Short answer is it depends on the trust and the circumstances entirely. Revocable versus irrevocable trusts, the time that it went into a trust, was it put into the trust in anticipation of litigation? All sorts of stuff like that is in play as to whether or not, if the trust has a clause in and of itself that limits the ability for it to be pursued by creditors. That's another one. Because if you have a trust and you can withdraw money from it at any time, then it's probably not going to be protected from a lawsuit. But if you have an irrevocable trust that pays out on a very specific schedule with a third-party trustee and terms to prevent the access of creditors to this thing, then it makes it much harder to get to. But if you set up that trust on your own in anticipation of the litigation that'll take your money, and you do that within, a year or two of the judgment, you're probably not going to be able to protect it. At that
Anything
point.
set up after the boating accident is going to be extremely vulnerable
Right.
to being pierced. And even the trusts that, shell out money on a periodic basis, like a monthly thing, like trust fund kids get, it's, they may not be able to pierce the trust, but they'll still take the money.
Right.
When it comes out. I mean,
yeah, they can garnish the income from it. Depending on the state, of course. States have different rules for collection, but that's probably not going to be the safest vehicle for it. A much better vehicle would be for an LLC of some sort of corporate entity that would have it, and the corporation pays for everything as an expense to the corporation if you can justify it, something like that. But even that, again, if it's done after the accident, you've got real problems. Speaking of things done after the accident, what's up, Steve?
hey,
How
Steve.
you doing? How's it going? Just coming in. I don't have a lot of time, but
You
what
feeling
did I
better
miss?
today, though?
Oh yeah. No, I felt better last Friday. It was just something I ate. It went through, and I actually took off on Friday just because this case kind of got me entangled in it. That's what happens. I get into it. It's like an interesting case, and I'm like, ooh. But
welcome to being.
Sorry, this stupid phone.
That's okay. Welcome to being entangled. It just got weeks longer. The judge allowed in all of the testimony for prior acts.
Oh, that's abusive. Well, somebody was saying, I was looking, somebody was saying that something about the TARP testimony was discussed. What is the TARP testimony, and what do we know about that at this point?
So there's this blue tarp that the housekeeper of the mom of the defendant, the Alzheimer's mother, she testified that I think it was like 3 days after the funeral for his dad, or for 3 days after the funeral for his wife and son. Dad, whichever one.
The dad.
So 3 days after the funeral for the dad, who died a couple days after the wife and son, that he shows up with this blue tarp. It's like one of those waterproof tarps that you buy at a hardware store.
Time out. Okay, and again, it got to catch me up. I'm sure I missed riveting testimony, but I'm going to ask you this.
Yeah.
Is I thought the tarp was recovered from the parents' house the day of the murders.
Tarp was never recovered, actually. There's a photo of the tarp taken somewhere.
Wait a second. The theory of the state, at least what we can deduce from it, is that he took these guns, wrapped them in some sort of tarp or raincoat or something, took them over to his parents' house, and then later disposed of them, but left the raincoat or tarp. And therefore, when they discover it, it's like, it's got this gunshot residue. Therefore, this is what he used to wrap the guns. All right.
Yeah.
Is that not what we're seeing here?
Apparently the tarp is not recovered.
But how do they test it then? How did they say there's gunshot residue in it?
I don't think they did.
That's what they said in opening, didn't they? They said that they tested it at the inside.
They did recover a blue raincoat, is what they're recovering.
When?
So the state, I don't remember, but the state is arguing it wasn't a tarp, it was a blue raincoat. And the raincoat was what was being used to carry the guns in. They recovered the raincoat. They were able to test it for gunshot residue. It tests positive. The actual caretaker is saying, no, it wasn't a raincoat, it was a tarp. But no tarp was recovered.
But see, here's one of the problems, all right? If they did not go over to the mother's house and execute a warrant on it and search it and find a raincoat or a tarp or anything that night, because see, they didn't search it. So what they did is they let him go. He could then go, I'm sorry, did I bore Ricada?
No, I'll be right. I had to turn my camera off for just a second. I'll be right back.
Okay.
I'm listening.
But the question is, is, okay, so let's assume that they did not search the parents' house, right? He takes the guns over there. He does not dispose of them because that's difficult to do it in the time frames allotted. What he does is he relocates them to the parents' house for later disposal. The cops then don't search the house. He goes back to the parents' house sometime later and destroys the guns or gets rid of the guns. But all that we have remaining is a raincoat or a tarp with gunshot residue. That occasionally is, now, first of all, bad police work for not searching the house immediately, because maybe they could have found the guns wrapped in the tarp at the parents' house, in which case we got a whole different case.
Well, they never knew about the tarp until September.
What does that have to do with anything then? How does the tarp connect into the case?
I think the caretaker told them in September. The caretaker was in a car accident, and she's chatting with the officer who's taking the report for the car accident. And she mentions to him, yeah, Alex came over the night of the killing, and he had a blue tarp with them. That was the first time anybody had ever heard about a tarp, in September. So months later, I assume at that point that officer told others, and they started going through their crime scene photos or whatever evidence they had collected contemporaneously with the event, saw a blue raincoat, not a tarp, but said, well, let's test that. Or they had tested it. It's gone. And now they're trying to, replace what the caretaker says was a tarp with the blue raincoat we covered earlier.
This is what good police work should cover. Because if you've got a guy there at the scene of a crime with a guy with his head blown off with a shotgun, and he's got a shotgun in his hand, and he's the only guy around, you'd say, where were you? I was over at my mom's house. Okay, send some cops over to the mom's house right now to go and search it. I mean,
Of course.
now that was not done. I guess we're saying that wasn't done, in which case,
Well,
anything else is just speculation.
minor counterpoint.
Mhm.
If they had searched that night, allegedly they would not have found the tarp because the tarp came days later. According to the testimony, the tarp would have come a couple days after the father's funeral, and he died a couple days after the shooting. So we're talking about 5-6 days before the tarp even arrives at the parents' house, which
So he
begs the question.
stashes the tarp somewhere else, brings it to the parent. But why would he bring it to the parents' house in any event? Why would you
Exactly.
do that? If it's stashed in the woods, let's say, in some secret location on a $700, and the cops never find it, he then goes back to that stash with his tarp and the guns that he wishes to. Why would you ever take that tarp to mom's house?
Doesn't make sense.
You dump the guns. I mean, then what? He marches it. I mean, it's such a stretch. Oh, and did they search? Okay, and also, is there a tarp and a raincoat, or is the state saying that the tarp is the raincoat that they recovered? What is going on with that?
State says the tarp is the raincoat. Although the state has a picture of the tarp, right? And that picture didn't look like the raincoat like a raincoat to me. It looked like a tarp.
Well, to hell with the state. What did the witness say?
She says tarp, not a raincoat.
Yeah, she says tarp. She said it didn't look like anything was wrapped up in the tarp when he had it. He just had it kind of tucked under his arm. And he took it into the house and presumably, actually, the crazy thing is she can't even testify that the tarp was present in the house. She saw him with the tarp, but she can't testify that it was present in the house because she never saw the tarp in the house, because she doesn't go in closets, and she's only been upstairs twice in that house in her years of employment. So he could have, in theory, brought it upstairs, shoved it in an attic or a closet for a while, taking it out later. Who knows? But
this is all rank speculation.
Yes.
Ugh. So the whole gunshot tarp raincoat thing is a nothing burger. And then we're going to listen to weeks of testimony of financial crimes that have nothing to do with anything.
It should be a nothing burger, Steve. But the question is not whether it is a nothing burger. It's whether the jury will make it out to be a something burger, right? Like, you can go to Burger King and order a burger. It's not any good, but someone likes it.
Good analogy. Lawyers go to law school to learn those kind of analogies.
Can the defense at closing mention how the prosecution extended this trial by weeks for extra testimony? They have to do it in a crafty way. They have
Well,
to.
if they present a lean and mean defense case, and then they can say, they got a bunch of smoke and mirrors over there. They're trying to pile up the evidence, say this stuff is all this guilt. But what you got is a pile of nothing. It's just like when I was a good old boy down in the farm, we had a big pile of hay. and there was a whole bunch of hay, but there were no gold coins in that hay. Come up with some sort of cool little story like that.
But also remember that the jury is not aware that these witnesses were not going to be called and are now being let in. All of this was done outside the presence of the jury. I mean, they can maybe make that inference, but the way you do it is what Steve's saying. Look, they brought everybody in weeks and weeks. You've heard weeks and weeks of testimony. You know what you haven't heard? A single conclusive theory about how Alec Murdaugh possibly killed Paul and Maggie. And we're going to show you all the ways in which he couldn't have done it using the state's own evidence. And that's the sort of strategy there. The other thing you missed, Steve, was the in-camera testimony of an attorney, the attorney representing the family of the Mallory Beach, the boat victim.
Okay. Mm-hmm.
He was one of the most evasive, weaselly testimonies.
PI lawyer, then you're talking, he's a PI lawyer.
Yes. And he testified that he had an order compelling the production of a response to interrogatories that were sent out. Okay.
That was going to disclose all the financial shenanigans of the defendant here. And the defense was shocked, right? They're like, wait, we haven't seen any order from the court that was going to expose all this stuff. And he goes, no, I got it right here.
Pulls it out of his jacket. The order was actually an order saying that the judge was like, if they don't voluntarily comply with the discovery request, we will schedule a hearing on the issue.
Yeah, this is why I don't do civil anymore. It's like 7th amended order compelling production of documents 18 through 85, right?
And it didn't even compel the order of, it didn't compel production of anything. It was a hearing. It was a potential of scheduling a hearing to compel if the order is granted. It was insane. And that he also testified over and over. And this kind of blew my mind. This was funny. He was testifying that he was going to go to trial in 2 months on the boating incident.
So he says.
Right. And they're like, wait, you have like 5 outstanding motions, including this motion to compel production. And he says, but I didn't need any of that to go to trial. I didn't need that motion to compel production. I could have gone to trial without it. I was just filing the motion to compel just to put pressure on him. It wasn't for trial at all. Which was
because
a little
civil trials are so speedy.
Yeah, well, that's funny. Well, so basically more or nothing.
The point of him as a witness was they're trying to say, hey, on that day, June 7th, that morning, the defendant knew that all his schemes were going to be exposed, and that's why he killed his family.
See, this whole theory. This is a state way to get in all the financial stuff that makes him look bad, that he's guilty of sin on. They don't care why. This is a problem. They are not being fidelity. They don't have fidelity to the truth, is from what I'm seeing. What they're doing is they've got all this bad stuff that makes him look bad, and we all know he's guilty. So we're going to back the truck up, right? And we're going to say, okay, now what's the reason we can get this in? And then they create this motive theory out of whole cloth and then try to force the evidence in to make it fit. It's really disingenuous. I'm not a fan of that type of prosecution.
Now, interestingly, that attorney, and I think they have to bring this up on his questioning. When that attorney confronted, the insurance offer for the boat accident was $500,000 paid out, but he didn't believe that Alec didn't have any money. He said he's got way more money. And he testified, he's like, well, how do you know that he's got money? He says, well, when you see that there's 50 civil cases on the docket in Hampton County, and Alec Murdaugh's name is on 50 to 60% of those, you know he's still bringing in money.
No, he was. It's funny, these guys that can spend the kind of money, and here we are, poor schlubs in the public defender's office. We're counting every penny, saying, can we afford our trip to Vegas? It's like, I don't know, dear. Well, I sold 100 books, right? And so, oh, great. Well, let's go. I mean, it's like these guys, they're making millions and they're still blowing their budget. I'm like, gosh, money doesn't solve all your problems.
Well, that's why I heard this lawyer was, I don't know if this is true, but someone in the comment mentioned the lawyer, of course, he wasn't going to settle for $1 million from Alex. I heard he was asking for $50 million collectively from all the defendants. And if there's joint liability, then anybody can be on the hook for the 50 million.
Right.
But keep in mind what this lawyer's payoff would be. It's probably 40% of 50 million, which is, he was looking at a $20 million payday
But now also
for this case. And then he discovers that the deep pockets weren't so deep.
They didn't exist.
Imagine he in his head, he lost $20 million.
Well, but okay, but I got another question, and that is normally that these PI lawyers are going after deep insurance pockets, and so this guy, I'm sure, has insurance, and so he's going after the homeowners insurance and the boat insurance and everything else. No,
Nope.
there's no insurance.
Insurance was $500K. That was the boat policy was $500K, and he said he didn't indicate homeowners insurance would apply. And if you could try to go after both of them, and then you get this, you get a fight between the insurance companies. But if there's existing boat coverage, homeowners, I don't know if that's going to work.
Except that, and this is, it's been a long time since I've done civil. Okay. But my understanding is that the insurance company has a good faith duty to defend and to tender policy limits. And then in order to exceed those policy limits, there has to be bad faith on the part of the insurance company. And so therefore they have a duty to protect Alex from suit and to defend him. So Alex is not paying for his lawyers, number one. And number two is, I'm still a little confused about the theory of liability towards Alex.
I think that's why why the policy is only paying out $500K on the boat policy, because it's his boat, and he allowed his if you allow someone to use your vehicle, you can have liability for the usage of that vehicle, because it's an assumption of the risk for you. I don't remember the specific. Torts are not like not my area of interest.
I used to do civil litigation,
right?
And and the whole game was to get the insurance company to play in bad faith so that you can exceed their policy limits. But if they tender the 500,000, I understand you think it's worth a 50 million, right? But maybe it's worth $1 billion. I mean, your loved one's it's not worth any amount of money as far as I'm concerned. But it does get reduced to this monetary thing. I don't know. I'm just talking.
Yeah. Alex suggested he could maybe cobble together $1 million for settlement
from other clients.
Yeah. Well,
give me a second.
Who knows where he's going to get it, but that's what he says. This guy doesn't believe he's only got $1 million available. So he's pressing on the financial issue. He's hoping for a much higher settlement. And what I think they need to bring in on this is that Alec confronted him, and because he said, "Hey, I thought we were friends. Why are you going after me? I've got this insurance thing." And Tinsley says, "We are friends, Alec, but if you think I won't burn your house down over this, you're wrong."
Yeah, well, that sounds like lawyers.
Yeah, I know, but bring it in front of the jury. Like, this guy's motivated to go after him in a pretty malicious way. And he says it. He says it right out loud. I'm going to burn your house down over this. Well,
he said that on the stand?
Yeah, now, in camera.
He said it in camera, but now you can bring it in front of the jury when he gets questioned.
Again, that lawyer's got $20 million at stake. Are you going to burn someone's house down for $20 million?
I'd burn their house down and buy him a new one.
Would he shoot his son?
That's the question.
See, the thing also is that I'm really, see, lawyers, though, they can sue anybody. And so the dad's liability is that he loaned the boat to the son, and the son was drunk.
Right. Negligent entrustment.
There's a lot of chain there. And
well, but we've got testimony in this case already, though, that his son's an idiot. And he knows his son's an idiot. He leaves boats and guns around all over the place. I mean, negligent entrustment after this trial especially sounds really good on him.
Look how this case is developing. So we have the murder case, which is I thought what we were doing. Now we have this theft cases against the trust. Now we've got the boat accident insurance case. We can just try them all in one case. Just take the whole year off, try everything at once, and then just have a global verdict and solve all the world's problems.
Right. We can go to another layer deeper. We can throw the boat case in here too.
Yeah, we can throw out his marital. We'll put his divorce case in there. It's like, reminds me of Hamlet. Remember when Hamlet puts on the whole play within the play?
Right.
It's like, oh, I'm going to watch the reactions if I put. It's like how many, or looking into an infinity mirror and it goes back. That's what we're doing in this case.
And I expect one of the reasons he was so underinsured is that he already ripped off his umbrella insurance policy over the housekeeper death,
Oh, yeah.
that wrongful death suit where he's basically sued himself, collected 3.8 million, of course, kept the money rather than give it to the housekeeper's kids. But that policy probably said, well, we're not covering you anymore.
Well, yeah.
So it's been an interesting day in that respect, but it's also still been the slow plodding stuff we're used to. And there was no argument, by the way, on the or no follow-up argument after the testimony was offered for the in-camera testimony. Hey, what's up, lady? Yes, you can.
The youngins are cute. I had my son came over last night. I'm so happy. I'm on a cloud.
Yeah, that's my 5-year-old asking if she could have a snack.
Oh.
But yeah, I mean, it's the same sort of plotting thing. Oh yeah. We didn't get any argument following the in-camera testimony, which was, I mean, to me, that was kind of annoying because it's like, you know, oh, the other thing that got let in or will be let in is the testimony around that potentially attorney-client privileged conversation thing that happened. They brought in
wait. Yeah, we forgot all about that.
Yeah.
So did what was done in that little?
They brought in one guy, one of Alex's former law partners who was present that day to basically say they were all in a room talking, right?
What did they say?
I mean, no, we haven't gotten testimony about what was said. We just got testimony that they're all in a room talking. And so presumably to eliminate privilege.
We're having atomic level, justice here. So it's like, okay, step one, it's going to take us a day to do this first step. Ready? Here it comes. One step. Now we can get to the next step. Ready?
Yeah. It's going to be a freaking mess. This thing's going to take forever. Oh my gosh.
Yeah. And I'm just coming in at lunch. I'm back at work. So I just took lunch and I thought I'd say hello to y'all. Thank you and we'll see you at the Las Vegas thing.
Yeah, that sounds great.
We might be covering this trial.
I won't be. I'm getting on a plane.
I was saying earlier, they're going to spend a week doing this financial stuff. I may as well there's no point watching that. I accept that the guy stole a lot of money. So right. I don't need to hear people testify about that.
I'll be here, ladies and gentlemen. I'll be here every day that I'm able to, which excludes Friday of this week and probably a good portion of Tuesday and Wednesday of next week.
Yes. Your invisible friends. Are they in the room with you today? Can you see them right now?
They're not here. They're not here. Steve, don't mention out loud, but read the private chat before you go and get back to me.
Oh, well, you can. What's the problem with that? You can read that out loud.
I know I can read that out loud, but I don't want to.
Okay. That's all I want to talk about.
I want to open a separate conversation with you about that. I'll send you an email.
Hey, Steve, don't forget when you come to Vegas, bring an autographing pen for all the books you'll be signing.
Oh, I sold so many books. We're actually having to reconstruct. Oh, did you see my new website? SteveGosney.com.
Yes, I saw it yesterday, right? I don't know if Nick's seen it.
It's all, you know who did it?
SteveGosney.com. You should pull it up. It looks really clean.
Check it out, man. Farmhand Tom is my hero. I love that guy. He is the coolest guy of ever. He's like my new friend. And he helped me out with this. And he's so amazing. That guy, you think he's some kind of I'm just a farmer down here in Nebraska, but man, this guy's brilliant. Look at what he did.
Here it is. Very cool.
Isn't that cool?
Yeah, you got that. You got a shop here.
Look, Rakate. Oh, we'll go back. Did you see your quote in there? You're up top, man.
Oh, there we are. Woo!
You made it, Nick. You made it.
Yeah. You made it now.
Okay, to the chat, before they think there's something weird, I just asked Steve if he likes Rob Zombie and Alice Cooper. That's all I asked. So you can answer the question, Steve. Answer the question,
that's
Steve.
Not what you really asked now. You were asking sex stuff. Now, come on.
Steve, do you like Alice Cooper and Rob Zombie? Do you like them?
Yeah, it's okay. It's like Ted Nugent. That's okay. But I don't listen to him. I don't it's not a go-to thing. I like much more extreme music.
So, Steve, the real question is, when did you stop being racist?
Yeah, right. Well, the Rob Zombie, is he of Parlor? But it's what I missed that.
Parlor?
Rob Zombie? From White Zombie? Do you not know?
Yeah, Rob Zombie. He's got John 5 as his guitar player, right?
I have no idea who his guitar player
Oh,
is.
come on, you're bringing up. Why are you asking this? I want to know.
That's what I said. I'm opening up a conversation for you. I'll tell you about it later.
All right. Well, no, we're going to go see Daytona, man. There's going to be Tool and Alter Bridge. I'll stuff the alternator. We're going to write out Alter Bridge and Pantera. And oh, man, it's going to be awesome.
I went to a show. It was Pantera and Slipknot.
Okay. Yeah.
Where Pantera was the headliner. Slipknot was right below them. I can't remember who was before that. I think Drowning Pool was there too before that guy died.
Very cool.
That was a good show.
Well, let me think. What else are we going to talk about? Yeah, so Las Vegas, definitely going to be there. Oh, so I'm trying to rework it. So I got this whole new back end that's going to, what we've been having to do is label each envelope and then write it out and then take each one down. And we sit in line for like 2 hours as they stamp each one in. And it's ridiculous. And Bronca's laughing because he's got the trucks backed up and the whole back end.
Hey, I've been there, man. We did it. We've been doing it for a long time.
So
running off to the post office with cardboard boxes full of books.
So Tom was great, man. He sat down and he trained us how to do this. And it's going to basically print out a label. At least this is going to be good. And the next book, man, I am busting my hump on my next book. Right?
You heard it here, guys. Steve Gosney's got a whole new back end and he's busting his hump right now. My goodness, the videos that are going to come out of this are fire.
Well, anyways, yeah, so the next book, I'm about 85% there, and I'm just hammering as hard as I can to get it done because it's really the book that I first did was Bronca. Bronca's like, and you were completely right. I'm going to go ahead and say I've been disagreeing with him a lot lately, so I'm going to go ahead and give him lots of schmooze. You were exactly right because I kept telling him what I was doing. I was telling him about what I wanted to write. And it's like, okay, that's great. But you need to get those pipes cleared. You've got all this stuff you've written, put it together in a coherent legal book so that you understand how the process works. And then when you write your next book, it's ready to go. And he is so right. And I thank you for that. That is exactly the right way. And so when the next book hits, it's going to be like the next book. The first book is about law. It's really my legal experience. It's everything I can contribute. It's like everything I've done legally, but that's what I do, not who I am. The next book is about who I am. And it's a very in-depth, it's like, I want to share everything I can, all the wisdom that I've accumulated, whatever, as small or as large as it is. If you like me, great. If you don't, toss. But otherwise, it's going to be a book all about how to live your life. It's called Prepare, a Handbook for Individual Freedom. And I can't wait I'm really looking forward to it. We're going to have to do like one of those long streams when it comes out because we know the reasons why, right?
Subtitled, My Years as a Ginger Groupie.
Anyways, I will leave it at that. And I do have to go in about 5 minutes.
Sure. And if you want to come back at any time, just feel free to pop in.
And what if I don't?
You don't have to.
Okay. Yes. Thank you. Let me see. Yeah. So I took all the books to the post office today and it's like, I've got to deal with that. Oh, gosh, I can't wait to get this back in. Farmhand Tom, has he been around lately? Have you seen him around?
I haven't specifically seen him around, but I don't know. I watched 3 chats at once. So I miss a lot of stuff. But no, I talked to him by email a little while back, but it's been a minute. I hope he's doing well. He's a cool dude.
He is a super cool, smart guy. I just love that guy. But enough about him. But we will we'll see you in Vegas, and the wife and I are going to be there, and we'll hopefully. I'm not going to bring any books to sign. If you want to bring a book, like Andrew says, if you want to bring, I'll sign whatever you want to sign, and I'll sign it if you want. I'll sign it anywhere. I don't care.
I'll sign Andrew's book. I'll sign Steve's book. I'll sign whatever book you want.
Did you get my idea about the silent auction?
I did.
You should do that.
Well, I'm thinking about it.
Like a poster and have all the people sign it and then auction it off. That'd be big bucks,
Got to cover that venue expense.
Exactly. Just put a table on there, silent auction, have 4 or 5 of them,
I can't imagine how much this must be costing. I mean, there are hotel suites that probably cost $5,000 a night in Vegas. it's
We have friends out there. We're staying with friends, so that's actually it's why the wife was like, "Oh, we can go see my friends." I'm like, "Sure."
Sign my copy of Mein Kampf. Oh no! I said I'd sign anything. Dang it!
Technicalities.
Oh, they're gonna lawyer me on the terms.
All right, I gotta go. I'll see you guys later, man. Thank you. Bye, chat. Good to see you. And Nick, as always, I'll send you a draft when it gets close. All right.
Sounds good, buddy.
God
Peace.
bless. Mhm.
Okay, the court should be back. I mean, it should have been back already, right? It was supposed to be 2:15.
I
Or
have to be
2:30.
honest, I wasn't paying attention.
I think it was 2:30. Sovereign Bosman says signing Baldos. I mean, if you bring one, it's up to you. I don't know if you want to sign it. James says, where the hell did all the money he was earning regularly go, let alone all the money he's alleged to have stolen? I mean, you never know, man. But it sounds like a family that bought literally whatever they wanted at any given time. Just dump the money somewhere. Or he's got it all sheltered somewhere that they haven't discovered. That's possible. Theoretically. I don't know.
I mean, I guess there could be some kind of generational wealth, right? I mean, his dad, his grandfather, his great grandfather, they were all rich. Where'd all that money go?
That was the perspective of that attorney. He said, the people around here think it's generational wealth, which it could be. It could be. And who knows? Maybe he just bought a bunch of NFTs. Have you seen those Bored Ape NFTs?
I barely know what NFTs are, but no.
I was checking on it because that NFT market was like really big for a while and people were spending like millions of dollars on these damn things. And I was like, oh, that's kind of fallen off, which is true for a lot of stuff. But the Bored Ape ones are like they're like one of the more popular ones. It's just a stupid monkey that looks like this.
Okay.
With like any variation of hat or like a cigarette or whatever in its mouth. The most recent one sold are selling for $480,000.
Oh yeah, okay, I see them here. I do recognize the ape.
Yeah, I mean, I've seen
as a meme.
Like venues and shit buy those now for themselves. Like, oh, that's my Bored Ape thing, but they're still selling for those almost $500,000 for an image. It's crazy. I don't like it.
I did read the filing. Was it Attorney Tom? Is Attorney Tom part of this click? I thought I saw him in,
on the Logan Paul stuff.
Yeah. So I did read his filing on that. That that looks sketchy as F. I hope he cleans other people out.
Yeah, he's going after the Paul brothers both. I think both in arbitration and in the court as a class action. So
right.
It's gonna be a mess for them. And man, I'm just glad I didn't sell any crypto shit. Like, because one thing you get offers for a lot of as a creator, even the smaller creators, you get brought offers like, oh, do our crypto thing, and they were offering to pay a lot, and I was like, I don't know shit about this. I don't know. I've never heard of this coin. I don't know anything, and I bet a lot of streamers got kind of suckered into selling absolute trash. But the other problem is they would give them a bunch of crypto and then have them pump it. And so you give a guy with 30 million subscribers 10,000 crypto coins or whatever of whatever, even if the value is really low, and then encourage him to sell it. And if they don't disclose that financial relationship and they don't follow the financial disclosures that you would in, say, the same thing with a gift of stock, like if Pfizer gives you 10,000 shares of Pfizer and is like, oh yeah, by the way, talk this up to your 30 million fans, they go out and buy it and the stock goes up $100 a share, you just made $1 million, right? That's illegal if you don't disclose everything and wait a certain amount of days. People doing this with crypto, I know there were some of these idiots got hit with that stuff. And now that's coming back to them, because if they talked it up and artificially inflated the value after receiving stuff without disclosure, they could be in a lot of trouble. I don't even know if that's the basis of Attorney Tom's lawsuit, but
just the original solicitation. Yeah, he mentions that in his class action filing, but just the original solicitation. You have a big enough audience, you can tell people, hey, everyone, send me $100 each and we'll do something for you. And you're just collecting the money and not doing anything for them. Now you end up stealing millions and millions of dollars from people, and you ought to be held accountable. It was just theft, is all it was. Appears to this layman's eyes.
Let's see. You should talk to CoffeeZilla about the offers you have received to shill crypto stuff. He covers a lot of the rug pulls and pump and dump stuff. I don't know where they are. Like, I just delete the emails and say fuck off. I don't care. I don't like to sell things to people that I can't understand, at least. And I am notoriously crypto boomer. So I'm not, trying to do any of that. What do you want? You need something? What do you need? Yes. Okay. My oldest daughter was like lurking in the other room like this. And I'm like, what? It's like, just come in. But there's no laws. So B-Man says there's no specific laws about cryptocurrencies or NFTs concerning pump and dumps. Might be other fraud laws that you're talking about, though. I'm not a lawyer. Yeah, there's a difference between SEC or FINRA regulations and stuff like that. But as far as, again, if you induce people to buy into something that is of no value, to inflate the value, and then you do dump it, you have civil liability, whether or not there's criminal liability. I mean, that doesn't need a specific type of security to apply. That could just be for anything on earth.
Now, you're assuming a fiduciary duty to these people. You're taking all this money from them. You've made these promises to. You've made promises to them.
Mm-hmm.
It can't just be a scam.
Right. Okay. Mary Capola says, so if he's not broke, how are they claiming the murders are about his finances? Again, and the defense will likely hit this in closing. If they're not already planning this in closing, I'd be shocked. But for them to say, you've heard from the state that this man is broke and has no money, and that's a motivation for murder. You've heard from the state that this man has all kinds of money coming in and that his family's continued existence is a threat to that money coming in, and that's a motivation for murder. The state can't tell you which one is true because the state can't tell you how or why Alex Murdaugh murdered his family. In fact, the state has no theory that matches any of the evidence presented here. They're just hoping you forgot that. Some sort of line like that, some sort of language like that around just the disconnect between what the state's theory seems to be and the multiple different angles of testimony that are coming in on all of it. Let's see. I
mean, of course, it's just an internal conflict for this lawyer to say, no, I didn't believe he was broke because he has this tremendous money-making potential that I see on the docket every time I go into court. Well, then he doesn't have an incentive. Then this is not the end of times for him. Then he can just work his way out of these problems.
Right. Atlas Knife and Tool, welcome to Paralegal Status. Corn Pop, thank you for the sticker. 200 Watt Studio says, bottom line, if you need a good lawyer, stay out of this entire town. Lol, this entire town is populated with corrupt lawyers. That Tinsley guy, he seemed like a slimy dude up on the stand. And that was during direct. He seemed worse during cross. Corn Pop sent another sticker. Coney Upstate says, if Alec is found innocent of all charges in all cases, would you consider inviting him to work at your law office? Nope. Not a chance. His reputation is trashed forever. Because here's the thing. Even if Alec gets off of the financial crimes, which at this point, I don't think there's any way he does based on just what we've seen in this trial. But let's say he gets off. At the bottom, at the very minimum, he was taking money without authorization, and his justification is he would pay it back when they approached him about it in the future. I mean, that's shady shit to do to your law partners and your law practice. Because what if you die tomorrow and you don't have that money coming in? I mean, right. Then they're just out. So no, of course you wouldn't have this guy work in your law firm. Even if they could somehow make the case that it wasn't illegal and would just be a civil matter. I mean, he's still terrible.
I mean, what do you do? What do you do if you're the partners and you discover this? Do you really burn the guy? You really get him disbarred? or you say, listen, MFer, we see you stole a bunch of money from us. We want it back. You're working for us until all this is paid back with interest. Don't take his law license away. Then he can't make any money. Then you're out.
Right. And if you
But,
burn him, you burn the reputation of your own firm. That's the other problem you've got is your firm gets in the news when that happens. And eventually that is what happened. And they had to collapse the whole thing and start over.
Right. Once it's publicly exposed, then you got to let the guy go.
Right. Let's see. Corn Pop sent a burger sticker. Yum. Roro Mad says murder suicide, but he chickened out is my theory. I mean, maybe, but there's no evidence of that.
Right?
The suicide attempt comes 6 months later after a whole bunch of stuff that wasn't out comes out. And that's the hard thing about this case again is we know everything that happens after the murders. And it's easy to think that all of that stuff is either contemporaneous or prior to the murders, or is there some knowledge? But if this guy is as narcissistic as he is to try this stuff in the first place, there's every reason to believe that he thought he would get away with all of this stuff in the long run. So it's until this stuff is actually exposed and he's actually facing down the barrel of the judicial gun, you can't just presume that he thought, well, I guess they all caught me now. Mandy Karavichus says one of the guys at work was watching an Attorney Tom video on his phone. I asked him if he knows Rekieta Law, and he said, nah. So I showed him your channel. I'm out in the real world making you new subscribers, Nick. Thanks, Mandy. You're such a bro. Let's see. Torgo the White says, Runkle isn't foreign. He resides in America's hat. JV Flotsam. iPhones have accelerometers in association with the gyroscopes that indicate direction. You should be able to see if there's a corresponding Z drop with the phone toss theory. Ships are dope fig. Okay. All right. Ships are dope. There's my only war. There's only war says somebody get this judge a 5-hour energy or something. Oh God, oh man. I don't even know. I don't even have a joke for how slow he talks. It's terrible. Steve was originally talking about how he liked the judge, kind of old school or whatever. And the more and more I have the sit in front of the watching this judge, the more and more I hate it. Honestly,
it's like dating.
Please expand on this thought. I want to laugh more.
Derail the whole show.
Martin Eicher says they should tape the testimonies when the jury is out and play it back at 2x speed. This is painful enough without the testimonies involved. Esme07, Nick, your commentary and guests are the only reasons I watch live and put myself through the torture of a trial. Thank you for your entertainment. Well, you're welcome for putting yourself through torture on my behalf. Jonathan says, would bringing up the financial stuff in this trial help the prosecution in the other trial? They would be able to test their case, so to speak, see weaknesses, flaws, where the defense is strong, etc. Yeah. And anything he says in this trial in his defense for the murder can be brought into the financial crimes. And if you think about it, there could be plenty of motivation to make various admissions or statements in the financial crimes to clear yourself of murder ordinarily or even accidentally. And now all of that is on the table. Anything that he says about it could be, well, will be used against him in the upcoming financial crimes trial. So absolutely. Funeral Man 04 says, I'm sick and haven't been watching. Can you give a brief update for today? Anything interesting?
Plus, these are all these financial people testifying. It's like free depositions.
Yeah.
For the financial trial.
Right. And second depositions and possibilities for perjury, and possibilities for, shoring up things that they might have missed if they've done depositions, strategizing for further questions to ask in deposition if they haven't. I mean, and that trial could be years away. I mean, 100 financial crimes of the magnitude that they're talking about. And he's going to be incarcerated, likely, because if he's found guilty here, he's going to be in custody. So there's no flight risk or anything, or like spoilage of the assets or anything like that. all of that, they'll just have almost unlimited time to build the case until the statute of limitations. So they'll have years. Ryan Baudouin says, how the fuck is this testimony relevant at all? This jury is so checked out. Why do we care if there's a TV in the room or the chair she sits in? Don't know. Next we've got Mark Freeman. If they find evidence it was a hit job, could Murdaugh be tried for conspiracy to commit murder, or would double jeopardy prevent that? If they find evidence during the trial, they could, I think at this point they could move to add it if something came up, maybe. But if he's acquitted on this, let's say he's acquitted because it was a hit job and they charged him with the wrong crime, he's likely out. Like, he's likely free forever from double jeopardy considerations. So they had the opportunity to bring that case and they didn't.
Please be seated.
Nathan Levy says, I know it's not a 20, but I know you're a man of faith. I just drove by an accident. Car boned a motorcyclist. They're doing chest compressions on the rider. Prayers out. Absolutely. Absolutely.
Council may recall from during jury selection, Juror 957 expressed a concern about being here if the trial goes too long.
Oh, no.
3 weeks.
We're going to lose an alternate.
So he's brought that to my attention, and he's 729, juror 729. So he's brought that to my attention, and he's pondering the issue. So
He's pondering the issue. I know what I'd be pondering.
Bring you all
How the
up to
fuck
date
do I get out of this?
ready for the jury?
You want your $15 a day or whatever it is?
I just want to raise one issue.
All right.
It doesn't relate to this witness, but the next group of witnesses the state intends to call relate to this blue rain jacket, and that it was seized.
That's the
because
courtroom,
of a
folks.
search at Ms. Libby Randolph's Murdaugh's house, and it was found in the closet. Based on what this witness had previously shared with law enforcement. There's no evidence that we've been provided in discovery that connects the defendant with this blue rain jacket. And so we'd move to exclude any evidence.
They're going to
of the
lose
blue rain
this
jacket
motion.
Unless they can represent to the court that they have any witness who connects the blue rain jacket with this defendant, Alex Murdaugh. Thank you.
All right. A mistake?
It's a blue vinyl item.
Your Honor, she has identified a vinyl blue in that closet, which she says was consistent with what she saw Alex Murdaugh coming into her house with. She said, yeah, that looks like it. There's some questions that were asked by the defense, which I'm going to ask her about now. When she is asked about a shirt or something else, but she, I believe, has testified, yeah, that is consistent with the color and the vinyl that I saw that's in the closet.
Yeah, he's going to let this in.
All right. Well, let's bring the jury.
Nice ruling, Judge. There, guys, he was going to let that in no matter what. I mean, to me, that was kind of a softball effort by the defense because they know that's coming in. Now, if they had recovered a tarp and a raincoat, maybe they got an argument. But without recovering the tarp, they'd say, yeah, she was mistaken about what it was. I don't think there was any way that was going to stay out, personally. Oh, my goodness. I think Lady Raggeds is like, she's got to run all over town today. I think she's bringing me a sandwich. I'm so freaking excited. Uncivil, what's happening now? They're bringing the jury back in.
All right,
They just
thank you.
moved to exclude
You may proceed, Mr.
the
Meadows.
tarp that they're going to ask about later. And the judge is going to ignore that exclusion request.
Smith, do you remember being interviewed by Patrick McDavid and Robert Purcell that worked with Mr. Harpootlian and Mr. Griffin in October 20th of 2022?
Yes,
And I believe Mr. Griffin had asked you about some shoes in response to our questions. Do you remember telling them that he had, these investigators, he had on some cloth-like shoes?
yes,
And I believe Mr. Griffin asked you about the length of time you were there. Do you remember these investigators asking you about the length of time that Mr. Murdaugh was at Alameda the night of June 7th?
yes,
Your Honor, he's offering a prior consistent statement, and no one's in, I don't know why, not impeaching her with it. You can't bolster her testimony with prior consistent statement.
Mr. Metters?
I believe he had questioned the 30 or 40 minutes and was questioning whether or not Alex asked her to say that. Through their investigators, it's clarified for me their conversations that directly contradict what she said early on direct that I have through their questioning and interviews, which I just got a little while ago.
All right, Mr. Griffin?
Again, he's offering a prior consistent statement, and it's not admissible unless it's being offered to rebut a claim of recent fabrication, and that's not the situation we have here.
The entire statement right now.
The objection to the statement being entered into evidence.
Yes.
Yes, Your Honor, it's not a statement. There's a whole 30-minute audio recording. Yes.
All right. Rule 613B addresses this issue, and you may proceed. The objection is overruled.
Mr. Griffin asked you the length of time that Mr. Murdaugh was there when these investigators questioned you in October of 2022. Do you remember them asking you about how long he was in the kitchen and in the room with Miss Murdaugh?
yes,
These must be the defense investigators.
And do you remember them asking you about, and he asked you on
From that 30-minute statement.
cross, whether it was unusual, whether Mr. Murdaugh had visited that time of night? Do you remember that?
yes,
And do you remember telling the investigators that he would not come on your shift after 8 o'clock? Do you remember that?
yes,
And that was unusual?
yes,
And do you remember one of them questioning you, you actually registered it in your mind that this is unusual for him to be here that time of night? Do you remember that?
yes,
And do the
Was
overruled
your answer
drinking
yeah?
game and
Because I
die.
was like, yeah, to be honest, I was like, oh, why are you here this time of night? Why are you here this time of night, you know? Because we all going to bed?
it's my mind.
He-
Yes,
He's going to object and just sat down. Like, screw it. Judge is going to let it in anyway.
This is the caretaker of the mom with Alzheimer's.
And as far as the length of time, do you remember them asking you how long? And you said it was about 20 minutes?
yes,
You know, and I'm trying to speed this up. May the court's indulgence. Do you remember, when Mr. Griffin asked you about your recollection as to what Mr. Murdaugh said asked you about the 30 to 40-minute period? Do you remember that? Remember just a little while ago when he was asking you about that? I'm not trying to be, just a little while ago.
Yes,
You're not trying to be what? Sneaky, snaky, lawyerly?
About whether if anybody ever asked you if I was here or not.
yes,
And do you remember that his investigators asked you if SLED had put that in your mind?
no,
Is that the recollection or something they put in your mind?
He's leading the witness. He's publishing a document that is not a certified transcript of anything. Object.
He's
Mr.
flashing her recollection.
I sustain the objection.
Oh, wow.
Wow, what happened?
Did Alex Murdaugh
Tony
ask you to tell
Sabatini came off
somebody how long he'd
sustained.
been there?
he said someone asked you, I mean, 30 to 40 minutes, that's what he said.
He said if somebody asked you.
Yes,
Just repeating her answer.
Mr. Metters?
Is that the answer you gave his investigators
yes,
back in October of 2020?
yes,
The defense is super unhappy.
Yep. Problem is, I mean, her testimony is now inconsistent. She didn't say that before, but now that she's being shown her interview with them, she may have said that in her interview with them, but she didn't say that here on the stand. Which one, like, what is it now? And that's going to be, recross is going to probably turn real nasty on this chick.
Now, Mr. Griffin asked you about this blue tarp. Did his or Mr. Harpen's investigators ask you about that when they met with you?
yes,
Did they bring something with them? Do you remember them showing you something?
no, a picture,
Okay. Did they also show you a tarp?
yes,
Did they tell you they just got it from Kmart?
yes,
Just bought it from Kmart? And I can't hear you. So their investigators brought this with you to the interview
yes,
and showed you this, correct?
yes,
How do you know that's the
Had
same
you
tarp?
already described well, who'd you first tell that there was something that the defendant may have been holding in his hand? Who'd you tell first? When he came in that morning after the funeral, who did you tell that first to in law enforcement? That the defendant may have been holding something or was holding something when he came in?
Dango, Officer Dango.
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 Okay. And as a
Maybe the
result of
Dango
that,
ate your baby.
Slade came and interviewed you.
Yes,
Okay. And then you told them what your testimony's been.
yes,
correct? So in October 22nd, when their investigators came, they were asking you about what you talked about to Dango, right?
yes,
Okay. And they showed you this, right?
yes,
And did they also ask you about if you've seen a shirt? Do you remember when they asked you if you'd seen a blue shirt?
yes.
What was a blue shirt?
It's a blue,
Well, I don't know. What was it? Just like a dress shirt or a shirt? What was it?
like a rain jacket or something, like a pullover.
Okay.
Something.
But they described it as a shirt?
No, not as I can recall.
Wait, so why did you say they asked you about a shirt if they didn't describe it as a shirt? Very confused.
No, this is a
Do you
prosecutor.
remember them asking you, you're positive it wasn't a shirt?
Yes,
They
Yes.
asked you that.
yes,
And your answer was it's vinyl. It was a vinyl, right?
yes, yes.
Don't lead the witness.
and Mr. Griffin was asking you about the vinyl, whatever. Do you remember them asking you if there could have been a gun in it, his investigators?
I can't recall, I can't remember.
Last question, Judge. Can I have that picture? States 411, Ms. Shelley. You've identified this previously. Does that look like the blue vinyl garment he was carrying in?
Yes,
Say that again.
yes,
Was it all crumbled up in his arms?
it was balled up, yes. balled
Was
up.
it folded out?
No, it wasn't.
Was he wearing it?
No, he wasn't.
That's all. Thank you.
By the defense.
Ms. Smith, it's clear when you left the next morning, you saw the blue tarp laid out on Ms. Libby's retirement rocking chair, correct?
Yes,
And it was not a rain jacket, was it?
no, it wasn't.
It was a blue tarp, like what's in here is in evidence 86, right?
Yes,
No doubt in your mind.
no doubt.
Now, our investigators, let me ask you, marked for identification exhibit 87, did they show you a picture of this rain jacket?
Yes,
Had you ever, and you told them you never seen that rain jacket, right?
correct.
You know, I would introduce exhibit 87 in evidence.
Objection.
Can I put it up here? Well, while they're working on that, Ms. Smith, did anyone speak to you over lunch about your testimony?
No,
Did you talk to any SLED agents or anybody at the AG's office?
no,
Trying to get that going.
What was that? It sounded like a cow.
Hey, I got my Ethernet cable wired up.
Today, or did that happen over
I
the
did it
weekend?
Saturday.
Oh,
I did it
okay.
over the weekend.
Nice.
It's
They at least-
blazing fast. It's nice.
Yeah, it's like Wi-Fi is always nice until you actually get that physical connection. It's actually, it's like, God, it's always better.
Yeah, let's see if we get the whole picture in there. Okay, thank you. Thank you, Doug. You ever seen this rain jacket before?
no,
Did Alec Murdaugh have that rain jacket with him when he came in to the Ms. Libby's home on the morning, I believe, a few days after the funeral?
no,
And if this photo, exhibit 41, states exhibit 41, can you see this blue thing wadded up?
yes,
If that is, in fact, the photo of the rain jacket that we just looked at, would your testimony be you've never seen that garment folded up in that closet before?
no, only thing I seen was blue velvet. I didn't know it was a raincoat or not. It was balled up.
Oh my God.
So you, well, have
Just
you
said
ever
you've
been in
never
this
seen the
closet
raincoat.
before?
No, I haven't.
So you don't know what that is folded up there, do you?
Correct.
And so if it's this rain jacket, if that's what's in that closet, you've never seen Alec Murdaugh with this garment before, have you?
No, I haven't.
All right. Now, just very briefly, I know you've been really good here. I know it's been a hard day, and we appreciate you being here. That day when you came to work, Mr. Randolph Murdaugh had been put back in the hospital. Is that correct?
Yes.
And that was unusual because he'd just gotten out of the hospital like a day before, right?
Yes.
And so it was, although it wasn't usual for Alec Murdaugh to come over that night, but this was an unusual day because Mr. Randolph had been put back in the hospital. Would you agree with that?
Yes.
All right. Thank you. That's all the questions I have, John.
Thank you, ma'am. You may step down.
That's actually a pretty decent cross.
Yeah.
Directly attack the I mean, because that was obvious that on direct they were trying to
may call your next
justify
witness.
they're trying to justify that vinyl tarp or the vinyl raincoat through her because they asked her about it in their investigation. But of course, the answer in her investigation was she's never seen it at all. But that's not what the prosecution asked. The prosecution said, did they ask you about this tarp? Did they, or this raincoat? Did they show you this blue raincoat? Is this what they showed you? Yes. They didn't ask her if, is that what you saw him bringing in? Is this the same color? So the defense had to come in and say, this wasn't the thing.
Kristen Moore, Moore. Good afternoon. Could you tell the jurors where you work? I work for the South Carolina Law Enforcement Division. And Agent Moore, you might need to pull that microphone a little, speak up so we can hear you, make sure to hear you out here. Thank you.
And it's a first date.
And what do you do with SLED? I'm a special agent assigned to the crime scene unit. And did you have an occasion to become involved in the investigation of the murders of Paul and Maggie Murdaugh?
Be right back.
Yes, ma'am, I did. Were you involved in the execution of a search warrant? Yes, ma'am. And where was that search warrant executed? At 2175 Yemisi Highway in Barnville, South Carolina. And do you know what that residence was or is? It was the residence of Alexander Murdaugh's mother. And who was there when you executed the search warrant? Several SLED agents were on scene as well as family members. What were you looking for when you searched the residence? We were advised that we were looking for a blue and colored tarp-like material. And what areas of the residence did you search? We searched the entire interior of the residence. Let's talk about the north bedroom of that residence. Do you recall what you located in that bedroom? We located a blue tarp inside the closet in the north bedroom on the second floor.
Yeah, she's a sled 10, folks.
More, I'm going to show you what's been marked as State's Exhibit 224. Do you recognize what's in that picture? Yes, ma'am, I do. Is that a fair and accurate representation of what you found in the north bedroom closet? Yes, it is. Your Honor, at this time the state would move State's 224 into evidence. Permission to publish? Yes. Agent Moore, could you describe for the jurors what you found in that picture?
That is the blue tarp that we located inside the bedroom inside the closet inside the bedroom.
And what was that tarp located in?
A storage container.
Were there any items in the storage container?
There were miscellaneous dishes underneath the tarp.
After you found the tarp, did you continue searching the residence?
Yes, ma'am, we did.
And what else did you find?
We located a blue raincoat in the coat closet on the second floor.
I'm going to show you what's previously been entered as State's Exhibit 223. Do you recognize that photo?
Yes, ma'am, I do.
They put that on the screen so the jury can see. Could you point out that closet for us?
It is at the top of the photo on the right-hand side. So the door immediately above the stairs leads to an attic area, and the door to the right of it is the coat closet.
So not this door right here at the very top of the stairs. The next door is the closet we're talking about.
That's correct.
And I'm going to show you State's 414. Do you recognize that picture?
Yes, ma'am, I do.
Okay. And what are we looking at there?
That is a picture of the interior of the coat closet.
Your Honor, at this time I move State's 414 into evidence.
No objection.
Submitted.
Now, Agent Moore, if you could you point out the blue raincoat or tarp-like material that you found in this picture?
It's in the back of that photo behind the white box, towards the bottom.
And if you don't mind, would you mind stepping down and pointing that out to the jurors? Would you come down to the big TV? Thank you.
It's right here.
Okay. So, and that's how you found the raincoat?
Yes, ma'am, it is.
Down in that closet.
Yes, ma'am.
And if you look at this picture, it appears there are other items of clothing that are hanging up,
Yes, ma'am, there was.
but the raincoat is balled up down there.
That is correct.
And what did you do when you located that raincoat?
We documented it with photographs, and then we collected it in a brown paper bag, which was dated, sealed, and initialed.
I'm going to show you State's 225, which I believe
Sorry about
the
that.
defense has an objection to.
Your Honor, if it's the raincoat, it's already in evidence. And the photo of the raincoat is in evidence. I don't know why we need another photo, but we do object any testimony about seizing the blue raincoat, anything beyond that, based upon my earlier statements to the court.
Response?
Your Honor, this agent's testifying to what she retrieved from the closet, and I believe this is a picture of her retrieving that item.
Objections overruled.
So, Agent Moore, do you recognize what's in this picture?
Yes, ma'am, I do.
And this is a true and accurate depiction of what you recovered from that closet?
Yes, ma'am, it is.
Your Honor, at this time I would move State's 225 into evidence.
Same objection.
Submitted over objection.
All right, Agent Moore, if you could tell us what is in this picture, State's Exhibit 225.
Bring up the Elmo.
That is a photo of the blue raincoat that I collected.
And this will be State's Exhibit 226. Without opening this, can you tell us what is in this item? State's Exhibit 226.
In the box.
Based off of the
Oh,
item number
what's in
and
the
lab number
box?
and my initials,
The
this would be the
box.
blue raincoat.
Your Honor, the state removed State's 226 into evidence.
Objection.
relevant.
Relevance to this raincoat.
Response.
Your Honor, this is the purported raincoat that was recovered from the closet.
What is the relevance of the raincoat? But of course, he's going to allow it in. I mean,
All right. And when you recovered that raincoat,
the relevance of the
what did you-
raincoat
did you do
has become a
anything with
question
it
of
besides
fact
photograph and collect it?
for the jury.
Not on that day. We transported it back to the SLED Forensic Services Laboratory.
And now in the closet where you found that raincoat, were there any guns?
No, ma'am.
Were you involved in any of the processing of the raincoat?
Yes, ma'am, I was.
And what part were you involved in?
On October 7th, 2021, at the SLED Forensic Services Laboratory, I met with SLED serology personnel to document and do additional processing on the raincoat.
And what processing did you take part in?
It was documented with photographs. The stains on the raincoat were then documented with scale tape and labeled, photographed again. SLED serology department then tested the stains with phenolphthalein, which is a presumptive test for the presence of suspected blood. All testing with phenolphthalein was negative. We then used an alternate light source to look for any latent stains on the raincoat. We observed an additional stain and documented it with photographs as well as scaled it. Then it was tested with phenolphthalein as well, and it was negative. We then used leucocrystal violet, or LCV, which is also a presumptive test for the presence of suspected blood, and it was negative also.
All right, as far as your involvement in the raincoat, does that pretty much sum it up for us?
Yes, ma'am, it does.
All right, thank you, Agent Moore. Please answer any questions from the defense.
Okay, I guess the defense appreciates that assistance.
Yeah.
So they tested every stain for blood and none of it was blood. So what are we
Good
talking
afternoon,
about?
Agent Moore.
Good
Yeah.
afternoon.
So I understand you went to Almeda, Ms. Libby Murdaugh's home, to execute a search warrant. Is that correct?
Yes, sir, it is.
And what was the day? September
September 16th, 2021.
16th, 2021. And you were looking for a blue tarp.
We were advised that we were searching for a blue tarp-like material.
Okay. And you found a blue tarp. Is that right?
Yes, sir.
And in that blue tarp, there were dishes wrapped up in that blue tarp, right?
No, sir, no dishes were wrapped in the blue tarp. It was folded on top of the dishes.
Okay. So you seized the blue tarp, right?
There
Yes,
was
sir.
a blue tarp.
And did you do any testing of the blue tarp to see if there was blood?
No, sir, I did not do any testing on the blue tarp.
You know anyone who did any blue testing on the blue tarp?
I am unaware of any testing done on the blue tarp.
You seized this rain jacket in here, in this box. Is that correct?
Yes, sir, it is.
And back in the lab, you did some presumptive testing. We sprayed it with phenol first.
Phenolphthalein was first utilized, yes, sir.
And phenolphthalein is a presumptive test for blood, meaning, you know, it could test positive, but it's not necessarily means it's blood, right?
That is correct.
And in order to determine whether something that has tested positive with phenolphthalein, you do another type test to confirm human blood, right?
That is correct.
But the blue rain jacket never tested positive for the presumptive test using phenolphthalein, right?
That is correct.
So it was negative.
Yes, sir.
So after getting negative with phenol, then you use another product called LCV. Is that right?
We did. We used an alternate light source first to make sure that we had all stains documented.
Okay.
Now, alternate light source is what?
It is a specific wavelength of a flashlight, and you use a colored filter, and then you can see any latent things that you wouldn't be able to see with your naked eye.
And the alternative light source doesn't tell you whether that's possibly blood or something else, does it?
No, sir, it does not.
So you use that alternative light source and you identified some area, and is that the area you tested with LCV?
We tested the entire raincoat with LCV.
The entire raincoat? Okay.
Yes, sir.
And again, that's a presumptive test like phenolphthalein,
Yes, sir.
and that tested negative,
That is correct.
okay? And so there's no more blood testing done of the rain jacket, right?
I was not involved in any further processing of the raincoat.
Not my job.
Do you know if that LCV that you sprayed on the entire shirt has turned the rain jacket in that box completely violet?
I have not seen the raincoat since the processing was done on October 7th, 2021.
Okay. What size is this rain jacket?
I could not tell you the exact size of the raincoat.
Well, would you agree with me that the records indicate it's a large?
Yes, sir, it is a larger jacket.
Well, the size being large, do you know if it's large? That's the size?
Larger.
I do not recall the size.
Do you mind if she opens it up?
Have her look at it.
Your Honor, do you mind if the witness opens the box up and let's see what size the rain jacket is?
Any objection?
Alex definitely wore an extra large,
No objection, Your
by
Honor.
the way. You've seen the photos from him at the time of the murder. He was
You have scissors?
bigger than he is in
No,
the
I
seat.
don't have scissors, I have gloves.
Yeah, you probably won't gloves. That's right.
Yeah.
Oh, girl who carries around blue gloves.
Watch
Lucky
out for
day.
those. What's in your other pocket? KY?
The sled prostate, please. Here we go again. Gonna take our year and a day to open his box. It would be pretty funny if a bloody mannequin head fell out of it.
Sorry, that was the joke box. Shit.
They're gonna have the defendant try on this child-sized raincoat. If the coat don't fit,
They're going to do it. That'll be hilarious. I can't get my arms in.
I swear to God, my 6-year-old opens boxes faster.
The one attorney's leaving because he's like, well, I'll be back in an hour when she's done opening the box. There's another in a box, in a paper wrapping, in another wrapping. Like,
Oh my
look at our
God.
it's a blanket. They have this thing wrapped in.
It's a white tarp.
There's another one. You gotta upholster a couch.
Don't laugh, Alex. Don't laugh. It's a bad look.
Remember, guys, so they've wrapped this thing up 100 times. Remember that they tested it and found nothing on it. There's no blood on this thing. They didn't ask about gunshot residue. Maybe there's another tech who tested it for GSR. You know it's going to be wrapped in vacuum sealed in plastic once she gets it out of this paper.
There's no rain jacket in there. It's just a big ball of paper.
Some aluminum foil next. Oh, thank God.
Tell us what size it is.
Yes, sir.
It's a youth small.
I don't see a tag right here at the front. You may want to put gloves on. It has chemicals on it.
Ooh, I don't want to touch it then, which I just did. Okay. Well, do you mind standing up in front of the jury and show them how large it is?
Jesus. Everything they do sounds like a calamity.
Is it a poncho style rain jacket?
Just sir, it appears that way.
Okay. All right, thank you.
Well, it didn't stain all that white paper.
Thank you.
Smells too good.
If anybody was taking notes, that wasn't a very big jacket for a
You know if
raincoat.
that rain jacket or photos of that rain jacket was shown to any member of the Murdaugh family to see if they recognize it?
I am unsure.
You did not then, did you?
No, sir, I did not.
Did you show that photo or a picture, excuse me, the photograph, the rain jacket? Let me scratch that. Did you show to Shelley Smith the rain jacket or a photo of the rain jacket?
No, sir, I did not.
Do you know of any sled agent who did?
I do not.
1 second, Your Honor.
You'll have my editor make a compilation of all the unboxing videos in this trial. It's 6 hours long.
Director's cut.
Conservative Husker says that thing was huge. Wow, Nick, you are biased. Dude, it has to go over your clothes.
That's all the question I have.
Further questions?
Let no redirect opportunity pass.
I only brought this.
All right, Agent Moore, what happened to that tarp or raincoat? Where is it?
It's in the
Back in
box.
stock?
Yes, ma'am.
Oh, get it out, please. Again, that's what we need.
State's Exhibit 226. This is the raincoat you collected from that closet at Alameda.
Yes, ma'am, it is.
Now, when you collected it, did it have like this tape here on the raincoat where we can, the white tape with the letters on there?
No, ma'am, I placed that on that.
So that was done during processing?
Yes, ma'am, it was.
And we've been talking about a raincoat, but is this what you would normally think a raincoat would look like?
No, ma'am.
This is rather large for a raincoat.
Yes, ma'am.
When you found it,
Maybe I'm
It's
crazy.
balled up
Doesn't look
like
that big to me.
That is correct.
What is it then? If it's not a
no
raincoat,
further questions for this witness, Sean.
is it a lab coat of some sort? Like, what are they?
Thank you. You may step down.
What's it supposed to be?
Call your next witness.
William McElvey.
What was the point of that redirect?
Just to show that it could be bundled up like, so it might look like a blue tarp, I think.
I guess.
Raise your right hand, left hand on the Bible. You affirm the testimony about to give shall be the truth, so help you God. Take a seat in the witness stand. State your name again. Spell your last name.
My name is William McElveen, McElveen.
Mr. McElveen, how are you doing today?
Well, how are you?
Doing well. If you would, tell the jury a little bit about yourself. Where'd you grow up and where'd you go to school?
I grew up in Columbia, South Carolina. Went to AC Florida High School. Went to the Citadel after high school. Graduated there in 2017. Went to get my master's at Clemson. Graduated in 2018. Moved back to Charleston, worked for a CPA firm for a while. And now I'm in finance for a home builder.
For where, sorry?
For a home building company.
And what area generally do you currently live?
Live in Charleston now.
Mr. McElveen, were you friends with Paul Murdaugh?
I was good friends.
All right, well, tell us a little bit about when y'all first met.
So I lived in Edisto Beach every summer with my granddad, and when I was growing up, and he was in Edisto all the time, so we just became close. Edisto's a small town, not many young people live there, so the young people kind of stick together. We both love fishing, hanging out, so we just became good friends through that.
So you would spend the summers in Edisto?
That's correct. Yeah.
And what kind of things would you do throughout those summers?
Kill wife and
hang out,
children of
work,
prominent
fish.
lawyers.
What kind of jobs did you get?
Worked multiple jobs there for 5-ish summers. Worked at the marina a good bit, a restaurant there called the Sea Cow. I worked at a realty company as an inspector and at the Bilo as well.
And I think you just said that you met Paul about the high school years?
That's correct.
Okay. Tell us a little about your friendship. How did it start and how did it kind of evolve?
It started just kind of.
It was love at first sight.
Fishing and hanging out. And then he was just a really fun guy. So we just hung out more and more. And I started going to Murdaugh, hanging out with his whole family. They kind of took me in and just evolved from there. Yeah.
So did you get to know him pretty well?
Yes, I did.
Did you get to know his family fairly well?
Yes, I did.
Tell us a little bit about Paul.
Paul was just a really fun guy, just like the life of the party kind of guy. Everybody that
For the
really
death
knew
of the
loved
party.
him. I don't know, just a great guy, very loyal friend, the kind of guy that's always there when you need him.
So if you reached out and needed something, you might want to pull that mic a little closer to your mouth so it picks it up. Just try to speak into the microphone.
Okay.
So was he sort of a responsive friend? Meaning if you reached out to him, would he respond back?
Yes, he was very responsive.
And how did you primarily communicate with him? What means?
Cell phone normally. Yeah.
phone calls or texts?
A little bit of both, but mostly phone calls. He was a big phone caller.
Well, I guess tell us a little bit about Paul's cell phone use. Did he like to use his cell phone?
He did like to use his cell phone.
How would you describe it, his use of cell phone?
He used cell phone a lot. Like kind of every time he had a road trip or anything like that, he would use it to call all of his friends and just check in on everybody. I can speak for almost all of his friends. We get a phone call from him almost every day. And then we use text a lot, Snapchat, that kind of stuff.
Was he on his phone quite a bit?
Yes.
To the point where was it very noticeable to his friends?
Yes.
Not a moment of the day until he was dead was he not using that cell phone.
Ever have a chance? Did you have an opportunity to get to know Maggie Murdaugh?
Yes, I did.
All right, well, tell us about her. What was your observations about her, or your whatever friendship y'all had?
She was just a super sweet lady. She kind of always trusted Paul when he was with me. She would know he's staying out of trouble. She just treated all Paul's friends like they were her kids. And
Were you driving the boat?
nice lady.
And did
you kill
approve
that
of you
girl?
hanging out with Paul?
Yes.
Okay, tell us about that.
About what? Sorry.
Well, did she ever comment to you about how she liked you hanging out with Paul?
Yeah, she did. Like hang out with Paul.
And did you have an opportunity to get to know Alex Murdaugh?
I did.
All right, and what were your perceptions of him?
Kind of the same way the rest of the family, just took everybody in, all Paul's friends. He was kind of the dad of all of our friend group. Same way the rest of the family, yeah.
And is he here today?
Yes.
Did you identify him?
Yes. It's in the brown jacket.
Thank you. Did you ever get to go out to the family property on Moselle?
Yes, I did.
How often would you have you been out there visiting?
Probably 30 or 40 times.
Okay. Did you spend the night when you went out there?
Yes, normally.
Tell us a little bit about the property. What kind of things would y'all do out there?
Did a lot of hunting. Also, probably more than hunting, just hanging out. Just enjoying each other's company, hanging out.
So you said about what, 30 to 40? Is that what you said?
That's correct.
Okay. If you would, please
Yep.
speak up a little bit. It's okay. All right. Now that the property, was there a main house location?
There was, yes.
All right. Was there a secondary location for kennels in a shed?
Yes, there was.
All right. Did you spend much time out at that secondary location?
A good bit, yeah.
All right. Describe that area for us, if you would. What was out there, and what would you do out there?
So it's like a big shed hangar that side comes up. We'd all hang out over there. And there's the dog kennels. And then a few years back, they built the shed across from the hangar. And it was just a good place to get away from the main house and just hang out and talk.
If you were visiting Moselle, would you spend most of your time hanging around at that shed, the hangar area?
Depends. For large groups, we would have people over there more often. If it was just me and Paul and the family, we just hang out in the house.
You mentioned kennels. Were there a number of dogs on the property?
There were, yes.
Okay. Do you remember them?
Yes.
Okay. Tell us about the dogs you remembered. And well, first of all, were there kind of two different kinds of dogs between family dogs or working dogs?
Yes.
Okay. Did you get to know any of the family dogs?
Yes.
Who were they? Tell us about those dogs.
Oh my God. Are the
Bubba
dogs
is
going to
a
testify?
yellow lab, and then Bourbon, brown lab, and Grady is a black lab. And they were all pretty relaxed, would hang out around the house mostly, but I don't know, they were just good dogs.
Did they, and when you slept over there, did the dogs sleep at the house location, the main house?
Yes, they did. The family dogs did.
The family dogs.
Yes.
And then there were some working dogs where would they stay, the working dogs?
They would stay in the kennels by the shed.
Yes, the location. So the Moselle location, when you started going there, did it have one or two entrances and exits?
2 entrances.
Okay. And describe the two entrances.
So one was the main entrance that was had like brick pillar outside, and that would just kind of go to the house and not really pass anything, go through some trees. The other entrance would be next to the cabin, right behind the shed, and that entrance can kind of go multiple ways when you go in there, but that passes by the cabin and the sheds and then goes to the house as well.
And with that entrance, is that where the mailbox was located?
Oh, I can't remember the mailbox is. I believe those at the pillars at the main entrance, maybe.
Is that the location near the dog kennels?
No.
That second
No.
exit?
Yes.
Wait, what?
Was there one exit that was used more often than the other?
We probably more often use the one by the sheds.
If there was ever a time where someone was leaving the house and you all were down at the kennels, what was the normal course of action for that person, whether it was Mr. and Mrs. Murdaugh?
Say that again?
If anyone was leaving the house or coming back and you all were down at the shed area, the kennel area, what was the normal course of action for Mr. and Mrs. Murdaugh if they were leaving the house and exiting and you were down there?
Typically, they would come check on us and drive by and just say, hey. But
that was normal?
I would say it's normal, yes.
Did you, with Paul, were you guys close enough where you shared your location with each other?
We did.
Tell us what that means. Is this an iPhone?
Yeah, it's the app on Find My Friends on iPhone.
And what does it mean to actually share your location with someone?
Just means at any point in time, you can open your phone and see where all your friends are and pinpoint their exact location.
Did you do that with many people?
Probably
lip smacking
5
is.
or 10.
Do you know if Paul did that with many people?
Don't think Paul did with many people now.
When you spent time down at the hangar and the kennels, was it common for firearms to be stored down there or left down there?
Not common, no.
In those times, you said you've been about there about 30 to 40 times.
I mean, yes, they were there.
How would you explain common? Was it something that you frequently see or not frequently?
Can't remember a time I've seen firearms left at the sheds.
The other better friend testified that he did.
Everywhere. Shed, cabin,
When's the
vehicles.
last time you saw Paul Murdaugh?
June 5th, I think, 2 days
Is that the
before.
witness doing that lip
Weekend
smacking?
before
Yeah,
Monday?
before every answer.
Tell us about that weekend.
I can't remember much. We were hanging out at my friends' houses.
Except that one, of course.
I think we went to a bar called the Windjammer in Charleston.
The Jammer?
But I don't remember much from the weekend.
The Windjammer. Woo.
Did you see him on Sunday?
Do not think I saw him on Sunday, no.
Did he stay at your house that weekend?
I don't think so. My friends and I were talking about that. We can't remember if it was my house or one of my other friends' houses.
Would Paul commonly stay at, when he was visiting Charleston, would he crash at people's houses?
Yes, he normally stayed at our house.
But you don't remember if that particular time he did or not?
Don't remember.
I'm going to do it every time now.
How were you kind of told about the murders? How'd you find out?
So I missed a few calls in the middle of the night that I didn't wake up to. The next
Your
morning, my
Honor,
roommate
you
came
instruct
to
the
my
witness
room,
to stop doing
told
that?
me.
Your roommate is who?
Frank Chapman.
And he told you what happened?
Yes.
Did you make it out to the property at all?
Yes, the next day I went out to the property.
So the 8th of June?
Yes.
And walk us through what happened out there when you made it to the property. Where did you go?
We just went to the main house and just went to see the family and to be with everybody.
A lot of friends and family were there.
Good bit of friends and family, yes.
Did you attend the funeral as well?
I did, yes.
Did you regret killing them?
Indulgence.
Oh my gosh. Bitter Sweetheart 46 and 2 says, quote, I don't want to affect the court schedule. One of the guys who added 2 weeks to the trial. Apache, if this is the perfect murder, then a few strangers committed the perfect murder on a property they've never been to instead of the guy that lives there. I don't think this is the perfect murder, but that's the sort of thing the state wants you to believe.
That's
Lubricate that smacking tongue, boy.
Good afternoon.
Afternoon.
'87 Sparker says, I bet he can
Mr.
suck a
McElroy,
golf
where
ball
are
through a
you
water
from?
hole.
From Columbia, South Carolina.
And are you friends with Wills Chapman and Frank Chapman and Will Loving and
I am, yes.
that crowd? Okay. And so you met with Paul, I take it, down at Edisto with the Columbia group?
Yep,
And you became really good friends of Paul's, correct?
correct,
And I think you described him as a loyal friend, did you not?
correct.
And you became close not only to Paul, but to the entire Murdaugh family, right?
Correct.
You know, there are houses that kids, teenagers, young adults congregate at their parents' house. Was the Murdaugh house at Edisto one of those houses where people would congregate?
It was, yes.
And you spent a lot of time at Edisto there in the summers?
I did, yes.
And you spent time around Alec and Paul and Buster and Maggie, is that correct?
That's correct.
And how would you describe Alec's relationship with Paul?
They had a very good relationship. They were kind of best friends in a way.
They were close?
Very close.
And how, from your observation, how would you describe Alec's relationship with Maggie?
From everything I've seen, it was great too. I mean, nothing, I've never seen anything negative.
Right. And they like for Paul to hang around with you and, right?
That's correct.
I mean, I think you were asked about that. You strike me as someone who's very responsible. Did they like that about you, you think?
They did, I think so.
And you strike me as someone who if you're down at Moselle, would not leave guns laying around. You wouldn't do that, would you?
Probably not, no, sir.
Okay, so when you were with Paul, hunting, you were responsible enough to be sure that guns got put away properly, correct?
Correct.
You were asked about some of their dogs.
Gee, Paul, we should probably put these guns away, don't you think, fella?
Actually, Paul had a puppy, did he know?
He did.
You have that puppy now?
I do.
What's his name?
His name's Goose.
Motive.
How's he doing?
He's doing great.
Survivor.
Glad to hear that.
Don't let him co-pilot an F-14.
And you describe 3 labs, Bubba, the yellow lab, Verdon, the brown lab, and Grady, the black lab?
That's correct.
And when you were at Moselle, I mean, these were family dogs, and they stayed up at the residence?
That's right.
No, but the residence, they had a invisible electric fence around the house, correct?
I didn't know about it, but possibly so.
Okay. Well, was Bubba a handful? Just take off sometimes?
Sometimes.
Right. And you don't know, when was the last time you were at Moselle?
I can't remember.
Was it in 2021?
Most likely.
Okay. Were the dogs there?
Can't remember.
When you heard that Paul had been murdered, did Will Loving come down to your house in Charleston, or was it another friend's house?
Will went to another friend's, but I think he came to our house later in the day. But we had a group at our house as well.
And then you went to Moselle?
The next day we went to Moselle.
Would that have been on that Wednesday? Murders were Monday night, late.
So yes, I guess that Wednesday we went to Moselle.
So not the Tuesday, but the Wednesday.
I believe that's correct.
And who all went with you?
I think Frank Chapman went with me. And that might be it.
And who was there when you got there? Well, were any other other friends of Paul there when you got there?
Rogan was there, and Nolan was there.
And what was?
There might have been a couple more, but I'm not sure.
Okay. What was Alec Murdaugh's demeanor when you saw him?
Just sad, crying.
Did y'all hug?
We did hug, yeah.
Did he? When he was crying?
Yes.
And did you go back over to Moselle after the funeral?
Yes, I did.
And were there a bunch of Paul's friends there?
There were, yes.
And can you tell me, was Alec, is he still crying, hugging all the Paul's
He
friends?
was still crying. I mean, there were so many people there that it's kind of a line to see him, but from the little bit I saw him, yes.
One second, Your Honor. Don't have anything further.
Anything further? Thank you. You may step down.
Oh, finally, no redirect. I
I
got
didn't-
nothing really to redirect about.
Break.
I didn't-
um,
another-
Addressing the jury, 15 minutes break.
15-minute break. They just got back.
Judge wants to talk to that sled agent about her blue gloves.
Yet again, I'm left at a loss for what the purpose of that witness was.
He talked about Paul being very responsive on the phone. I mean, this is part of the state trying to say, hey, when he didn't use his phone for 10 minutes, that means he was dead.
Yeah, I mean, but what the defense is able to elicit out of him is yet more testimony. Paul and Alec were best friends. I mean, best friends. How is Maggie and Paul's relationship? As far as I could tell, it was great. Fantastic. They loved having everybody around the house, didn't they? Yep. They loved you being a friend of Paul, didn't they? Yep. You're like it seems like everybody who comes into this family is immediately welcomed in. Everybody's welcome. Everybody's loved and wonderful. I mean, I'm having a hard time being sold that this guy's a brutal murderer of his family.
Yep, it's a hard sell.
Yeah. I don't know. Bubba ran off at 8:44. Well, but we knew that from the Snapchat video already. I mean that. So anyway.
A good time for another book grift.
Yeah, as soon as look, it's Bizarro Me on Law and Crime.
Oh.
Oh God. It's like
Good heavens.
a couple years. Like I got the gray coming in here. No, not good. Yeah, go ahead and bring up the book. Of course, it's in your title there, lawofselfdefense.com/Nick.
Nick, right. Get a free copy of the Law of Self-Defense Principles, the Bible of self-defense law. Learn how to be hard to convict if you're ever compelled to defend yourself, your family, your property against criminal predation. Look at the reviews on Amazon, folks. 5-star rated, over 1,200 reviews, but don't buy it on Amazon. Amazon will charge you for the book plus shipping and handling. We only ask you to cover the cost of getting the book to you. The book itself is free when you get it at lawofselfdefense.com/Nick. All right. Thank you.
Go,
and if you
guys.
bring it to Vegas, I'll sign it.
Make sure to check it out. Make sure to check the book out. Hard to beat a free book that can give you practical advice on a situation you never want to end up in. But that's the amazing thing about self-defense situations is you don't end up there because you want to. You end up there because something is happening to you that is unforeseen typically.
Somebody else makes that decision. We don't choose the time, place, and manner of our attack. The other guy does that.
Exactly. Because if I did, it'd be over instantly.
It'd be a rifle fight at distance.
But make sure and check that out because it could save you. It could save your life after you save your life, and that's the tough point. You have to defend
And we get
yourself
letters
twice.
every month from people in prison who somehow got a copy of my book saying, "Man, if I had this then, I wouldn't be here now."
Here we go. I'm gonna keep. We're almost caught up on the super chat, so I want to make sure we're all caught up, so we don't have a giant backlog and people get their answers and questions read before the end. Patchy says, "If this is," oh wait, I read that one. Cody the bum. My granddad told me once. Sometimes you gotta ball up all the shit, throw it at the wall, and pray something sticks. That is the state in this. I mean, yeah, that's what their case looks like. You throw it all together and hopefully the jury grabs onto something. And that's the danger of jurors, is that they can grab onto anything. I mean, it could be something innocuous that tips them towards guilty. And once that happens, then they're in the mindset of everything looking bad, kind of how the state is right now. Tilly T says, Bronca and Kurt didn't answer the question. Oh, would you, if you had to work on this case, would you rather be on prosecution or defense?
I'd rather be on the defense.
Yeah, I figured. I would assume Kurt would too, but I have no idea.
Because I think that the state's in a position where it necessarily has to half-ass the case because they don't have the evidence they need.
Right. And this is it's a strategically brilliant move by the defense to ask for the speedy trial, or to demand the speedy trial, I should say. Because if they'd waived their right to speedy trial, the state could have spent another year flushing this case out. And flushing the case down.
Is what they're doing.
And they're not going to change their mind on it either. That's the thing, is once you're targeted, I mean, and well, they charged them, but once you're charged, I mean, they're going for it. It's not like they're going to go, oh, well, you know what? 6 months later, well, we don't have the right guy. Actually, we just decided. Torin 3 says, Nick, were you able to get your braid from the post office? Do you like it? Also, thanks for letting me shout out my channel, youtube.com/Torin3, where people can see me making the braid for you. Only one subscriber away from 500 and halfway to the point of remonetization. Thanks again. Torin, I have not been to the post office. Lady Rackets went by the post office and grabbed everything, but I don't have it. So I'm guessing she probably picked it up, but I haven't seen it yet. Elgonza 1000 says, didn't most of these people not know he was stealing from them until after these murders? Also, how much do you want to bet the prosecutors will have each and every single one recognize and point out the defendant? Could be. A lot of them didn't know he was stealing from them because when they reported to the law firm that they didn't get paid, the law firm had the obligation to pay out as the entity that was ultimately representing them. You know, he was an employee of the entity or an agent, however you want to work that out. But the law firm had the responsibility to pay out the clients. So the clients ended up getting paid. It just maybe took longer than they thought. Then they went to him to recoup the amounts lost eventually. And why the first time that happened, they didn't go recoup the amounts lost is a mystery. But maybe it's because they kind of, I'm not saying they all knew and were participating, but maybe they were new and were participating. You know, who knows? Who knows? Island says search for parents' house search parents' house with a warrant 3 months later. Ranos 123. You went to church and didn't spontaneously combust. Was this a satanic church? No, it's a regular one, but I do douse myself in flame retardant. Tara Rayner, the tarp could have been covering the ATV before it was moved. Wife says Eddie got a bird in his mouth on Snapchat. I mean, maybe the tarp could be anything, but it sounds like the blue tarp that they recovered was laying on a chair in the house. If you've got a tarp covering an ATV, outside. Some people are like, maybe he lays the tarp down on the dirty ground to lay prone to do shooting. I mean, it could be any number of things, but I mean, I don't know.
Right. The caretaker says it was folded on Miss Libby's retirement rocker, which I presume is something you would not want getting dirty. And then the police recovered it, folded up, and put on top of a stack of plates, which presumably is something you'd not want to put a muddy tarp on. So I don't get it.
And it's not like these tarps are expensive. So if one gets dirty and ripped up, I mean, the most you're out is like $60 for a huge tarp. I mean, this is a multimillionaire. It's like he's probably not pinching pennies on what looks like about a $30 purchase. So I don't know. The tarp thing seems like a complete red herring to me. And then they brought out this rain thing, which is not a raincoat. Apparently she
like a poncho.
She didn't think it looked like a raincoat. I don't know what it was supposed to look like. I don't know if she's an expert on raincoatology. I'm not sure what that was all about, actually. Does this look like a raincoat to you? No. What's it look like? I mean, maybe a lab coat or something like that. Or something that you'd wear while dealing with animals, like livestock, maybe. Maybe like a butcher type apron in that respect, except no blood on it. So again, very weird. Why do we care about this tarp or the raincoat if there's no blood or gunshot residue on them? And maybe there's gunshot residue that's just going to be testified by someone else. But right now we got nothing. Moni 2489 says Tinsley also testified that the Beach family was wanting their pound of flesh. Sounds like a family fed up and with waiting and a possible motive. Could be. American Dreamer, how many books to sell to buy your wife dinner in Vegas, Steve? Tanny Simmons says, I have to think Alex knows he's going to jail over the financial crimes. However, quality of life in jail over financials over double murder is undoubtedly different. Minimum versus maximum security. Well, I mean, there's also just the thing of if he didn't kill his wife and kid, even if he's going to jail forever, he probably doesn't want to be known as a guy who murdered his wife and kid. I mean, that seems like that'd be really important to me. Like if I did not murder my family, I would want to be not known as the guy who did. That would be worth a lot to me. Chris West says, this morning you said your state was like California. Nope, Pennsylvania isn't. It sucks here. John Fetterman in D.C. and she is also from our state. Dude, we got Ilhan Omar. Don't even at me. Big Rig 0485. And I'm pretty sure our marginal income tax rate is higher than Pennsylvania's, which makes me sad. Big Rig 0485 says, this judge have a retirement date coming up soon, or is he just an ignoramus? I think he seems to know his rules of evidence. Whether he applies them in the way that we agree with is different, but he seems to know them.
Book.
Yeah. He cites to the rules very quickly and pretty specifically. I mean, he's just a slow talking guy, and he's making decisions in this case that I don't agree with, but I don't know that he's an idiot. Jay Bolts, thank you for the donation. Bojangles Poonan says Monkey Don remember nothing. Monkey don't remember nothing. Becky Z says wait for it. Nicholas Stero Union Rep Labor Law says if Murdaugh is acquitted, can he sue the state for the amount he has owed his financial victims? No. No. So acquitted of the murder.
What was the question?
If he's acquitted, can he sue the state for the amount he has owed his financial victims?
No. Why would that even be a thing?
No, there is a federal criminal frivolous case recovery act. I don't remember what it's exactly called, but a malicious prosecution recovery action you can do against the federal government. It caps out at $2 million. And the income requirements are, if you're above, basically any level of income, you don't qualify. So almost no one qualifies. And that's for Fed crimes. I don't think they have one for states, but you're almost never going to recover money for being accused by the state of a of a crime, even if it's a malicious prosecution, you're probably not going to recover civil damages.
Yeah, Washington State does have a provision where if you're charged with a use of force crime like assault or murder or whatever, and you raise the legal defense of self-defense, if the jury acquits you, they can also be given a special verdict form asking explicitly if they're acquitting on the grounds of self-defense. And I think you just need a supermajority of the jury to check the yes box on that piece of paper. And if they do that, the defendant can recover his legal expenses from the state. The state will pay. But that's the only state I know that has any provision like that.
And it's highly restricted just to use of force in self-defense. I mean, typically speaking, if you're accused of theft, even if it's a frivolous case against you, you're not recovering, and you'll spend thousands of dollars defending yourself. To potentially hundreds of thousands of dollars, depending on the case. 200 Watt Studio says, welcome to another episode of Unboxing ASMR. Dr. Spoon, why was the state making that rain jacket seem like it was an actual tarp fat chicks order off of Torrid? I don't know. John Bassinger, if the raincoat doesn't fit, you must acquit. Aquamarin, I drop in every 2 to 3 hours to follow up in double speed, and I feel with the jury. Will they tell them they will be stuck here for months and why they are? They've already indicated, well, the jury seems to have figured out that they're going to be there for a lot longer than the 3 weeks they were told. One of the jurors has already said, hey, I said if it was longer than 3 weeks, I probably wasn't going to be the 3 weeks is going to not be enough. That's what it seems like happened there. And so that juror may be dismissed.
I mean, they do have these trials that can go on for weeks. It's terrible. Can you imagine? I mean, I would be so pissed.
Yeah. I mean, they're getting paid, like, if someone mentioned it's like $20 a day for this. And, that's fine.
I mean, who cares? It's the opportunity cost. It's the money I'm not making, not working.
Yeah. Let's see. Where are we? A generic account says Paul definitely had a type. Oh, come on now. Woo. Excelsior says, assuming he's innocent, doesn't all this time and evidence spoilage basically guarantee the real killers don't get caught? Yeah. Yeah, I mean, it's gone now. They picked their man. They picked their man, and it's Paul, and it's Alec. So that's, 87 Sparker. I bet he can suck a golf ball through a water hose. Cards 96. Are you guys getting any CLE credit for having to sit through this? If we could apply, or at least in Minnesota, I could apply for some of this to apply to CLE credits, but I don't know that they'd actually give it, because just going and watching trials doesn't do that. However, I do think that this will count towards my pro bono hours this year. Aaron Larg says, if Bubba ran off and Alec chased, he's not on scene. Coney Upstate, how long does gunshot residue last on clothing, and what relevance does residue have on clothing at an area where many guns are fired?
Lasts a long time, and there's no relevance.
There you go. Yeah, the second part I know there's no relevance at all. But how long it lasts, so long time.
Gunshot residue only matters if the suspect would have no reason to have exposure but for firing the gun at the crime scene.
Nancy Jennings, did the police bring in special dogs to follow scents? Do you think polygraphs will ever be brought back? I don't know if the police brought in special dogs to follow any scents. Polygraphs are a pseudoscience that they're not up to the scientific rigors that are required for evidence and in a criminal case or a civil case. And you've seen what does get allowed in, so that should tell you a lot about polygraphs.
The only thing they're good for is putting stress on people who mistakenly believe they work.
Right. Yeah, you can get them to admit to things or get them to do whatever if they believe that their answers will matter. And what they say during a polygraph test can be admissible, but the actual results of the test are not. If you want really good examples of proper polygraph usage, you got to watch The Wire. They tell that guy at the photocopy machine is a polygraph test, and he has to put his palm on the scanner, and then they have it they preload in green and red paper into the thing, and he's like, yeah, if you tell the truth it'll come out green, if you tell a lie it's gonna come out red. He's like, what's your name? My name is Terrell. Green. Where do you live? Here's my address. Green. Like, do you know who shot this person? Nah. Red. Perfect.
By the way, I saw someone in the comments jokingly suggest that I send my book to people in prison to mock them. Believe it or not, we send a lot of books to prison because people in prison try to order the book, but they don't have credit cards. So they're writing like on a legal pad and pencil to try to figure out if they can send a check or something. I just send them the book. We don't even ask them for shipping.
Let's see. We got a couple more. Susan Humiston says, hi, Nick, just checking in. See you soon. Hey, thanks, Susan. By the way, there is a minor update in my personal lawsuit. The opposing party they've filed their amended complaint against me. So that's fun. Good times. So now my lawyers will have to file their response. Joe Sullivan says, so there's a boat accident in 2019 where a young woman dies. And 2 years later, Murdaugh family killed. Pretty sure anyone sympathetic to the Beach family would be more likely suspect. Yes. That's correct. Outcast 77. How will Alec pay his lawyers if he is so broke? Seems like a very large team to pay with no money. Also, did the person claiming about the trust and Buster ever send you verification? No, I have not received a copy of the trust that Alec allegedly put money into that will revert back if he's found not guilty. I have no idea what that is. As for how will he pay his lawyers? Well, he may have paid them a very large advance. They may be working pro bono. There could be someone else paying a portion of the fees, all of the fees. There could be generational money that exists that is not normally accessible. So that is a possibility. There could be a pre-existing trust for Alec from a prior generation,
right,
that would pay out necessary expenses, including legal fees for a defense. And if that trust has millions of dollars in it, for example, it could very well be paying for this defense and would be very hard to access by a creditor or by a judgment in that regard. So that is a possibility, but that would be something that would have been well outside the scope of contemplating these murders. That would have been something set up by his father or grandfather.
Maybe before Alex was born.
Right. That could be anything around that. We would have no idea. Total speculation.
That's how trust fund babies are created, right? Among the wealthy, people who just go skiing all the time and stuff like that. They get a guaranteed, income in the mail every month.
Wouldn't that be fucking sweet?
I don't know.
I mean, there'd be, okay, correction. There's some fun elements to it, especially if you got it when you were like 20, right? Like you go out and just party or whatever, all the time with no responsibility. But yeah, I love and now the real grift, the super grift is the hyper rich, the kids of the hyper rich who then make YouTube channels about their rich lifestyle. And all they do is like, watch me and my friends go out on our yacht. And then they put out a YouTube video on it and it makes it gets millions of views and makes tens of thousands of dollars. And it's like, wait a minute. That's the grift right there. That's what you got to do. John Dia 021 says, Could there be pressure on the witnesses / judges to be favorable to the DA because Alex is hated in that area and they fear their lives will be impacted negatively afterward?
Sure.
Yeah. I mean, it's certainly possible. Speaking of pressure, what's up, Joe?
Hey.
Hey, Joe.
How are you, gentlemen?
We're on mic. How are you?
I'm not on mic.
You weren't for a moment there.
No. How are you? So, are they going to merge? What would it take for them to merge a fraud trial together with this?
Right.
Well, I think he's got.
I think Nick, you suggested it earlier. To me, it makes a lot of sense because this way, if I'm the defendant, okay, I mean, I'd be concerned that some people in the jury are going to look at him and say, "This guy's a fraudulent d-bag. He's a terrible human being."
Right.
And I'm worried he's guilty of being a jerk. I don't know that there's enough, and they might say to themselves, he probably killed him, and he's guilty of being a jerk, so he deserves to go away for the rest of his life for the fraud that he committed. So I don't know that a jury is going to end up finding guilty of that. So he's probably did it here anyway. And I think the reasonable doubt standard drops considerably with all the prejudicial testimony they're expecting to hear. So at the very least, if they merge the two trials into one, you can let the jury basically, decide his fate.
But do you think there's any way that a jury actually hearing the whole thing goes, you know what? He is guilty of all these financial crimes, but I don't think he killed his family. I don't see that happening.
I mean, they still have paper thin motive. I mean,
Yeah.
He's guilty of all these financial crimes, so he ends up killing his own son. Who the guy? There's all this video of how much love he had, and the birthday parties. He was willing to sacrifice his own law license in taking some really shady steps right after the boating accident to try and protect this kid who he supposedly kills 2 years later. It's very hard to understand. He's also sufficiently intelligent enough to know that killing your kid and wife, especially because you're likely to be fingered to be the first one most likely to have killed the wife, right? I mean, every time it's a cliche. Who killed the spouse? It's who kills someone. The first suspect is the spouse.
It's always the husband, yeah. Or
Yeah.
the wife.
Yeah, so that's why it's like to think that like, oh yeah, this is going to be that he's such a legal neophyte that he would think that this would in any way insulate him from any sort of or give him any sort of reprieve from these fraud claims seems so ridiculous. It seems really stupid.
Yeah, it doesn't seem like it would. I mean, it's extremely unlikely. And anyone thinking about it, who with knowledge of how investigations work in criminal prosecutions, it casts more doubt to me, just in a general sense, that he would do this.
And the wife's phone being half a mile from him when he's calling it. How is the state possibly going to explain that away unless they suddenly introduce a second person who's involved in this whole thing? That's a real. I mean, it almost makes like it's impossible that was him. So you sort of have to figure out, like, unless there's some sort of explanation they give us that we haven't, I haven't heard about yet. Maybe something came out today that I missed. I don't know, but I don't understand. I mean, if it's the phone almost gives him an alibi. Because they know where his phone was, they know where her phone was when it was being ditched on the side of the road at the same time. How is that not an alibi that he's half a mile away from getting rid of the evidence? How is that not a great alibi for him that the state itself provides for him? So to me, they have real problems with this case unless they can muddy the waters enough that they can become found guilty of being an a-hole.
Well, not just that. You mentioned something else. I mean, all of the testimony that we've gotten so far about the relationship between Paul, Maggie, and Alec is positive. All of it. There's no one has suggested that there was ever any animus or negative things. Now, presumably, we're going to eventually get there, I would think. But no one so far has.
Please be seated.
Unless he killed his son because the son fought him for killing his
Anything
wife.
before the jury comes.
I don't know. It's weird.
Anything before the jury comes. Judge, we're moving for a mistrial again.
trying to attempt to resolve. It shouldn't be a complicated issue, but Mr. Waters and I are complicated people.
Yes, sir.
It's all just making Alec look like a stand-up citizen. I don't know. I wouldn't go so far as to say he looks like a stand-up citizen, but he looks like a guy who likes his family. And to be very fair, a bunch of people who do really shitty financial things do so for their families.
Sometimes.
I said a bunch. I didn't say all of them.
Some people are really just selfish narcissists.
Of course.
All right, Mr. Waters.
Your Honor, I don't know if Your Honor has another instruction that you prefer. I probably would do the language just a little different in that particular one, but I think fundamentally the principles are accurate. I do think that the next to last sentence is superfluous because that's already said, but I think that's fine. And in the end, I don't
Would
think
be
that,
redundant than not superfluous.
There's too much that we have an issue with that particular charge.
And Your Honor, other matter before we bring the jury in, would you want to hear from me now? The state intends on, not this witness, if this witness is another witness, there's a GSR person, specific GSR person.
That's correct. It'll be the witness after this.
Okay. Evidence of GSR gunshot residue on that blue jacket. We would object to any such testimony under a 403 analysis. Prejudice outweighs the probative, and I'm struggling to figure out what the probative is. So I'm in this. I think it's factually driven. I think the state needs to give you some sense of what it proves. A jacket, I might point out, no one has put in the hands of the defendant. And the tarp that they found, they never tested for GSR, blood, DNA, and everyone says tarp. That's a jacket. I don't know how you connect it to the defendant. If the prejudice far outweighs any probative value in that it's not been connected to him, even circumstantially not connected to him, the only witness to it, Shelley, who I've talked to.
Well, it's circumstantially connected to
was
him.
not what he had in his hands.
The real problem is the gunshot residue is everywhere.
Or never seen it with him. So, Your Honor, we'd oppose it under the 403.
Have they ever had a negative test on gunshot residue in this case?
Yes, Your Honor. I think if you listen to the testimony of Ms. Smith in totality, first of all, she identified a picture where she said, yeah, that looks like what it was. It was balled up. And that picture, of course, was then identified by Ms. Moore as where they recovered the actual raincoat, which, of course, is a very, very large raincoat and very easily could be identified as a tarp. I think any issues that Mr. Harpootlian wants to make, he can certainly argue those to the jury, but the connection has been established between Ms. Smith and that particular raincoat, and looking at the picture and saying, that looks like what I saw.
Oh my
That
God.
other tarp, she also testified.
Little
that there was no
manipulative of
silver
the
on that tarp.
testimony.
If you look at the picture of that other tarp, it is half blue and half silver. So it's a very.
But the half blue and half silver doesn't describe the
Here
raincoat.
was, I think, Miss. I don't have to find the exhibits.
You're arguing out of both sides of your ass.
Today, yes, please.
But it is amazing. The tarp and the raincoat are evidence under the loosest terms. There's no blood or DNA on
Your
them at
Honor,
all.
I can put them up on the elbow or hand them up, whichever you prefer. But we have State's Exhibit 224, and this was a tarp you can see with a lot of silver on it. But State's Exhibit 411, Ms. Smith identified as that's what it looked like. You can see that balled up thing right there, and that is ultimately the rain jacket, which, as you saw, particularly on redirect with Ms. Gowd, this is extremely large, very easily could look like a tarp.
Look
And when she
extremely
balled it
large
up,
to me.
Ms. Smith said, yeah, that's
What's
what it
the
looked
significance
like. So
of this
I think there's
thing?
been enough of a nexus established as to the probative
I think
value.
the
And what
state's
you'll,
trying
of course,
to
hear
imply
is
that the guns were
from the GSR
smuggled away from the
experts,
scene of the
very high
murder
levels of
inside
GSR,
this blue
were found
whatever
within
it
the
was.
inside. The inside.
But it makes no
of that,
sense because
blue rain jacket,
if you're going to
which, again,
smuggle
was
them
this
away from the
big
murder
and
scene, you
very,
wouldn't
very
bring them
long.
to your parents' house.
Again, Mr. Harpootlian can argue to the jury whatever inferences he wants to, but I think the state has established enough of a nexus to not only make it relevant, but to make its probative value not substantially outweighed by the danger of unfair prejudice. Yes, sir.
I think he either misunderstood or is misquoting what
Yep.
Ms. Smith said. She said, when she was shown that photo, she said, it's the same color or like the same color. She never, ever, ever said, that's what I saw him with as he came through the door. He put, and by the way, she found the tarp. That couldn't be the tarp because the tarp was found downstairs across a chair, which is what she said he walked in with. So the tarp in the box obviously isn't it. And I mean, she said the tarp that he came in with was the one that was on the chair when he came down, not the coat. All she ever said was that blue coat, balled up, appears to be the same color. No one has ever said that she saw him or anybody saw him with that jacket. And I would also point out that I hate to say this, but I would suspect there are a number of rain jackets in this area of the state that have GSR on them, in them, around them. So there's no one that says he had possession. All she ever said was, and by the way, it was all balled up. All she said was, it looks like the same color. She saw a picture of the rain jacket and said, that is not what he was carrying when he came in.
All right.
I'll admit it.
The item is in evidence. The witness testified as to the location of the item of evidence and where she.
He's of course going to allow the gunshot residue in.
The defendant. It's in evidence. Obviously, the state contends that it has some inculpatory evidence on it. This is a circumstantial case, and circumstantially.
Wait, so it's a circumstantial case. I'm going to let in all the evidence.
Yeah, apparently.
The issue of whether or not.
It's a very weak prosecution, so I'm going to let in all the
gunshot
evidence.
residue or whatever it might be.
They have no case. Let me help him out as much as possible. It's essentially what he's saying.
I overrule the objection. I find it's.
And to be clear, I don't think the judge should let this in, just based on what he's been permissive on so far. I can't see any way he wouldn't let it.
Though I do not believe
Is there some date that you could attach to this GSR? It could have been there for like a month, right? It could have been. The GSR could have gotten on it.
I find that it's more
like back in April
than prejudicial. And
just left on it.
I deny the motion to.
That's not me,
prevent the
folks.
state from
Not me.
offering testimony.
Courthouse.
Accept your ruling.
Yes, sir.
I wouldn't.
Bring the jury.
We maintain our objection. Oh my gosh, this judge is so permissive on all evidentiary issues, and now we know his reasoning. Well, it's a circumstantial case, so you can bring in circumstantial evidence. Well, you can bring in circumstantial evidence in a direct evidence case too. That's not how that works.
It's the most ridiculous thing in the world. It really is. Every case has some circumstantial evidence. Look, fingerprints are circumstantial evidence. The only kind of evidence practically that's not circumstantial is eyewitness evidence. So,
well, if they had DNA evidence, well,
that's also circumstantial.
Yeah, I suppose. Yeah, eyewitness evidence, video evidence.
Yeah, that which is basically the ever seeing eyewitness is video evidence. But
yeah, maybe some audio.
Yeah,
but this is very frustrating because again, imagine being like, well, we found proof that this was used in concealing the murder, I guess, but that's an interesting question. He's not charged with covering up the murder. He's not charged with spoiling a crime scene. He's not charged with desecration of bodies or anything like that. Oh, hey, here we go. Speaking of desecrating bodies, what's up, Sean?
Not much. What's up, guys? Joe, how are you doing, man?
Next witness.
Your exile?
My appeal was rejected today.
Oh, no.
No. No love.
It's the most predictable
Sorry to hear
time of the year.
So I had to miss the last half hour. Did I miss anything after the raincoat lady?
Well,
I
there
mean,
was
It was a friend of his, right?
Yeah, it was a friend of his, and then a 15-minute break.
Okay.
The friend of his basically testified that he used the phone all the time, and then he testified that Paul loved Alec very much and Maggie. Oh.
This is I'm sorry, my title below says it all. I've been watching In and Out during the day. This judge sucks. This is awful.
Who gave me my headline? I'm trying to figure out where this stuff comes from.
My name is Natasha Moody.
That was me. I did.
Thank you.
Moodie.
And it all comes from the beautiful Genie stream.
Yes. It's coming up soon. Another month to perm.
I spelled it with a Y on my paper. I'm sorry.
It's okay.
Miss Moody, where are you from?
Jacksonville, Florida.
Why are you
For whom do
yelling?
you work?
Bank of America, NA.
What do you do for Bank of America NA?
I am a consumer resolution associate.
Consumer Resolution Associate. What does a Consumer Resolution Associate do?
Get bitched
I
at.
manage a portfolio of litigated matters. I appear on behalf of the bank for trials, depositions, mediations, and I also review our business records on a daily basis.
Your business records. Were you asked to review business records for Bank of America NA in relation to this case?
I did.
I am showing you 3 items labeled for identification as States Exhibit 415, 416, and 417. Do you recognize these items?
I do.
And how do you recognize them?
I reviewed them and I also initialed them.
And
Yeah, she
generally
does-
speaking, what are these items?
These are
It's like this
documents
broad turned him down for a date.
for
He's
this
so angry.
case.
She does look
opening
like the chick
account
from Commando.
Documents, monthly
Somebody mentioned that in
statements
chat.
for various accounts and
Got tired of all that
copies
action,
of
went into
checks
banking.
for this account, for various
It's one of my
accounts.
favorite movies.
Movie's
So
so
the bank
good.
records?
Let off some steam, Bennett.
I let him go.
When he takes the circular saws and throws
Yeah.
them like murder frisbees into guys'
Yeah.
heads.
Or the best one, he's like, the only thing holding you now, Sully, is gravity.
80s Arnold movies were so awesome.
Mhm.
Like, I always forget that the first half of Predator is just a raw action movie, and then it goes
Mhm.
into the horror. But when he throws that knife through the dude and staples him to the wall, stick
Yeah.
around.
Yeah. Also, one of the few movies with 2 governors in it.
Yep. Oh. Shoto Tank. Love your show. Been with you since Rittenhouse. Joined locals during Brooks. Wish the event was on Saturday night. Single dad can't make it Sunday in Vegas with school Monday morning. Yeah, sorry, man.
Oh man,
I
I've got an early
apologize.
flight back Monday morning. That's gonna be rough.
Tie will still be tied around your head.
It's better,
I'm carrying
Rambo.
a chicken onto the plane.
better than a Burger King crown on your head on the plane.
You get to the airport, produce your identification. My name's Bronca, First
Our
Blood,
state
Part
moves to
2.
introduce exhibits 415, 416, and 417 into evidence at this time. My understanding with subject to any objections from your honor's previous ruling off today.
Yes, sir. Ms. Harpooly.
Your Honor, may I confer with Mr. Murdaugh?
Yes.
What the hell are you guys doing?
Is this just more of he stole money?
For the admission of the.
This is this. I guess it's fraud Bank of America account
Give
where
whatever
he was.
necessary charge you're going to do.
Oh, the fake forge.
Yeah, they're asking for the limiting instruction on
All
this
right.
one.
Be happy to.
Okay.
Ladies and gentlemen of the jury, I'm going to slow down my speaking a bit.
This should take us all the way to the end of the day.
You know, he's more at home in front of a general store talking about his past rulings in court.
Ladies and gentlemen,
barbershop.
evidence or testimony is about to be offered.
I remember it was a summer
That
hot
the
5. Was it hot
Defendant
6?
may have been involved in other criminal activity. And that evidence is not evidence.
May have
proof
been.
That he committed the offenses charged in the indictments.
Despite the fact that that's the state's going to
Testimony
argue the entire
Has been
rest of the
allowed
week.
and is being allowed for the
And
limited
we all know the jury doesn't give a shit.
What's the
They're going to listen
purpose?
to this and blame them.
Hold on a second.
state in proving motive. You may not consider this evidence for purposes of character of Mr. Murdaugh, nor may you consider this evidence as evidence of his propensity to commit other crimes, or that it is more likely that he committed the crimes with which he is currently on trial.
Basically, there's no reason you should be hearing
Is
this.
being
It's
allowed
terrible for you to be hearing
based
this.
on the
Yes.
state's representation.
Yep.
That it helps
Apparently, Rule
explain
403 does not
the
apply in this courtroom.
defendant's motive to commit the crimes for which he is accused.
In fact, Chapter 4 of
You
the
may
Rules of Evidence
proceed.
doesn't exist, I guess.
Very briefly, Ms. Moody, we had 3 discs that are
Don't
now
talk
in
dirty to
evidence.
me, prosecutor.
What information is on that first disc? You indicated that was bank records. Do you have any additional information to describe those bank records?
I do, but I don't have the disc in front of me.
Showing you State's Exhibit labeled 415. What records are on that disc?
There are checking account ending, it involves checking accounts, and I can give you the last 4 digits of those.
If you would, please.
Checking account ending in the last 4 digits is 6779. It has account opening documents for that one. The next one is account ending in 7991, and those are account opening documents for that account. And then checking account ending in 7625, and that's account opening documents for that account. And then
Doesn't
also
matter, guys. This is
monthly
all bullshit
statements
promoted by the Federal Reserve and the globalists.
supporting documents for all 3 accounts.
Thank you.
Said Alex
Now
Jones
showing
coming
you
to cross.
State's Exhibit
Ma'am, you work for the
416. What's on
globalists,
this
don't you?
disc?
These are credit card ending in,
How much money have the Rothschilds put into your account?
sorry,
Yes.
9559. And those are monthly statements in that, and account opening.
How do you feel about
application
fractional reserve banking?
documents.
State's Exhibit 417. What's on that disc?
Also
Please
another
answer
credit
if there's
card
a gun
ending
to
in
your head,
8591.
because we know there is.
And these are application accompanying documents and monthly statements for this account.
Moni says, can you get rid of blood on a jacket and leave GSR? I have no idea.
That would be really, I can't. I mean, the amount, that would be goddamn near impossible, I'm thinking.
These are in evidence.
I don't think you
but
could.
we would not have an
GSR is
objection
easy to clean
them,
off.
Except
It's like
if
dust,
previously
right?
made objection.
Well, it's dust and chemicals, but I mean, like, you could take like a rag with oil on it and wipe a gun clean and it's clean. I mean, to get blood
further
off
questions
something,
for this
you've
witness.
really got to clean it.
Thank you, Ms. Moody.
Could depend on the nature of the
Moody,
texture.
you may step down and you're excused.
A lot of nooks and crannies on the gun.
Yeah.
No, I mean, as far as the GSR coming up easier from a raincoat, it might make a difference if
Call
it's
your next
cloth or
witness.
plastic.
I'm just thinking, you know, it's easy to clean that off compared to.
I mean, if you took the gun apart, you sprayed it down with brake cleaner, that would do it.
Yeah. But I mean, like, if I had a shirt and it was covered in GSR, I could throw it in the washer and it's fine. If
There
I
we go.
Yeah.
If I had blood, that's not going to cut it.
Let's make this panel how to clean up your murder weapon and clothing panel.
Hey, hey, I talk about this all the time. You got to sanitize your shit when you do it.
I need you to soak it in ammonia. If you don't have any ammonia, get a bunch of cat piss, leave it out for a week, and then pour it on your shirt.
Yeah.
How do you get brain off a raincoat?
Yeah.
Lick it.
Yeah.
Trick question.
Well, is it brain or brain water?
Think about it, Joe.
My name is Jamie Hall, Hall.
Good afternoon.
Good afternoon.
Do you own any leather, Miss Hall?
I'm currently employed at the West Columbia Police Department as an evidence custodian
Yes, you do.
since April of 2022.
Would you please tell the ladies and gentlemen of this jury about Jamie Hall? As much to your background, as personal background as you want to, I'll leave that to you, but specifically,
Like earlier, is your brother here
your
today?
education and background that led you to law enforcement, please.
Yes, sir. I grew up in the Midlands area of South Carolina. Upon graduating high school, I attended Clemson University and obtained my bachelor's of science degree in wildlife and fisheries biology. After that, I spent a couple years traveling and working some various jobs. I moved back to the area in 2013 and began looking to start a career, and ended up at SLED in 2015 as an administrative assistant in the trace evidence department in the forensic services laboratory. I was an administrative assistant until 2017 when I became an evidence technician, or excuse me, a forensic technician too, in the trace evidence lab.
When did you graduate Clemson?
Sorry, in 2010.
So after you traveled some, you started working in SLED in what year?
In 2015.
Okay. What was your job then?
I was an administrative assistant.
And what does that mean?
For the trace evidence department, that involved answering phone calls, filing documents, pretty much
Around the
normal
copy
administrative
machine.
duties.
Did you further your education or your experiences while you were at SLED in that field?
No, sir. When I became the technician in 2017, that's when I began the in-house training for that career.
I hate this
Tell us
in-house
about the
stuff.
in-house training when you became the forensic technician.
Yeah, so that training involved oral and practical examinations in-house under the supervision of
This in-house
an
stuff is such
analyst,
bullshit, though.
in which I learned how to properly handle the evidence and process the evidence for potential GSR. I
It just means this is how we've always done it.
oversaw some
Yeah,
testimonies
that's all
of some
and that's-
analysts to be familiar with
they aren't going to
court training
fail you because they
policies
want
as well.
you.
And I took some outside
So-
training from Hook College in Chicago as well.
Hook College in Chicago?
Hook, yes, sir.
What was that training?
It
Specifically?
was
How to shoot
training
people.
regarding
Yeah.
the scanning electron microscope, which is used for
Put
GSR
the hook
analysis.
in hookers.
That's
Yeah.
the acronym is SEM for
The
that.
SEM, yes, sir.
And when did you leave SLED?
In March of 2022
And do you mind, you're working where now?
at the West Columbia Police Department,
West Columbia Police Department, and you are there what?
evidence custodian.
Now, back in June
It's
of
not a black hole. Some people do escape.
2021, you were a forensic technician for SLED.
Yes, sir.
Special agent, forensic technician?
No, sir, I was not considered an agent or considered law enforcement. I was just the forensic technician.
I
too.
was assigned the
So then,
Chupacabra
June of
task force.
2021, what was your job on a day-to-day basis?
My primary role in the trace evidence department as a forensic technician was to prepare evidence for GSR analysis. That include GSR kits as well as inanimate objects that came in for potential GSR testing.
And we're going to have Ms. Fletcher testify right after you, but what is a GSR kit?
A GSR kit is an envelope that goes out to officers or investigators so that they can collect on scene from a potential suspect's hands. And it involves, it has all the items they need: gloves so that they can make sure they're not contaminating the subject's hand. And then the little vials that contain the GSR particle lifts with a double-sided adhesive that's used to dab across their hands to pick up any potential GSR.
So those are kind of done in the field, if you will.
Yes, sir.
After a local law enforcement agency uses one of these kits, what happens to it?
When they decide that they need it analyzed, they submit it to the laboratory. And then when it comes into the laboratory, I prepare it for analysis. So that involves me making sure it's been properly sealed and initialed, handled properly, the correct kit. There are a variety of kits out there. Our lab has particular kits that we accept. So I confirm that it is an acceptable kit. And I also confirm that it was collected within the allowed time frame. On a living person, we're touching things all the time and possibly contaminating or removing the GSR. So we do have a 6-hour time limit on kits collected from individuals.
So if a kit comes into SLED or your possession,
Did you just admit you
check to see
routinely
if it was
contaminate evidence?
collected during that 6-hour time period?
Yes, sir, I do.
And how do you do that?
We have what we call an information worksheet included in each GSR kit that the officer fills out that includes the time or the estimated time that the shooting occurred, as well as the time that the kit was collected.
For you guys saying, is this a full-time job? From all over the state, people are sending crap into her. So I'm assuming there are a lot of people getting shot in South Carolina.
I'm going to show you what is marked States 13. Can you tell if you were involved with States 13? And if you can, how can you tell?
Yes, sir. This has the unique SLED lab number and item number, and it also has my initials on the day that I processed it.
6821 JEH.
Yes, sir.
What's the E stand for?
Elizabeth.
Now, Court, would you open this, please?
Thank you.
Working those
She opens
scissors
this
like
up.
a boss.
Yeah.
If it's wrapped in another envelope in there, I'm gonna. Oh my God! It is.
Okay. When they were
Son of a
unfurling
bitch.
the raincoat, did you see my text, Nick?
Yes,
Yeah.
sir. Again, it also has my date and initials from the day that I processed it.
Should I read it?
Yes, sir.
You can if you want. I'm fine. If I send you stuff, you can read it.
Tell us again, what are you looking to
Sean
see?
sent that.
Whether it's what's done or not.
They're
or just
opening that
tell us what
all the
you-
white paper.
So
That's
for
Alex's
GSR kit,
plan sheet.
I start by using what we call an inventory worksheet. And on that worksheet, what I'm doing is confirming the manufacturer of the kit as well as the lot number for the kit. They have lot numbers for quality control purposes to make sure they're not contaminated before
It's
they're used for
two-sided
collection.
tape. How much of a
I'm
lot number do
confirming
you
who
need?
it was collected from, that 6-hour time frame. And during that time, I also label the
Jesus.
individual particle lifts inside with the unique lab number, item number, date and initials for control purposes.
Imagine it as a shooting in the facility that manufactures these kits.
Wanted
Shit.
collect
Yeah.
this GSR kit from the defendant. Are you aware of that?
I mean, this is a
Are
step
you
up from
referring to
paraffin
the
wax, but
gunshot
God, this
residue
is
analysis information sheet?
That's exactly what I'm referring to.
Yes, sir. That's what I would have used to confirm the 6-hour time frame.
And it's in evidence already. I'm not sure exactly what number.
you're allowed to intern at the federal plant and then go there.
Yes, sir.
Veronica.
Okay. And this has already, if you'll trust me, this has already been entered into evidence. Did you use this in examining, determining whether this was collected properly?
Yes, sir, I did. It also has my date and initials on it.
So using the form, show these ladies and gentlemen what you did. How you came up and.
Oh, so yeah, there's a section here at the bottom. So we have the subject's name from whom it was collected.
And who is that?
This one says Richard Alexander Murdaugh.
Okay.
As well as the time and date the shooting occurred, 6/7/21, 10 p.m.
And that's information that's gathered at the scene from somebody, right?
Yes, sir. This particular kit says that it was filled out by collecting officer Brian Vandor. Sorry if I messed that
That's
up.
good enough. Okay.
And then at the bottom, the collecting officer has also signed and dated that it was collected at 6/7/21 at 11:15 p.m.
And would that 11:15 fit in the time period where you're saying, okay, well, I can pass this on to be analyzed?
Yes, sir. It's an hour and 15 minutes.
And so not taking away from what your job at all, but one of your jobs just to make sure that's done correctly?
Yes, sir.
And then do you inspect the vials, if you will, to make
Yes,
sure?
sir. I make sure that there's nothing out of the ordinary with them. Occasionally, you would have a little crack in the vial, but I've never had anything damaged.
So in your opinion, these were collected properly and you passed them on for analysis?
To the best of my knowledge, yes, sir.
It's like really, really good. I'm testifying that it's like really good. It was done really good. Like
Tremendous.
Now, were there,
Unbelievable.
let me ask you this much. Local agencies that you examine items for potential evidence, in this case, gunshot residue, how do they get to the lab?
Typically, the officers from the local agency submit them through our evidence control department. And once they're submitted that way, that's when they're assigned their unique lab number and item numbers for each piece of evidence. And then
But you said
based
the shooting
on
happened at 10
the
p.m.?
type of analysis that agency requested, we would get notice that it needs to be processed. And so I would pick it up
That's
from
when the
evidence
call came in.
control and bring it upstairs to the trace lab to begin the processing.
And is all that documented from local agency to y'all and where it goes from there?
I can't attest to what the outside agencies do. I believe it probably varies agency to agency. But once it's been logged into our system downstairs, it is tracked throughout the laboratory for every hand that touches it.
That's kind of what we refer to as a chain, correct?
Yes, sir. It's
Chain of
referred to as the
evidence.
chain of custody.
Chain of custody. Now, did you have some other items of potential evidence in this case that you examined?
Yes, sir. I had several other items.
Okay. Um,
It's good that they went from the financial records to chain of custody so that everything is clear.
Yeah. Nice arc.
It's like we just found a random witness that we want to bring in at some point, so we're going to throw them in front of you right now. They seem so disorganized.
I'm going to show you what's marked States 418. Ask me if you can just identify this. That's all, and does it relate to your testimony?
Well, I can no longer see my initials, but I did process items that were in container D, and this is marked with container D for this case number. Yes, sir.
And would you open it up then to see if you can
Yes.
further find your mark with the court's permission?
Oh, God.
There's totally going to be more envelopes inside of there.
It's going to be like a Russian doll series of ever smaller
Babushka.
boxes. So she gets to an engagement ring in the middle.
Your Honor, we object to the inclusion of Matryoshka evidence. Do these people not have Amazon? Do boxes not come? I get so many damn boxes at my house. I'm like a box opening professional. I'm an expert in boxes, you may say.
You may say that.
You may say it. I'll allow it.
Yeah.
Mark 21, excuse me, it's your lab number 21 contained in States 418 at this point for identification. Do you recognize that?
Yes, I recognize it as the lab item number 20.
And what is lab item number 20?
It was a brown paper bag containing one pair of green cargo shorts.
The bloody
And also
shorts.
contained in 418, lab number 21. Can you tell me if you recognize that?
Yes, sir. It's lab number or item number for this case 19, which was a brown paper bag containing one white t-shirt.
Now, okay.
No, breaking news. It looks like they're not going to drop the LSAT after all.
Yeah, they shouldn't.
There was talk about dropping the LSAT?
Yeah.
They've been trying to get that thing eliminated for a while.
Your Honor, all 418 without objection.
White privilege?
They admit it.
Yeah, actually,
I'm
yes.
going to show you what.
It's so unfair that people have to take a test fast. Have you heard of the bar?
Based on logic.
Oh, they're trying to get rid of the bar too.
Yeah. Some people don't test well. Well, sorry, but in the legal world, to work, you're going to have to synthesize under a deadline. Otherwise, could you imagine? Well, I had a special exemption for the LSAT. It took me 8 hours. Oh, what's your hourly rate then? Because I
Please
drop it by 70%.
Look at 423, 424, and 425.
I mean, I just look at the quality of lawyers we have out
Do you
there now.
recognize these, and do they
And you're going to
relate to
drop
what
the
you're
bar?
talking about right now?
Good Lord.
Yes, sir. These are PGSR collection worksheets from clothing that I generate during my process of collecting from inanimate objects.
Inanimate objects.
Yes, sir.
I don't know. Dropping the LSAT sounds very anti-Semitic to me.
The shirt, 423.
Yes,
What's in
sir.
evidence? Tell these folks what you did with the shirt.
So anytime we're processing clothing or an inanimate object in the lab, we start by making sure everything's been thoroughly cleaned. And we also place down parchment paper to just as an extra check and balance to make sure there's nothing contaminating the evidence. We also place what we call a clothing blank out onto the table where we are processing. That's just another one of those double-sided adhesive stubs, and it's left open and exposed to the environment to make sure there's no contamination in the environment. That's how I start all of my clothing. Then I confirm that everything is adequately sealed and documented, and I open my items and lay them out on the parchment paper. I photograph items, and then I do label those items for identification later if needed. And then I will sample the clothing item closest in the areas that would be closest to the discharge of the firearm. So in this case, we're talking about a t-shirt. So I will sample the right chest and sleeve area together and the left chest and left sleeve together. So if you want to draw a line down your midline for right and left, and then we typically go down to just below the chest area.
And is that what you do with every shirt?
Yes, sir. If it's a long sleeve garment, I would typically use a separate particle lift for the chest area and the arms, just because the adhesive doesn't last quite as long.
And if you said this, I apologize, I'm tired. Why are you doing those areas?
It's closest to the discharge of a firearm.
Potential discharge, so that's where you test.
Yes, sir.
Well, looking at the shirt, look 418, the shirt that's contained in here. Which one's the shirt?
19.
19?
Yes, sir.
Before you get to doing the particle list, what's the first thing you do?
I confirm what the item is and that it's properly sealed and initialed.
Do you open it?
After I clean, I open it. Yes, sir.
And do you make observations of items when you first open it?
Yes, sir. Anything that seems out of the ordinary for any item is documented on the worksheet in the comments section.
And you have a comment section. That's where you put your thoughts, right?
Yes, sir. Anything that may, again, be out of the ordinary or affect the analysis later.
And just to go back, you go down a bit. Yeah, so this is right sleeve, right chest, left sleeve, left chest. Hanes beefy shirt, right? Here, you go.
I don't have any objection to introducing 423 into evidence. I don't think it's in evidence yet, but no objection.
Did they take GSR off his clothes or off his body too?
They tested his hands and now his shirt,
Those
his
three.
t-shirt.
Okay.
I thought I'd said that. If I didn't, I apologize.
Which again, he grabbed a shotgun
Is this a Hanes beefy t-shirt?
and had it
Yes, sir. It
with
was.
him at the scene when the police showed up. So GSR is not a
But-
surprise.
But where on
Small
his
reddish
hands?
brown stains observed. Shirt had an odor of laundry detergent.
I don't remember.
What do you mean by that? An odor of laundry detergent?
Oh, here it is.
It just smelled freshly laundered, which is not typical
they all have-
of the lab.
that's how you know it's
Typically,
bullshit. They're
clothing
using the
smells
same
like
phrase.
musty when we get it.
That's how you know it's
examined this shirt,
gentlemen.
On June 8th of 2021.
You didn't know,
You
did you
corrupt
have any
motherfucker.
knowledge about this case whatsoever?
I just knew that we had asked to make it a priority in the
loud.
lab.
I brought it down. You were, for some reason, you were turned way up.
Sorry. That shit is bullshit though.
And you
I guess the
attempted
Hobbit
to
had a
collect
correct hot
particle
mic.
from that shirt.
I did collect particle lists from the shirt. Yes, sir.
That's on the StreamYard side. Sorry, guys.
Okay.
Next, stage 4.
It had, I don't know if it was another stream or whatever, but it
Freshly
had
laundered like Colombian
25.
drug money.
Sorry, we're out of
Yeah.
order here. This is also your clothing worksheet.
The reason why detergent's
can I
so
see the top of
remarkable
that
in
sheet?
South
I'm
Carolina
sorry.
is because they're all poor hillbillies.
Oh, yes, sir.
And what was this that you examined?
Sorry if you live there.
This was the worksheet we generated when we collected from a seatbelt that was collected from a 2021 Chevy Suburban, South Carolina tag CZL420.
It'd be prospective blood and gunshot residue on the seatbelt.
I think we have it marked for ID only. Do you recognize this? Strike that, I'm sorry. The seatbelt states 100.
I'd be really curious how long GSR lasts when
It
it's in
doesn't go
contact.
away.
That's what I'm saying. Like on the seatbelt, like could it have gotten there a year earlier and still been
Yeah.
there?
Yeah.
Yeah, you don't launder a seatbelt.
Yeah, I guarantee you I've got stuff in my garage that's I haven't taken it outside in a year or two and still got GSR all over it.
Page 100. Can you look at this and see if you haven't examined that before? Does it relate to your testimony?
Yes, sir. This was sled item number 142, and it also has my date and initials on it as well.
All right, what did you do with stakes 100?
At the direction of the analyst, Megan Fletcher, I collected samples from various areas on the seatbelt.
Can you tell the ladies and gentlemen of the jury, how did you determine where you were going to collect samples?
Since this was not our typical item, I collected from areas in which Megan instructed me to collect.
Which was where?
We collected from the buckle, 3 different areas of the belt, and the latch plate.
Can you show the jury where you collected?
Yeah. So this, I believe, was what we call the latch plate.
Okay.
Sorry if I'm misspeaking on that, but and then the buckle was. Oh gosh. This area here. We did the top and bottom of it. And the 3 sections were just, we measured the length for each section, did a section, rolled more out, and did the next section.
And how are you actually doing it with the particle lifts? How are you collecting that?
So as stated before, the particle lifts have a double-sided adhesive on it. And you just repeatedly dab that across the garment or the item that you're collecting until it loses its adhesive abilities.
100?
Got to repeatedly dab.
Thank you. And looking back on the sheet, this noted here, that's where you went through and did your inventory sheet, correct?
Yes, sir.
And this is to document you did what you did, right?
Yes, sir.
Now, did you also have an occasion to examine the pants in this case? It's already, I believe, in evidence.
I did collect from some cargo shorts.
And those were also included on what I just took down off the OMO, but can you tell the folks where you collected or tried to collect lifts off the cargo shorts and why you collected in those areas?
Yes, sir. For any type of pants or shorts, we always collect from the right groin and the left groin area. Again, that's the area that's closest to the discharge of a firearm.
Closer to some other discharge as well.
That is standard practice.
How would it be close to the discharge?
I was wondering the same thing.
Are you like in supine shooting from your back at somebody?
The right and the right.
It doesn't sound like it's from your back.
I don't know. I point my gun this way.
Yeah.
I'm not sure how that's anywhere near my dick.
I was gonna say the kickback. The kickback seems like it would be really a bitch.
Oh, Kevin Costner might be leaving Yellowstone.
Is that correct, Mr. Griffin?
That's his show.
I know, but it sounds like Matthew McConaughey might be showing up in or
Would
something.
you mind opening up for it? First of all,
Doesn't sound good.
Do you know whether or not you examined a pair of shoes in this case?
I did, and these are the shoes, sled item number 21.
Okay. Would you please open that for the ladies and gentlemen?
And guys, yes, I understand cowboy and hip shooting, but nobody shoots like that anymore. Unless you're doing that cringe cowboy shooting stuff.
Hey, that cowboy shooting is fun.
Yeah, it's fun, but it's all like little mouse fart loads. So it's
Yeah,
like,
yeah, it is.
that part, like, I don't mind the rest of it. Like, I like the idea you have to have like a name and you got to dress up.
That's a lot of work. Yeah.
Yeah, but I like the names and stuff.
Otherwise, it's like shooting at an old school penny arcade.
Yeah. SAS, I tried to register the name Hopalong Douchebag, but they wouldn't let me use it.
I happened to be at one of their national championships one year, and I just wandered over, and they just equipped me with a whole bunch of guns and had me shoot. It was fun.
They're super cool. They're very nice people. That's the nice thing about them.
before you're cutting that, do you see JEH on here?
Yes, sir, I do. On 6/8/21, I signed my initials.
Him not wearing gloves is
What is all that
contaminated.
right there?
I believe it's yard debris.
Court permission to dump this right here, or can I get a trash can?
Is that trash can sterile?
What are we dumping into a trash
You're
can
dumping
from an
something
evidence
that's-
bag?
Some of the evidence.
Yeah. That trash
gonna-
can's not sterile.
We're just gonna dump a little.
No evidence control there.
I think that they're getting rid of that evidence.
Yeah, we don't need that.
These are states 419 in without objection. Can you show these to the jury?
Jura?
Sir.
I would demand to show what they dumped out.
Those don't look like rich man shoes.
Show the jury.
Yes, those look like wet man's shoes.
Show the jury what you
So with shoes, when we
gloves, these
collect from them,
fucking
we're going to
gloves
collect
on.
again to the area that would be closest to the discharge of the firearm, so the front of the shoe. So in this case, I would do the area where the laces would typically be and the front toe. Depending on how well the adhesive
Well, those are
continues,
contaminated.
will depend on how far back I go, but I start with the toe and then work my area down the sides.
Start with the toe, baby.
Some people like
is this the condition they were when you saw them on June 8th, 2021?
There was more grassy type material on them when I
That's-
had them.
Same or
And what I just
similar,
dumped in the
bro.
trash
Come on.
can with the court's permission and in here, did you indicate on your comment section
Yes.
whether or not yard debris was
This is where-
present?
this is
Yes,
where
sir.
the
I
confusion
commented
comes.
that shoes were wet with yard debris present.
Wet with yard debris?
Yes, sir.
Did you, on
Object
June
now.
8th now, go back in your mind,
Mhm.
when you saw these, in addition to wet and yard debris, did you make any other notes in the comment section about those shoes?
I did not.
Do you remember, did you see anything that looked like blood
I did not make any note of that. No, sir.
with your naked eye?
No, sir.
Top or bottom?
No, sir.
I'd be objecting like an asshole at this point.
From the top to the bottom.
I mean, even if this gets overruled at the appellate level, the appellate court's going to be like, wait, what? What did you do? Because this is not the same way she saw them. And she just admitted to it, and they dumped part of that evidence away.
Did you have any other items that you examined that were presented to you for examination, either by yourself or with Megan Fletcher?
Yes, sir.
Big rig, you asshole.
What was that?
It was sled item number 173. And it was, we described it as one blue rain jacket / poncho.
Okay. And was this the same? No. When did you examine the poncho?
I believe we began on October 5th, 2021.
So is it fair to say that the clothes, the shirt, the pants, and the shoes were on June 8th of 2021?
Let me check my notes.
Ovid says we thought it was suspicious
that's
that his
correct.
clothes
June
were
8th of
freshly
2021.
laundered
And I didn't actually-
because the
I
family's
apologize.
clothes
When
washer
did
was
you
no
examine
longer
the
operational. Oh my God.
Yes.
Oh.
Ladies and gentlemen, can you believe this man
The
here
seatbelt
knows
was
how to
examined on
operate a washing
September
machine?
1st, 2021.
And again, the specific date for the raincoat.
I'll
as
rest
well?
my case.
October 5th, 2021.
And tell the ladies and gentlemen, take us to the lab now. How did you examine that garment, the rain jacket?
This was also not our typical garment, and I believe there was some information provided from investigations. So everything I did in this case was at the direct, or in this, for this particular item, was at the direct supervision of Megan Fletcher. She essentially told me where she would like me to collect, and she documented everything on the note sheet while I physically collected the particle list.
427 without objection.
Is that correct?
That's correct, Your Honor.
They're admitted.
And Your Honor, 421 are the particle list from the rain jacket, and I believe there's no objection except the further the objection they made previously. No additional objection, 421.
They're admitted.
So let me go back in time real quick. Are these the particle lifts you took from the seatbelt? 427?
Yes, sir. My initials are also on each individual stub.
And that's sort of like the officer has in the scene. You're now doing it in the lab, taking particle lifts, right?
Correct.
And particle lifts from 420 lifts from 19, 20, and 21, which I think are the pants, the shirt, and the shoes. Were these the particle lifts from 420 that you actually took?
Yes, sir.
Again, in the tubes.
Yes, sir.
And your initials is on.
Yes, sir.
Now, 421, you said it was a little different, unusual. How did you take the particle lifts on this rain jacket?
I believe everything was considered in Megan's custody while I was doing the collection. And then it was transferred directly to my custody when I carbon coated the particle lifts. That's just a process where a thin layer of carbon is added. It allows the analyst to get better images on the instrument. It doesn't do anything to add or remove GFSR. It just simply adds a very thin layer of carbon.
Except GSR
so it was in
contains
my
carbon.
custody at that time, but prior to that, it was in Megan's custody.
I'll show you this. Martin, it's 226. Is this the rain jacket that you were describing?
If I can check the bottom cuff.
Stop shoving it on her. Let her get her damn gloves on, you weirdo.
I just drag it on the floor now.
Yeah, I mean, God forbid this ever gets.
Yes,
you know,
sir. My
retest
dates,
this
the
shit.
date and my initials are here in the bottom cuff.
So you looked at this rain jacket.
Yes, sir, I did.
He's just grabbing it with his
Megan
bare
Fletcher
hands.
was with you.
Yes, sir.
And
They
tell
should
the
be
ladies and
objecting to
gentlemen,
this. This
how
is
did you process?
not how you
Or did you
properly
attempt to get particle
retain
lifts?
chain of custody for this stuff.
Basically, the entire garment. We marked it off in different sections, again, where Megan advised me to collect from, and I repeatedly dabbed the particle lift across each section until it lost adhesive.
These particle lifts?
Yes, sir.
You dabbed each one of these?
Yes, sir.
Okay. And what are these little things on here? These tape or the,
I'm not sure what those are.
now you did the outside of this garment.
Those are like the evidence.
Correct.
Little stick
Did
marks.
you do anything else to it?
We also sampled the inside of this garment as well.
You actually turned it inside out and took samples from the inside.
That's correct.
Megan Fletcher was with you.
Yes, sir.
What about the hood? Did you test it or take samples from the outside of the hood?
Yes, sir, we did.
Did you take samples from the inside of the hood?
Yes, sir, we did.
Wait, this guy's a state, right? Or is he defense?
State.
State.
It's still state. Okay, Jesus. I mean, really, if this ever comes back for like an appeal or there's ever issues with the evidence, that's completely fucked now.
Had the court's indulgence.
You
But
can't
you-
retest that.
Come on. He's not winning an appeal, Sean.
You do it the right way because you do it the right way.
I'm not saying you're
That's-
mistaken about that. I'm deferring to you on that. I'm simply
Yeah.
saying he's not winning
Maybe.
an appeal.
Yeah, who knows? I mean,
I don't think an appellate court wants to go through 6 weeks of testimony.
Well, that's a big problem. Yeah.
yes. Well, and not even
Just the
necessarily an
6
appeal,
weeks,
but
though.
like a habeas petition. Who knows what he can win on? Also, some of you guys were not happy I made jokes about hillbillies.
When you're
Oh, well.
examining all of these items, do you wear gloves?
Yes, sir.
Just
That's
making
okay.
sure.
Hillbillies didn't
Did you wear
understand it
gloves?
anyway.
Yes, sir.
Were you wearing gloves? Not like
to
I'm
make sure we're
doing.
not contaminating it, as well as to protect ourselves from anything that may be on the garment.
And as far as the,
Which
Like
you
I
didn't
just
do.
did.
contaminated,
Yes, like
you
I'm
don't-
doing
you
right
don't
now.
want to put anything of you on that garment.
Correct. It's standard practice for us to wear a lab coat, gloves, and if it's going to be processed for
No,
DNA
she likes to
later,
play
we also wear a
doctor.
mask.
And is that in a controlled environment? Where you
Make sure you keep those
test to
goggles
get
on,
these
baby.
parts?
You're gonna
Yes,
need
sir.
them.
Are we going to get any of the results from this testing at some point?
Next witness.
Private defense.
Thank you.
She's just a collector.
Oh, thank God.
In more ways than one. That's why she's got the goggles.
Oh my. You're
Zippity
saying,
Doodah says, I'm a hillbilly. B-A, B-S, J-D, O, and F-U.
you're saying it's next witness, but to be fair, with the disorganization of this
Good afternoon.
prosecution, it could be like 9
The,
witnesses from now.
Next witness
You
on
said
this
if
subject
you
next
do
year.
DNA testing, you wear a mask.
Yes, sir.
Did you wear a mask?
Yes, sir, I did.
So, to your knowledge, were some of these items processed for DNA after the GSR processing?
It was my understanding that they had the potential for DNA analysis. Yes, sir.
Okay. Now, let's just talk about how you go about sampling for GSR. And you talked about the shirt, and you said you would do the chest and sleeve on either side. How does that work? Do you lay the shirt out on a table?
Yes, sir. So as I stated, the table is thoroughly cleaned, and then we place down parchment paper as well, sterile parchment paper, and lay the garment out on that so that we can access all the areas.
And for the shirt here, I think it's item 19, did you just check on the 2 areas at the top on the chest side?
Yes, sir. Unless we're given information from the investigative team or from an officer who submitted it that there's potentially a reason to test somewhere else, we only test the chest and sleeve area because that's the area that would be closest to the discharge of a firearm.
And that's what you're looking for is, you call it gunshot residue, is that right?
Yes, sir. It's microscopic, so you cannot see it. Therefore, we're testing the areas where we would expect to find it.
And you would expect to find gunshot residue on the shoulders of a person who had recently shot a gun, I would take it.
Yes, sir.
That's what you're looking for,
That's what we're trying to find out. Yes.
right? And then you did some GSR testing of a seatbelt assembly and buckle and whatnot, right?
Correct.
And you did GSR testing of this rain jacket here, right?
Correct.
And shirt, shorts, shoes, and Officer Murdaugh, I think's his name. You received a sample from him, and you just checked to be sure it was off.
I didn't
Murdaugh's
physically
hands?
receive it from him, but he was the collecting officer listed on the sheet. Yes, sir.
Okay. And so he would have taken the sample, or whoever did it would have taken it from Mr. Murdaugh, and that would be item number 18, I believe.
Slide item 18. Yes, sir.
And those are the samples taken from Mr. Murdaugh's hands, I take it?
Yes, sir.
Okay. Now, you can get gunshot residue on you by just simply picking up a firearm, can you not?
Those questions would be better asked of the analyst. I can only testify to factually what I did.
My job.
And the
My
analyst
job
here is
again.
Ms. Fletcher?
Yes, sir.
Let
Stratification
me ask
of
you to take a look
expertise is
at
amazing.
your worksheet, which is in evidence 423. And do you have that up there?
Yes, sir.
You know, I think I'd rather put it on the Elmo, so we can, do you have it in?
I have my copy. Yes, sir.
Okay, great. So, all right, yeah, go to the top. Okay, let's stop right there. Agent Hall, it says that this was a brand Hanes beefy t-shirt,
Yes, sir.
and then
Beefy t-shirt?
article lifts, right sleeve, right chest, left sleeve, left chest, correct?
Correct.
And it says description, paper bag containing one white t-shirt. Is that right?
That's correct.
And Doug, if you'll go up, down a little bit more, okay. And then there it says, comment, small reddish brown stains observed. Shirt had odor of laundry detergent. That's what it says, correct?
Correct.
Do you know what those small reddish brown stains looked like?
They looked like small reddish brown stains on the shirt.
Were they
Thanks,
tested?
bitch.
I have no knowledge of what was done after I handled the object.
Okay. Now
my
below
job.
here, it says sealed brown paper bag containing one pair of green shorts. Is that just an entry for another item?
Yes, sir. That's item number 20. The sheet is designed where we can put 2 items on one sheet.
So when you received the shirt, item 19, was it in its own separate bag?
In this case, it was. Yes, sir. That's why I made the note that that individual item contained its own brown paper bag, while the description says brown paper bag containing.
Okay. And the shorts, those are green cargo shorts. And again, you lifted, it says right groin, left groin.
Correct.
And it's just is it on the inside of the pants leg or?
Well, it's on the outside of the garment, down to, a reasonable distance, depending on the type of fabric, could depend on how much adhesive it has, depending on how large the garment is from the person. A small garment versus a 3XL is completely different. It depends on how far I can go down on the garment.
And to do this, you take a sticky something or another, and
It's a double-sided adhesive on an aluminum stub within those little vials. The bottom has a holder for that, and then we grip it by the bottom and repeatedly dab it across the garment.
until it loses stickiness.
Correct.
And then do you do one vial per area or multiple vials?
It's 1 vial per area listed. If for some reason I needed to use an extra vial or an additional vial, that would have had its own listing on the worksheet.
Okay. Now, I take it you don't know what the results of your lifting were, do you?
No, sir, I do not.
You would then finish your work and send it up the chain?
Yes, sir. All the items are either given directly to the analyst or they're securely stored in the trace evidence lab until the analyst takes possession of them.
And this blue rain jacket, you said you put carbon on it or something?
Yes, sir. It's a standard practice for anything collected from an inanimate object. We typically get a lot of debris, sand, dirt, or fibers, typically from clothing, and that can cause it to be a little bit more difficult on the instrument for them to get pictures of the particles. So the carbon just allows them to get a better picture of the a better picture of the particles when they do their analysis, but it does not do anything to add or remove GSR.
So you put the carbon down before you use your sticky thing?
No, sir, that process happens after the collection.
Okay.
So it goes into a small device, and there's little rods of carbon that are rubbed against each other inside of the instrument to put the layer of carbon onto it.
I see. But you're not putting carbon on the garment?
No, sir.
Got it. Okay. One second, Your Honor.
Oh my gosh.
This will test your patience.
So are you involved in any way with DNA processing?
No, sir, I'm not.
Okay. And so you don't know whether any of the items were processed for DNA?
I have no knowledge of where the items went after they left my department.
Okay, thank you so much.
You're welcome.
No, sir. Thank you.
Thank you. You may step down.
A real Sissy Spacek feel to her.
The only sissy today was that friend of Paul's.
Unless you have a 2-minute witness, this will be it for today.
We don't, Your Honor, unfortunately.
Ladies and gentlemen, that'll do it for this day. We'll
They
resume
wrapped
at
up
9:30
45
tomorrow morning.
minutes earlier
Please
than
not
normal.
discuss the
Oh
case.
my God.
Well, there you go.
There we go. We got a couple super chats, really not many, and then we'll just wrap up the show. Igor Slagathor says, "Attorney, Ms. Hall, what did you do? What got you into law enforcement, Ms. Hall? My family was screwed over by a shyster lawyer, and I vowed to use all my power and knowledge to gain vengeance and screw over shyster lawyers, like the defendant." Let's see. Next, we've got Doc Salty. "So if I took a dump on a plate and told the judge that the dump told my friend's cousin's roommate that Alec Murdaugh did it, would it be admitted into evidence?"
Yes,
probably.
Oh, do we have some more here?
Mr. Harpootlian, concerning the item that you were objecting to the testing,
I'll allow
I
it.
think was that the blue, what exhibit number is that?
Not the t-shirt, not the shorts, not the shoes.
And regarding that same number 226 rain jacket, is the same item that Mr. Griffin cross-examined a previous witness concerning? Ms. Smith,
Yes, sir.
concerning,
Examined her extensively about whether she'd ever, first of all, was that rain jacket in his hands when he came in that morning? 2, had she ever seen him with that rain jacket? And 3, did she, I mean, when she looked into the closet, did she know whether it was a tarp or whether it was a rain jacket? Was it the same color? She said it was the same color. That's it. And I objected to it because I thought that prejudicial outweighed the probative.
If you can't tie it to the murder, the day of the murder, or anything like that, how is it probative at all?
so I also recall Mr. Griffin questioned her as to whether it appeared there was a gun or different things in it.
No, Your Honor. I questioned her as to the tarp. This witness, Ms. Shelley Smith, they never showed her the rain jacket. She's never identified a rain jacket. And when asking court here, a photo of that rain jacket, she says, Your Honor, that is not what he had. And what's so prejudicial is they have introduced GSR, and they will introduce an expert tomorrow to say it's covered with GSR. And that is extremely prejudicial. They have no evidence connecting Mr. Murdaugh to that rain jacket. And the only witness they relied upon to get a search warrant, Your Honor, says that he came in with a tarp. I questioned her whether in the tarp, it looked like there was a gun in the tarp. She says no. She says he went upstairs, he came down, he laid the tarp open on his mother's retirement rocking chair. And she leaves that day and she sees the tarp laid out, and it's a tarp that looks like it goes over a car. And now they're coming in, showed her a photo of something in the closet that they seized and says, yeah, does that look like a tarp? And, I mean, does that look like what you saw? She said, well, it's blue. And now they're putting in GSR on an item in a house he doesn't live in, on an item he's never had in his possession, to the best of anybody's knowledge. And that's the basis of our objection, Your Honor.
So, Your Honor, again, if you look at the testimony, excuse me, in its entirety, Ms. Smith described
Oh,
no,
boy.
they pretty much got you. I heard her testimony.
She testified, of course, that Alec Murdaugh had showed up early in the morning, which was highly unusual. He was carrying what appeared to be a blue
Irrelevant.
tarp balled up. And then she was shown the picture in the closet where it's balled up and said, that looks like the item. Now, when it was pulled out and shown by them, she said, that's not what necessarily I saw, but she did recognize the balled up item and the balled up item in the closet, which the investigator said that's how they recovered it. She did identify that picture, and then if you put the two chains of evidence together, that's what the investigator recovered that she identified. Now, certainly they can argue to the jury whether or not that's the right tarp or not, but she did say that that is consistent with what I saw, all balled
You
up,
have to
which is
show it's
really
the
what
right
she saw.
tarp.
Again, this is also evidence that, was admitted and has been extensively examined before the
What is-
jury on. So certainly they can
You
argue
have
all
to
these
show it's
points
the
to
right
the
tarp,
jury, but there's
prosecutor.
enough of a chain that's been established by the testimony for it to be submitted to the jury.
Your Honor, might I make a suggestion? We're getting daily transcripts. Perhaps overnight you could, before they, the prejudicial
Good
piece
call.
is the witness they're going to put up tomorrow, I would suggest. Perhaps you could look at that daily transcript of her testimony alone. And I don't believe, I submit, she said what he said, maybe what he wished she said. I don't believe she said what he said. Your Honor.
English.
I think Mr. Waters was arguing this. I don't believe Mr. Metters has a dog in this.
Y'all just did.
Well, good for the goose, good for the gander, but.
Throwing a temper
520,
tantrum.
I just thought maybe this was a simple solution. He's going to say this is what she said. We're going to say this is what she said. I think it's clear she never said that what was in the closet was what he carried in. But, and of course, you have a court reporter that could, I guess, not type it tonight, but perhaps give you an audio of it. But it's a very simple question. Boils down to what she said about what she saw in the closet. Because clearly she said that when shown a picture, that's not what he walked in with. He walked in with a tarp, which he left over a chair. And, other than their supposition that he somehow brought that rain jacket in and wadded it up and threw it up in the closet, no evidence that there was a gun, no evidence that anything was balled up in it. They want to make a giant leap of logic. It's not circumstantial evidence of anything. So
It's a
I
wise
would
move
ask the
to
court
give him time
to perhaps look at the daily
before
transcript.
committing to allowing it
Somebody's
in.
got one right there. And just look at her
Hasn't
testimony,
mattered
not all,
before.
just her, or even a piece of her testimony. What did she see in the closet?
I don't think
in
the defense is
response
going to win
to
at this point.
Mr. Metter's question. Now, Mr. Metters believes she said
Gives them
something,
time
and
to
Waters
review the
believes
testimony
she
also.
said something different than what we think. The proof is in the pudding, as they say, or whatever. That's not really a legal aphorism there, but I would suggest strongly that maybe overnight. look at it,
Aphorism.
let us know what you
SAT
think.
word.
Mr. Metters, you had something? Mr. Waters, yeah.
I think, and I guess on redirect through their investigator's transcript, I think they were asked, I asked her if they had asked her about whether it could contain a firearm, and she said, well, I don't know. But that was brought out, I think, which would directly from their investigators who asked her about it. So that, I think, made it relevant. They certainly thought it was relevant when they were interviewing her. So that's why we do think it's relevant, and we hope Your Honor will let us keep going tomorrow with the GSR to see if there's anything potentially in the rain jacket that has GSR in it.
All right. Okay, we'll adjourn for this day.
Oh, there you go.
Well, we'll probably not get a ruling on that tomorrow either, since the judge likes to just go ahead and wait on rulings until something gets testified to, and that one was already testified to, so we shouldn't see a subsequent testimony about it.
And the jury's already seen all the stuff, so this trial's a disaster.
Yeah, it's a mess. Yeah, how do you have the limiting well, all of that stuff you heard about a raincoat, ignore it. Well, what did we hear about the raincoat? What did we hear about the tarp? I don't even know. It's a mess. I don't think, frankly, based on this judge's admission of everything else, I don't think they actually have a good argument on excluding the raincoat.
What I was going to ask you is, unless I missed it while I was running in and out of things, did they immediately, when she said, "Oh, that could be the thing I was looking at," They showed the crumpled up one, and then they showed, well, this is what it was. Oh, that's not it. Well, that's if it's the exact same item. Why weren't they immediately jumping up saying, Your Honor, this needs to be addressed. This is obviously not admissible. Or did they not address it at that point?
I think they did.
They did?
And then
Okay.
the judge, then they went to lunch.
Oh.
Right? Is that I think they went to
Well,
lunch.
it's complicated because they knew it was coming, so they've been objecting on and off all the time. So it's hard to
I just
recall
didn't know if they
exactly.
would. Okay.
Well, anyway, let me finish these up, and then we'll be able to wrap up the show before 6 p.m. Central tonight, which will be nice. Nancy Jennings says, oh, wait, no. Shredkowski says, this is right when the judge was talking to the jury. Remember how I said this trial would last 3 weeks? I lied. 200 Watt Studio, ain't got time to bleed, quoting the governor of Minnesota. KG Western Designs just started a YouTube channel and uploaded 2 shorts related to my leather work, and Nick is largely to blame. Thanks to the community and Nick's nose. There you go, guys. Check out KG Western Designs for all of your leather needs. Maybe he does straps. I don't know. Nicholas Cruiser, can you explain how all of this crap that the state is pulling, what the jury shouldn't be hearing, and the clear bias Judge Darkey has, and all the other insubstantial garbage is not appealable? No, it's all appealable. The standard, Steve Gosney talked about this the other day, but the standard for evidentiary issues on appeal is abuse of discretion, which is a very, very high standard because judges at the trial level have broad discretion on admission of evidence. If they believe that there is probative value that outweighs the prejudicial impact of the evidence, it's going to come in almost always. Now, there are times when that would come up. What you laid out, though, is all of these different things. And that's what Steve Gosney was saying, is that sometimes, individually, these things wouldn't be enough. But if you can make a case that it's cumulatively prejudicial and repeatedly abusive, then you can overcome that standard. And they've got a lot going. Maybe they'll get to the point where they could. I don't want anybody to be misled about how tough the abuse of discretion standard is to meet at appeal. It's the top
hard.
level.
It's the hardest level. It's in contrast, the other common one that they'll apply is reviewing something de novo, which means anew. So when they're reviewing something de novo, which is not what they do with evidentiary issues, but when it's de novo, they're basically saying, what do we think is the right way to approach in this situation? But that's not what, and we're going to look at this as if there was never any decision made, and we're going to weigh in as to what's the right way for this to be handled by courts. The problem with abuse of discretion, and the reason they allow for abuse of discretion, is because they don't want to have judges have the appellate court looking over their shoulder all the time. So they say, so when you're talking about someone with abuse of discretion, what it really means is, look, we're going to give the judge a very wide parameter as far as saying, is this admissible? Is it inadmissible? And unless he goes way outside the field of what we want any judge to ever be doing, we're going to say, even if it's something that we ourselves would never really do, it's this judge's discretion to do that. And that, unless they abuse their discretion, they literally, it's like whatever discretion level we give you, you abuse that, ignore that discretion, and go even further than anyone should allow. That's the only time that they'll let you win on the appeal. And that's why, as Nick was just saying, abuse of discretion, you're almost never going to win an appeal on.
Yeah, and the appellate courts, they don't want to be trial courts. they don't want every trial to be like a World Series, best 3 out of 5. Right? They want a certain degree of finality, and trial judges are hired to do trial judge job. So someone has to do that job. That's them. They get to make the call, and they're going to be giving enormous discretion. I mean, at the end of the day, how do you know if a piece of evidence is admissible or not? The judge tells you. If he says it's admissible, it's admissible.
Yeah. I mean, and abusive discretion means it has to be clearly outside the rules. And unfortunately, I mean, the reason we have judges on most of this stuff is they're the referee to call balls and strikes, and most of the stuff isn't clearly outside of every rule. I think I would be very surprised if they won on the raincoat, because it is still an object that in some way resembles the description of something that is recovered with gunshot residue on it in a crime involving guns from a location where he was. I mean, it's up to the jury at that point to weigh the value of that evidence. Sure. And we can think that that's worthless. And I think the defense is making a decent case that it's worthless. But as for it being not permitted to be brought in, I think that's a harder sale, objectively speaking. Although, you know, I again, and I maybe think that it shouldn't be brought in a perfect utopian case, but this case hasn't been utopian. This case has had lots of permissive evidence inclusions. Similar to Rittenhouse, by the way, a bunch of shit went into Rittenhouse that really shouldn't have gone in.
And I've said, Megan Fox really got confused when I said it, but Schroeder was an awful judge in that case. A lot of people like, oh, he was so base. Like, no, he wasn't. He was a pussy.
Yeah.
And Binger knew exactly how far to push him. That it's like he'll yell at me and he'll scream, but at the end of the day, yeah, he's not going to do it. He'll just bark, but no bite.
Yeah, that was the thing. Schrader seemed like a good judge because he was willing to bark, and we were always waiting. Okay, when's the hammer going to drop? When's the hammer going to drop?
Yeah.
That's a clear Fifth Amendment violation. I mean, that is a clear Fifth
Don't
Amendment
get brazen
violation.
with me, but okay, next time I'm going to punish you. Next time I'm going to punish you.
And then the next time they got brazen, and he rolled over again.
Yeah.
The Ava Blink says, did Joe get summoned by the pickles? Yes, he did. Yes, he did. I was eating kosher pickles earlier.
Oh, nice.
Random Killer 563 says, everything gets decided in the comment section. Yes. Moni, I know the caregiver testified to him wearing a t-shirt and shorts, but did she confirm that it was the same clothing he had on when the cops got there? I don't think they asked. Big Rig 0485 quoting me, eat my words, in the legal world, you'll have to synthesize under a time limit. This prosecution says, oh, really? Ryan Knoll, do you think the judge is more deferential to the prosecution because the defense demanded a speedy trial? Prosecution has less time than normal, so they let everything in they want. I think it's more likely that the judge is deferential to the prosecution because it's a highly political, tense, publicized case, and the judge is going to be more apt to be more permissive. And I think that's what we saw in Rittenhouse, and that's what we're seeing in a lot of these public trials, especially ones that are big news stories, is the judges seem to be very permissive about what comes into their courts. I don't know if the panel has a different opinion, but that's my...
I'd like to think this is how he normally is too. He's very, very fast and loose. And it's pathetic. I mean, it's just...
Mitchell says the motive was hidden in the tarp, Your Honor. Nancy Jennings, did anyone bring in the dogs to follow a trail in so many places? Oh, we don't know. They've had some testimony about dogs. I don't know if they were related to the police or not, but I'm not sure what the dogs would be looking for specifically.
But those dogs would have dog scent everywhere. And you know what, though? You know where they dumped the motive? They dumped it in the trash can when they dumped it out earlier.
Yeah, no kidding. Cat Zap, this is just like what defendants standing before the Murdaughs in court experience, so he is getting what he deserves in spades. That could be true. Southern Brainwater, we need less Judge Ambien and more Dick Poon. Dick Poon's a good name. Good name for that guy. Okay, a couple more. The Magis 93 says, I'll drop $5,000 if Charlie is going to be there. Rackets. I don't think Charlie's coming to Vegas, but she could. For $5,000, maybe you could just pay her to come to Vegas.
Oh, she'd be fun at a party.
She'd be hilarious. Ben 5375, Nick, will you sign my Baldo? It's only slightly used. Look, I said I'd sign stuff that you brought, so I don't know. I am Trouble says, Nick, help. I'm currently in Twitter gay baby jail for calling out Keffels as an autistic retard myself, and they mass flagged my comments. Good luck, brother. Chank you Uyghurs, Sweaty Gunt says, how do lawyers become aware of all the fuckery that goes on in these trials and not become full-on anarchists? Well, because if we were anarchists, we'd be working ourselves out of a job. Oh, bye, Joe.
Joe bought it.
How do we not
got Joe?
How do we not have massive disdain for the state? I mean, no, we do. So,
Magis 93, I know this might be dumb, but where are all the laws written that aren't in the Constitution? Like the Constitution doesn't say murder is illegal, but it is. So where is this law written? Well, It's derived from our
Blackstone.
constitutional authority, but
Are we getting the
it's-
sovereign citizen territory now?
what's up, Joe?
Sorry about that. I don't know. My Chrome crashed.
Oh, that's okay. I thought it was because of what I said about keffels or something.
I missed it.
No, don't worry about it. No, the laws are Congress has the authority to basically pass any law that comports with their Article 1, Section 8 and 9 authorities and provides for the general welfare or common defense, or taxing and spending or commerce.
Or really anything they want.
Yeah, they can mold almost anything into those things, but that's where the authority comes from. The Magis 93 also says, Judge, I'd like to admit this deep fake of Alex shooting the victims into evidence. I'll allow it. Not a Robot 101 says, Sean, I'm the guy who asked you about AR buying advice. Bought and took my Zion 15 to the range, fired 200 rounds. I now don't have shoulders for this week. I can't wait for next weekend to do it again.
Oh, come on. ARs don't have recoil.
Yeah.
That's silly.
What do you, hemophiliac maybe?
Yeah, I don't know. I can fire my AR one-handed relatively accurately.
My kids were all firing them when they were of single digit age.
You could fire them. Like I've heard the story. Like, I don't know if they still do it, but like there used to be stories like to show like recruits it's not dangerous. You can hold it against your balls and shoot it, and nothing happens.
Let's see.
Cool story.
Rumble
Yeah,
username
I know.
says,
Cool
after
story.
this trial, Nick is
Probably
going
not.
to Nick is going to have so much PTSD from women opening things up that even women opening up their blouses will trigger him. I'm already triggered. I'm a boy of purity. Brimstone, Triple D, Bizarro Nick looks more Texan than Nick. Hey, you know what, Brimstone? Fuck you. Take that. USA Now. Oh, no. Come on. Okay, well, we'll bring Kurt on. Hey, what's up, Kurt? I'm just about to share a meme.
I'm sure the exciting prosecution reveal, right? We're
Well-
all in together.
The only exciting reveal I have is this meme from Locals, which
Nice. I saw that earlier.
wow.
No fact checking necessary.
Like a daughter, right? Alan Yatsu says, once the study conclusively proved that if you were to take every lawyer and lay them down end to end around the equator, we would all be a lot better off. No. Alan Yatsu, says, oh shit. Not a Robot 101 says, in my defense, I was in the range 4 hours. The Zion was the last thing that I shot. Okay.
Okay.
The Pie Baker says, hey, Nikki, is YouTube still asshole about the CBD sponsorship? Was watching something the other day and they had 3-minute long CBD ad before the video. Maybe Rumble would be chill. It all depends on the type of products specifically. But Rumble is definitely more chill about it, as you'll find out really soon. Edith Maddock says the real killer and has a picture. And I think we're about done here. So here is the here's the real killer. I don't know who that is.
It would probably be funnier if we did.
I don't get the joke, but if I got the joke, I'm sure I would laugh at it.
Real killer is chicken in revenge for death of other chicken by dog.
That could be.
The chicken, the dog killed the chicken, and the Murdaughs went down to the kennels to discover this and laughed and laughed and laughed at the death of chicken, and other chicken snapped.
That's the
committed
girl
murders.
that was killed in the boating accident.
This
is Mallory.
Beach.
Oh.
Beach.
So it's
She
like
got a honey badger on. Yeah. There she
like I
goes.
spit on your grave.
Or
or whatever.
Blackouts.
Yeah, Mallory Beach.
She was
What's
just
her name?
floating around in the water.
Oh my
She was only faking. She was just
No.
pretending to be deceased.
Yeah. I didn't
Okay.
recognize her by sight, but at least I remember her name.
Doc Salty 96 was the real killer. Were the friends we made along the way. So there we go. That's all the super chats. Gents, do you have anything to add before we close up shop for the day?
F. Susan.
Yep.
Yes.
Just generally or anything particular?
No, Susan denied my appeal today at my strike. So
Joe, is Susan New Jersey for that bitch? Yeah, we got to
So-
get you. I got to have you on the show, the night show, like maybe tomorrow.
Sure.
How long is your strike for them this time around?
Just a week.
Oh,
My
just a
old
week.
strike had been cleared off. So I got a strike like a month ago, and that got eradicated. Tonight on my stream, I plan on, and it got eradicated after I had like a conversation with customer service, and I was explaining to them how they never gave me a proper chance to appeal, and they sort of wrap together your appeal on the video and your appeal of the strike, which is really two separate things. It's one thing that they're taking down my video saying it doesn't conform. It's another they're giving me a strike at the same time. They could do, in theory, either or. So when I thought I was appealing the video, it turned out, I said, here are all the reasons the video should be good. And they said, well, you lost your appeal. And sorry, your strike's staying in effect. I'm like, I wasn't even appealing it yet. So I ended up having a long chat with customer service. We have the ability to go into customer service and have a
I've
conversation
talked
with
to
them.
They're basically
I did not know
retarded.
that.
Yes,
Useless.
yes, they are. But I actually
Along with my YouTube account rep that I was
after-
assigned, I've also found to be completely pointless and useless.
Oh yeah, the account rep. You need to have the right account rep. Only Nick has one of those. But
What
that's
up,
it.
what up, Jody? How you doing, girl?
Right, but I'll tell you
get
this:
us a
the
name like
last time
Jody?
I did this,
Can we share?
I got my strike reversed last time. So I plan on streaming my conversation as I have it tonight. I'm going to be streaming on Rumble, and basically,
I'm sure they'll love that. That should be good.
it's going to be on Rumble. It's not going to be on YouTube. So how would they?
Let them have it, Joe.
Yeah, I'm going to basically be blasting them. This is like so stupid. It was allegedly medical misinformation because I aired the Project Veritas Pfizer drop. I aired it 4 days after it came in. It had well over 1 million views. YouTube had said nothing about it, as if it was totally fine. I aired it on Thursday night, and on Friday they give YouTube a strike and take down the video. And a couple days later, they take down mine. And I'm like, look, when I was watching with Branka actually, and you, Sean.
Yeah,
Right. So that video is where I ended up getting a strike, and I actually found in the video where I paused at one point. And I said, everyone should be clear. There's no medical advice here, and you should not be coming. Don't look to the internet for medical advice. Well, I'm not giving you medical advice. My panel's not giving you medical advice. Talk to your doctor. Stay safe from all things. And still, like
talk to your doctor. Talk to Pfizer.
You had exculpatory statements, or
yes, yeah. It's like
did you put that in your appeal?
Yes, yeah. I
Damn
actually
it.
took a quote out. I took the quote and I put it in there. I actually spent time going through the video, and I just was typing it as and just transcribing.
Here's what you need to do.
Okay.
Here's what you need to do, because I don't know if you saw, but Veritas leaked the document from YouTube about handling the strikes on that, and it specifically says if there is the statement to the mitigating statement or whatever, to not flag it, but I think just to demonetize it or something like that. So what I would do is I would go on Twitter, I'd tag Team YouTube and say, hey, Team YouTube, not only do I have these statements in there, I put them in my appeal and you incorrectly applied your standard. And I'd blast them on Twitter because we know that that's the only place you can get this shit done. But even if you don't beat out your 7 days, at least getting that strike removed and say, this is your leaked policy on this. We know about this because it got disclosed, but this is supposed to be the standard, because that's actually what's in their terms, is if there is that statement, you're supposed to be protected from
What statement specifically? Because I'll tell you, what I actually said, I can read to you what I said, because I took a transcription of what it was that I said in the moment. And it was actually, what I said was, I should point out, by the way, there's no medical advice here, and you should talk to a doctor for all your medical concerns and issues, whether it's COVID or any other sickness. I'm not giving you medical advice. No one here on my panel is giving you medical advice. You shouldn't be taking medical advice from anybody on the internet. Talk to your own personal doctor to make sure that you stay safe. That was the statement that I said in the middle of my stream.
I think that should suffice under what they released. I don't remember what they did. It's either on Veritas's Instagram page or their Twitter page, though, and they've got the screenshot. So if I find it, I'll send it to you. But otherwise, just check those places because they published it. Okay. So anyway, let's see. D. Lindsay has a little face sticker. Doc Salty, the real killer, were the friends we made along the way. I think I read that one, and I think that's it.
All right.
So to everybody in the chat, thank you so much for hanging out. Check out my co-streamers channels all over the place, YouTube and Rumble. I will see you guys tomorrow for more bashing our heads against tables. Until next time, thank you, gentlemen, for joining me, and we'll see you all very soon. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig, the spirits blow as the ones who get unemployed. So pour out a glass for the T-post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the T-post on Twitter, as we hear lost-plaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have